Morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. As a reminder to everyone, today is not your trial date, and I do encourage you to speak to your attorneys before speaking on the record this morning, because everything that we say here is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present here in the courtroom with me and are available to you by phone. For those of you represented by private counsel, know that your attorneys also come here to the courtroom with me and are able to address your cases from here. If your attorney is not in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have already retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have present attorneys from the State Attorney's Office, as well as representatives from confinement status, pretrial supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here today if you are present on misdemeanors or municipal ordinance matters, but understand that is dependent on what is going on with you personally and with your case. For those of you present this morning on felony matters or violations of probation, those cases cannot be resolved here at First Appearances. Following today's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. As we are getting started this morning, we have a few different cases that are going forward on today's docket. We'll do the best we can to keep things moving smoothly. I'm going to be beginning with the satellite jails while the Public Defender's Office is still speaking to people from Maine. I do have one sign-in before we get started. I'm not sure which facility this person is at, but on page 19, Bryce Lemar Liu, his private counsel as well as family members are present. Well, I believe I have a sign-in.
North Broward. That's North Broward, Your Honor.
All right, perfect. Okay, North Broward. And can we have one of my deputies grab them from outside? Thank you. All right, good morning, deputy.
Good morning, Your Honor. We had to recall Lou.
Okay. When he's available, will you let me know, because I have his attorney and some family members here. So that's the only sign-in that I have. So if you would just let me know when you guys are ready, and then I'll come back to him, okay?
Got it.
All right.
Thank you.
Thank you. Yeah, thank you. Okay. All right. So let's get started with some of our satellites. I'm just going to have my people here in the courtroom tell me which order we're going in, since I don't have the indications as to the facilities here. So we're going to skip over the main cases right now while they're finishing those, and we'll do Paul Ryan Conti and anyone who's ready at North Broward. My deputy at North Broward, do you have LaShunda Cummings ready?
North Broward.
Thank you. All right, good morning, Ms. Cummings.
Good morning.
Ms. Cummings, you're before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause, and at this time, I'll hear the parties' recommendations, beginning with the state.
I'm Jessica Etienne on behalf of the state. She does have priors. She has prior resisting without violence from 2015, adjudication withheld. She has aggravated assault with deadly weapon with resisting without violence. However, that was dropped. Different victim. Petty theft from 2008, adjudicated guilty. Driving while license suspended from 2007, adjudicated guilty. A battery from 2006, different victim, declined to adjudicate. And based on the priors, Your Honor, the state is requesting $1,000 bond.
All right, I'll go to the defense. Counsel, I'm sorry, I don't mean to interrupt you. I just want to make sure that the button is turned on for the microphone so that they're able to hear you. Sometimes it's a little hard, you might want to
Ms.
pull it
Cummings.
down.
This is Akeelia Drake with the Public Defender's Office. Ms. Cummings is 42 years old. She's lived in South Florida her entire life. She's currently employed at Winn-Dixie, which is considered essential employment, as everyone is aware. As the probable cause affidavit states, the listed victim does not want to cooperate. The person refused to speak to the police officer, and it doesn't appear to be any cooperating witnesses. We're asking that Ms. Cummings will be in full cooperation, in full communication with her attorney, will come to any required court dates. We're asking that she please be released on her own recognizance.
Ms. ATM, what was her most recent prior that you read me?
Her most recent trial was a Resisting Without Violence 2015.
18?
15.
15.
Now, would I be able to speak?
Ms. Cummings, I don't want you to say anything about
Actually,
the
she
facts of the
she
case
does have
today,
an
okay?
aggravated battery with a deadly weapon that was filed in 2018. It's currently filed. It's pending in mental health court.
It's pending. Oh, okay.
Because I didn't do anything.
Hold on, Ms. Cummings. I don't want you to say anything about the facts of the case, okay? We're just talking about bond and release conditions today. All right, so I don't want you to say anything that's going to be harmful to your case.
It's really bad in
All right.
here.
All right, Ms. Cummings, we're gonna take care of you. Just give me one moment.
Coronavirus.
All right, Ms. Drake, I'm willing to. I'll give you two options, and you can, if you need to discuss them with her, you can. I can either give her a $500 bond, or I will ROR her and place her on pretrial supervision. All right.
So I will call her to the side deputy.
Okay, Ms. Cummings, your attorney here, Ms. Drake, is going to call you on the phone to speak to you privately about your options, and then when she's done speaking to you, I'll bring you back up, okay? She's going to call you on the phone right now. All right. Thank you. Okay.
Cummings laughing. McCoy again.
All right, so let me go to the next case. Vic Samuels, is that Paul Ryan? All right, let's go to Paul Ryan. Thank you. Okay. All right. Good morning, Ms. Samuels.
Good morning, Judge.
Ms. Samuels, you're before the court this morning on two charges. Count 1, aggravated battery with a deadly weapon, domestic violence. Count 2 is child abuse without great bodily harm. I find probable cause, and at this time, I will hear the parties' recommendations. We will start with the state.
Your Honor, I'm requesting $2,500 on each count, no victim contact with any of the alleged victims. I would note the victim does want to prosecute, so I guess that's aggravating. He also answered yes to all the lethality questions. As far as prior, she has theft in 2017. She went through a diversion program for grand theft in 2013.
Okay. All right.
Samuels is a 27-year-old proud mother of 2 children, including a 5 and 3-year-old who are home, she is the main financial support for. For the past 5 years, she's worked as a call center agent. She does live with her grandparents, Ms. Samuel's grandparents, which are her children's great-grandparents, who are elderly, 69 years old, who obviously are highly susceptible to the pandemic. Ms. Samuels reports that there is no contact order in place with the listed victim. She reports that he actually has been stalking her, that she actually is the victim in this case. Obviously, that is more of an issue that's right for trial, but we will be pursuing that avenue. Ms. Samuels does have a place to live separate and apart from the listed victim. We recognize she has prior contact with the law, which was a diversion, but she has no violent history. She'll be in excellent communication with her attorney, come to any required court dates. We're asking that Ms. Samuels please be released on her own recognizance.
Based on these allegations, I'm not going to be comfortable with an ROR. I understand the information that Ms. Samuels has provided to you, but that is in direct contradiction to the information that I'm seeing in the probable cause affidavit. So if you have an alternate recommendation, then I will hear that.
Your Honor, I also do want to indicate Ms. Samuels indicates that the police did not speak to her or witnesses to the alleged incident, which includes her grandmother. Ms. Samuels would be, and we're open to any sort of community supervision if pretrial is deemed appropriate. Obviously, call centers are a high concentration work environment, so ROR with pretrial would be something the court's inclined to consider.
I'm gonna set the bond on each count at $1,000, and there will be an order of no victim contact. That will apply to both the adult alleged victim as well as the 2 minor alleged victims. Ms. Samuels, it's very important that you understand the no contact order means until further order of the court, you're not to be in the same place at the same time as these individuals. That also means no phone calls or text messages and no third-party contact or social media contact with these individuals. Do you understand?
Yes.
All right, thank you. Good luck, ma'am. All right, are we ready to go back to North Broward for Ms. Cummings? Okay.
I should ask now, may Ms. Samuels please have a return order to go back one time with law enforcement to get her property? Because the 2 minor children, I believe, live in the house with her grandparents, and that's where Ms. Samuels lives.
Well, there's not a no return order, and she's not having any contact with the children, so I'm not sure of the necessity for that.
To get her items at the house where the children live, like her personal items, if she needs clothes or. Okay, perfect. Thank you. Oh, thank you.
Okay. All right, so let's go back to Ms. Cummings' case. And Ms. Drake, did you have an opportunity to speak with Ms. Cummings?
I did, Your Honor, and Ms. Cummings thanks the court for the options, and she would like to be put on pretrial, ROR to pretrial, and she'll be fully compliant.
Okay, all right. So on Ms. Cummings' case, that will be an ROR. She will be placed on standard pretrial supervision. Ms. Cummings, a couple of important things for you to know, okay?
Yes.
Number 1, you're going to be released today, but you have to report to pretrial supervision within 24 hours of your release, all right? If you fail to report to them as I have instructed you, a warrant will be issued for your arrest. The deputy's given you a piece of paper with instructions on where you need to go, so it's very important that you understand that, all right? You understand so far?
Yes, ma'am.
Okay, additionally, there is going to be an order of no victim contact. That means that until further order of the court, you're not to be in the same place at the same time as the alleged victim. That also means no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand that?
Yes, yes, ma'am.
All right, thank you very much. Good luck to you, Ms. Cummings.
Thank you.
Thank you, Your Honor.
Thank you. All right, what's our next satellite case?
Your Honor, I missed, North Broward asked that Mr. Nichols please be called towards the end so they can use proper quarantine protocols. I'm sorry, did you say Nichols Becker? No, I said Brian Nichols. I apologize. That'll be fine. I'm sorry.
All right, so Brian Nichols is where, North Broward?
Your Honor,
Yes?
we have to have a special protocol for him as well.
Okay, I'll put him in your stack. We'll get there. We're gonna get through this docket one way or another today, guys. All right, who's my next one? I don't care. If they're at a satellite, just let me know. I'm going through the stuff.
North Broward
Okay, do you have Quentin Jackson?
Quentin Jackson was here, but he refused.
Okay, well, that's all right. These are ad charges. What else is holding Mr. Jackson? Does he have any bond holds or anything?
I believe you're on.
All right. Uh, he has no bond holds. Okay. All right. On Mr. Jackson's case, in light of the refusal and the fact that these are ad charges and he already has no bond holds, I'm going to make a probable cause finding in absentia, and I will leave the standard bonds in place on these two ad charges. Thank you. All right. Who's next? Do you have Donnie Chestnut at North Broward?
Yes.
All right.
Chestnut.
Okay. Thank you. All right. Good morning, Mr. Chestnut.
Good morning.
Sir, you're before the court this morning on an ad charge. This is a new charge for false owner information provided for pawned items. A fine probable cause. My understanding is that Mr. Chestnut does have a no bond hold. In light of that, do the parties have any objection to the standard bond? Defense?
No, Your Honor.
All right, so Mr. Chestnut, I'm gonna leave the $1,000 standard bond on this one since you have the no bond holds. Okay, good luck.
Come on, Chestnut, come on out.
Okay.
Yes, Your Honor. Yes, Madam Clerk, he does need a Spanish interpreter.
I'll put him in my file for the Spanish interpreter. Okay, North Broward, do you have Peter Metzler?
North Broward.
Thank you. Good morning, Mr. Metzler. Mr. Metzler, you're before the court this morning on 3 charges. Count 1 is grand theft. Count 2, trespassing on school grounds. Count 3 is burglary of an unoccupied structure, unarmed during a state of emergency. I find probable cause, and I'll hear the parties' recommendations, beginning with the state at this time.
Your Honor, on charge 3,
Yes.
I'd be requesting a $5,000 bond, considering this was a school he broke into. He was convicted for a theft in mid-February. Looks like he might be on probation for...
I'm not on probation.
Well, he was placed on 9 months probation late December.
I'm not
Okay,
on
Mr.
probation.
Mr. Metzler, right now, it's the state attorney's turn to talk, so I just need you to listen, okay? All right, Mr. Linder, go ahead.
He was placed on 9 months probation late December of last year for criminal mischief and trespass. I don't know if he's still on probation. He's saying he's not. That's fine.
Okay.
Theft 2019, felon carrying concealed weapon 2015, 24 months state prison as a habitual offender. Battery 2015, theft 2015, attempted strong arm robbery 2014, a little over 14 and a half months state prison. Another strong arm robbery 2012. Nothing further.
All right, thank
Your
you.
Honor, I would object to the fact of probable cause and using the aggravator of the state of emergency in this case. In this case, I don't think the aggravator works just because it's usually an aggravator as a condition arising from an emergency, which means a civil unrest or power outage. There's nothing that this aggravator resulted from him making it easier for him to commit the burglaries in this case, Your Honor.
Actually, Your Honor, I would argue, while that was argued in the past, those arguments were made before a countywide shelter-in-place order was made. That shelter-in-place order, Your Honor, it's one of the reasons I believe is also for the benefits of law enforcement can concentrate in other areas. If Mr. Metzler was following that order from the county, he wouldn't have been in a position to be committing this offense.
I'm homeless. I was
All right,
just
Mr.
looking for somewhere to
Metzler,
sleep.
Mr. Metzler, I don't want you to say anything about the case right now, okay? Just listen, just listen. All right, I'm going to leave the probable cause finding in place, and I will hear the defense's recommendation as to bond.
Yes, Your Honor. Mr. Metzler is only 25 years old. He does have family support. His mom lives in Indiana. He does have an uncle in South Florida who he can stay with, especially if pretrial needs to verify an address. For the past several years, he's worked in lawn care. We recognize he has prior contact with the law, but Mr. Metzler also suffers from asthma, making him particularly susceptible to the worldwide pandemic that we're dealing with. Mr. Metzler will be in good contact with his attorney. He will come to any required court dates. We're asking that he please be released on his own recognizance.
I got no way to pay a bill.
Wait one moment.
Okay.
Please.
Mr. Linder, what was his most recent, did you tell me that the cases were resolved or there's anything pending?
Your Honor, well, first off, and as far as counsel's guarantees that he will show up in court, 3 of his last 4 arrests have been on capiases for failing to appear in court. His last arrest was March 20,
All right.
February 28th, and that was on a capias on a trespass. And,
I didn't know my court date because I'm homeless.
Mr.
and the
Metzler,
address-
Mr. Metzler, please, just one moment, okay? Just listen.
All right, my bad.
and then there was a theft that was resolved February 13th.
Okay. All right, Mr.
Petty theft.
All right, I'm going to leave the standard bond in place on count 1. The bond on count 3 is going to be set at $2,000, and there will be a no return order to this school location, which I believe is Cypress Elementary. Mr. Metzler, that means that you're not to go to or return to that location. Do you understand? Mr. Metzler, do you understand the no return order I just explained to you?
I understand, but can I speak?
I just want
It's not
you,
about the principle of my case. I just want to speak.
just about bond or release conditions, you understand?
Yes, ma'am.
Okay.
Ma'am, I'm homeless. I was going into school to go
Okay,
to
Mr.
sleep.
Metzler, I don't want you to
I'm
say
not
anything
speaking,
else.
please. I'm not speaking on the principle.
That's exactly what you just
Right
did.
now?
Mr. Metzler,
Right
that's gonna
now?
be it.
Okay, can I speak? I want to speak on the principle of the war.
Okay, Mr. Metzler, I'm gonna let you speak.
I'm at a
Mr.
case where
Metzler,
I can't
that's gonna be
afford
it.
bond.
That's gonna be it.
Yes,
Deputy,
I
go
can't
ahead.
afford bond.
Sir, can you step out, please?
All right.
Ma'am, please, can I speak one more time?
Mr. Metzler, you can talk to your attorneys after the hearing is over.
Step
All right, who's my next satellite case?
Some's got to give people some.
I'll do the Spanish.
Your Honor?
Yes, Deputy.
Excuse me. We have Lou Bryce here.
Okay, let's bring him up, please.
Okay.
Can one of my deputies
Come on,
have
Lou.
them? Thank you.
Do me a favor, could you look them up again? Because I can't, I gotta Might not.
Okay, good morning, Mr. Liu.
Good morning.
Mr. Liu, I've got your private counsel and some of your family members present. I'm just waiting for them to come into the courtroom. Just give me one moment.
Okay.
You don't have a social there?
Hi, everyone. All right, are you family members?
Yes, I'm the mother.
Okay, I have a note on here that there's a private attorney. Is that correct or no?
So much.
Who's the attorney?
Denzel Laddie?
Laddie?
Yes.
Has he already been retained?
Yes.
Does he know about this hearing this morning? Is he coming to the hearing?
No, Your Honor, he actually called us and left a number for the court to call. Thank you.
Hello? Hi, is this Maurice? All right, Maurice. Tell me.
All right, let me just get Mr. Laddie on the phone. One moment.
Tell me, is your family, mom, dad, siblings? All right, what do you do?
Hello, good morning.
Good morning, Mr. Laddie. This is Judge Cawthon. How are you this morning?
I'm well, Judge. Good morning. How are you?
I'm hanging in there. I've got
Sounds great.
I've got Mr. Liu here in front of me, and I have some family members present as well. So I'm going to go ahead and read his charges, and then I'll go to the parties. Okay?
Sure.
All right. Okay, Mr. Liu, you're before the court this morning on 6 charges. Count 1 is battery on a law enforcement officer. Count 2, resisting an officer or obstructing with violence. Count 3, reckless driving. Count 4, driving without headlights, that is not for magistrate. Count 5 is a tinting violation, which is not for magistrate. And count 6 is a separate count for battery on a law enforcement officer. I find probable cause, and at this time, I'm going to hear recommendations from the parties. I'll begin with the state, and then I'll go to Mr. Laddie after Mr. Linder is done.
Your Honor, I'm going to be requesting a $1,000 bond on count 1 and 6, the 2 batteries on law enforcement officers.
Okay.
$500 bond on 2. Based on the driving pattern in this case, Your Honor, I'm going to be asking for an order of no driving until further order of the court.
All right, and Mr. Laddie, I'll go to you next.
Good morning again, Judge. That was very reasonable, I must say, from Mr. Linder. I appreciate that. However, Judge, my client is just turned 19 years old. He just graduated high school, got accepted to DC, plans to do business administration there, has been a resident of this county for all his life, pretty much. It seems to me this is an isolated incident, Judge, based on my conversations with him. I'm asking Your Honor, he doesn't have any money to pay the bond. His parents are there, I'm sure. They're not independently wealthy or independently financially able. So therefore, Judge, I'm asking for pretrial release, if at all possible.
All right.
I don't know if counsel's aware of the allegations, but that he's allegedly at midnight driving 130 miles per hour without his lights on Griffin Road, putting his life, his passenger's life, any other drivers on the road's lives in jeopardy. When he stopped, he lies about why he was driving like that because his passenger essentially indicated the story he was giving wasn't true. And then when he's taken into custody, he kicks one police officer and headbutts another police officer. I'm not asking for what I consider to be high bonds, but I think they are reasonable under the circumstances.
And again, just to rebut a little bit, again, those are allegations, Judge. As it relates to this 130 miles per hour, I do not believe any of the officers can indicate with any degree of certainty that he was clocked going 130 miles an hour. In addition to that, Your Honor, there was no indication that he was weaving in and out of traffic or obstructed anyone. But again, Your Honor, I'm asking for pretrial release, and I'll defer to the court.
All right, well now I have, are you Mr. Liu's parents?
Yes.
Okay, are you here just to observe this morning or to speak? You don't have to speak, I'm just asking. Just to observe? Yes?
Yes, ma'am.
Okay, all right. Okay. Mr. Linder, does Mr. Liu have any prior history? Okay. Happy to see that Mr. Liu has his parents here. He's lucky to have parents who have taken an interest to come here to support him today. I've heard what Mr. Laddie has said as well as Mr. Linder. I understand Mr. Liu has a limited history, but the information that's provided in the probable cause affidavit does give me some concern, especially in light of the present circumstances that we find ourselves in light of the stay-at-home order that has been issued, to see allegations such as this. You know, it gives me a lot of concern as far as the danger and risk to the community. Based on the information, everything taken in totality, I'm not willing to grant a straight ROR to pretrial supervision. However, what I will do is on counts 1, 2, and 6, I am going to set the bond at $500 per count. I will leave the standard bond in place On count 3, that's a $100 bond. And in an abundance of caution, I am going to order that Mr. Liu not be driving until further order of the court. Mr. Liu, so that you understand, as a condition of your release, that means that you are not to be driving or operating any motor vehicle until a judge says otherwise. Do you understand that?
Yes, ma'am.
All right, thank you very much, sir. Good luck to you. All right, Mr. Laddie, thank you for being present. Mom and Dad, good luck to you.
Thank you so very much, Judge. Have a good day.
Thank you, same to you.
Welcome. Bye-bye.
Okay. All right, I have our 2 interpreter cases. Let me just ask, the second look, Gutierrez, is that one of those where the attorney's appearing via Zoom? Okay. All
Gonna
right.
need a Spanish interpreter, Your Honor, Gutierrez.
Which one?
Gutierrez.
On Gutierrez, okay. All right, Debbie, just give me a few minutes, because the attorney on that case is appearing via Zoom also, so we gotta get that set up.
Okay.
All right, let me go through some more of our other cases first, and then we'll come back to those. All right, are we ready to start with the main cases? Okay. If I get to someone that you haven't spoken with, then just let me know and I'll put them on recall, okay? All right, let's go to Maine. And first on my list is going to be Paige O'Laughlin. All right.
Hello, Judge.
Good morning, Ms. O'Laughlin. All right, ma'am, you're before the court this morning on 1 charge of touch or strike battery, domestic violence. I find probable cause, and at this time, I'll hear the parties' recommendations, beginning with the state.
She has no priors. The state has no objection to her being released by ROR.
ROR? All right.
Your Honor, may we ask for permission to travel? Miss O'Laughlin actually lives in Toledo.
She's not being placed on pretrial.
Oh, okay, perfect. Thank you.
All right, Ms. O'Laughlin, I'm going to ROR you, which
Yes.
means that you're going to be released today. But I also need you to understand that as a condition of your release, there's going to be an order of no victim contact. That
Right.
means that until further order of the court, no being in the
Right.
same place at the same time as the alleged victim, no phone calls or text messages, no third-party contact or social media contact. You understand?
Absolutely.
All right.
Thank you.
Thank you, ma'am. Good luck.
Thanks.
Debbie Alvarez. Good morning, Ms. Alvarez.
Good morning.
Ms. Alvarez, you're before the court this morning on 2 charges. Count 1, driving while license suspended, habitual. Count 2 is a felony probation violation, which has a no bond hold. I find probable cause, and the no bond hold will have to be addressed with the division judge. In light of that, do the parties have any objection to the standard bond on count 1?
Your Honor, can we still possibly argue for a bond on the
No,
No?
not on felony cases.
Judge, my argument, so if I may just lay an argument, Your Honor.
Can we turn the speaker off at Maine for a moment, please? Make it brief, counsel.
I will, Your Honor. 948.06, subsection 1, subsection E, subsection 2A. Your Honor, it allows the court to hear these arguments as long as admittance is not entered, as long as she hasn't admitted, Your Honor. This is a driving offense. She before going in, Your Honor, at the time that she took in this plea for this underlying probation matter, she scored less than 22 points. Now she picked up, she was on 6 months probation in front of the Honorable Judge Barbara McCarthy, and she picked up this driving offense. She was within about 2 months from her.
Counsel, she's on probation for felony driving with a suspended license. She has picked up a new charge for driving with a suspended license. She now has a no bond hold. There's nothing else to argue until it is before Judge McCarthy. Thank you. All right, good luck, ma'am. Is Grace Johnson still medical? Okay. Princess Jackson is a medical.
Yes, medical reset, Your Honor, on Johnson and Jackson.
Okay, thank you. And how about Kirsten Chernay?
Medical reset as well, Your Honor.
All right, I see on Ms. Chernay's case, she has 2 out-of-state holds, which have no bond holds. In order to, I understand she's medical, but since this is gonna be going to extradition court, I'm going to make a probable cause finding in absentia, and that way she'll be able to be set on the extradition docket. Jared Harrison.
Medical reset, Your Honor.
All right, and I'm gonna do the same thing in Mr. Harrison's case. I see the only thing that he has is an out-of-state hold, so I'm going to make a probable cause finding in absentia, and he can be set on the extradition docket. Earl Gaines.
I ain't seen that. Major.
Good morning, Mr. Gaines.
How you doing?
I'm well, thank you. Mr. Gaines, you're before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause, and at this time, we'll hear the parties' recommendations. We'll begin with the state.
Your Honor, he has no prior driving infractions,
Okay,
and based on the facts, the state will be asking for a $500 bond.
$500?
Yes.
All right, defense?
Yes, Your Honor. Mr. Gaines is 31 years old. He's lived in South Florida his entire life. For the past 7 years, he's worked in the funeral industry. Mr. Gaines does report that he has asthma, which is one of the underlying health conditions that makes people particularly susceptible to our pandemic. He does have a place separate and apart to live from the listed victim. He will be in, he reports, advises he'll be in good contact with his attorney and come to any required court dates. We're asking that Mr. Gaines please be released on his own recognizance.
All right, in light of the fact that it appears there was an independent witness and the alleged victim in this case sustained multiple contusions and cuts to her face, I am not willing to grant an ROR at this time. The bond will be set at $500. There will be an order of no victim contact. Mr. Gaines, please understand that means until further order of the court, no being in the same place at the same time as the alleged victim. Yes? Your private counsel, Mr. Gaines?
Yeah, can you give us 30 seconds so I can look at the
Sure, why not? Mr. Gaines, I'm going to call you back up in a few minutes since apparently you have private counsel and no one advised me of that until now. I'll call you back up in a minute. Daniel Sales.
Thanks for now. You have a better attitude than me.
Good morning, Mr. Sales.
He needs a Spanish interpreter, Your Honor.
Okay, I'll put him on recall. Okay, let's bring Mr. Gaines back up, please. All right, yes, counsel.
Hi, Mike Giletti, apologize for my outfit, but,
Oh, you're fine. You're fine.
Judge, I understand that, that we're able to agree to a $500 bond and no contact with the supposed victim, so that sounds pretty reasonable.
Okay, excellent. That was my ruling anyway. All right. Mr. Gaines, your private counsel is here. As I said before, the bond is going to be $500, and the no victim contact order that I explained to you is going to be in place. Okay, do you understand that? I'm sorry, can I just have the deputy turn the speaker on for one moment? Thank you. And Mr. Gaines, you understand that no contact order I explained?
Yes, ma'am.
Okay, thank you very much. Good luck, sir.
All right, thanks.
All right, thank you,
Wait,
Mr.
I'm a
Belletti.
lawyer, right?
Thank you. Did I, oh no, that's on the next case, okay. All right, Shannon McAfee. All right, good morning, Mr. McAfee. Sir, you're before the court this morning on one charge of battery causing bodily harm, domestic violence. I find probable cause, and I'll hear the parties' recommendations, beginning with the state.
Your Honor, the defendant has no prior driving infractions, so based on the facts of the case, state is requesting a $500 bond.
Okay, defense.
Judge, I'd be asking for an ROR. He has a place to live outside of the suspected area where this occurred. He just needs to get some kind of clothing from that area, and I'd advise him to go speak with somebody who can do that, with a law enforcement officer if he ever has to go get there to get his personal effects.
Okay. All right, based on the allegations, I'm just noting some of the information provided by the alleged victim, including the injuries that were allegedly sustained. In light of that information, I'm not willing to grant a straight ROR at this time. I am going to set the bond at $500. There's going to be an order of no victim contact, as well as an order that Mr. McAfee possessed no weapons, firearms, or ammunition. Mr. McAfee, with respect to the no contact order, that means until further order of the court, no being in the same place at the same time as the alleged victim. That also means no phone calls or text messages to this person, and no third-party contact or social media contact. Do you understand that?
Yes.
All right. Additionally, there is going to be an order that you possess no weapons, firearms, or ammunition. That means until a judge says otherwise, if you are in possession of any of those items, they are to be surrendered to local law enforcement. Do you understand?
Yes.
All right. And if you need, as counsel said, if you need to go back to the location where the alleged victim resides to get some personal belongings, you may do that one time, but it must be with local law enforcement. That means that you are to call local law enforcement beforehand and coordinate with them. Do you understand that?
Yes, ma'am.
All right. Thank you very much. Good luck, sir.
Thank you.
Richard Kelly. Good morning, Mr. Kelly.
Good morning, Your Honor.
All right, Mr. Kelly, you're before the court this morning on one charge of battery causing bodily harm, domestic violence. I find probable cause, and I'll hear the parties' recommendations beginning with the state.
Your Honor, he has no priors as well, and based on the facts, the state will be requesting a $500 bond.
Okay, defense?
Your Honor, I'd be asking for a standard pretrial since he has no priors before the court. Unfortunately, he was working as a commercial desk salesperson, Your Honor. But business is slow based on what's going on with the pandemic.
Okay.
So I think a non-mandatory bond would be perfect in this case.
All right, I will ROR Mr. Kelly and place him on standard pretrial supervision. Mr. Kelly, a couple of important things for you to know. Number one, since I'm putting you on standard pretrial supervision, that means that you will be released today, but you must report to pretrial supervision in person within 24 hours. One of the deputies will give you a piece of paper with instructions on where you need to go. If you fail to report to them as I have instructed you, a warrant will be issued for your arrest. The second thing that's important for you to know is that there is going to be an order of no victim contact. That means until further order of the court, no being in the same place at the same time as the alleged victim, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. All right. And Mr. Kelly, do you understand everything I've explained to you? Oh, I don't think the mic is on. Deputy, can you just turn that on? Thank you.
Yes, I do.
Okay. All right. Thank you, sir. Good luck to you.
Thank you.
Rolando Gabarit Barcenas.
Medical reset, Your Honor.
All right. Thank you. Jesus Carry On. He's still medical.
Medical reset, Your Honor.
Okay. Is John Tikax still medical?
Yes, medical reset.
Eligio Gonzalez Torres.
Spanish interpreter, Your Honor.
All right, I'll put him on recall. Thank you. Stefan Brown. Good morning, Mr. Brown. Mr. Brown, you're before the court this morning on one charge of illegal use of a credit card more than 2 times in a 6-month period. I find probable cause. I see there's a $1,000 standard bond. Is the state seeking anything beyond that?
No.
Okay. Defense, any objection to the $1,000 bond?
Judge, I'd ask the court if it's inclined to grant a non-monetary condition of bond. He is 34 years old. He's been in South Florida for about 2 years now. He does want to resolve his case, but unfortunately, it's a felony, so I wouldn't suggest you do that.
Well, he wouldn't be able to do that anyway.
Your Honor,
All right. Yes.
just to advise the court of his history, 2017 strong-arm robbery. He was sentenced to 25 months in state prison as a habitual offender, released February 17th, 2019. Other priors include possession of cocaine, violation, domestic violence injunction, another strong-arm robbery in 2013, burglary of a conveyance of 5. There are other priors, but those are the most serious and relevant.
All right, I'm going to leave the $1,000 bond in place. There will be an order of no victim contact. Mr. Brown, whether you know the alleged victim or not, please understand that the no contact order means no being in the same place at the same time as the alleged victim, no phone calls or text messages to this person, no third-party contact or social media contact with that person. Do you understand?
Yes, ma'am.
All right, thank you, sir. Good luck to you. Markendi Mombranch. Good morning, Mr. Mombranch.
Good morning, ma'am.
Mr. Mombranch, you're before the court this morning on 2 charges. Count 1, grand theft auto. Count 2, driving while license suspended, second offense. I find probable cause. Is the state seeking anything beyond the standard bond?
Not at this time, Your Honor.
All right, defense?
Your Honor, I'd be asking for standard pretrial. At this time, Mr. Montbranch cannot afford the $1,000 bond. He does work as a line cook at La Bonique Crepes, which is right down here in Fort Lauderdale. He has been working there for about 2 years now, Judge. He's a young age of 24 years old, and he does have 4 children that him and his mother both take care of, but his mother does work, and so he would be one of the primary caretakers of the 4 children.
Priors?
Does, Your Honor. He got arrested earlier last month, resisting without violence and trespass. He had a 2018 grand theft auto that he violated probation on late December. He was sentenced to 180 days. With gain time, he was released. I guess he already had his 180 days in when he was sentenced, so he wasn't taken into custody.
Okay.
Other than that, drug priors.
All right, based on the nature of the allegations, I'm going to release Mr. Mombranch and place him on standard pretrial supervision. Mr. Mombranch, a couple of important things that you need to know. Number 1, since I'm putting you on standard pretrial, you're going to be released today, but you must report to pretrial in person within 24 hours. If you fail to report to them, as I've instructed you, a warrant will be issued for your arrest. Number 2, with respect to the grand theft auto case, there is going to be an order of no victim contact. Whether you know the alleged victim or not, please understand that means no being in the same place at the same time as the alleged victim, no phone calls or text messages to that person, and no third-party contact or social media contact. Do you understand everything I've explained to you?
Yes, ma'am.
All right, thank you, sir. Good luck.
Ma'am, blessed.
DeBarris Singletary. All right.
Yes.
Good morning, Mr. Singletary.
Good
All
morning.
right, sir, you're before the court on 3 charges. These are each related to a violation of community control in a felony case. They have no bond holds. I find probable cause, and
My only question is, I understand it's a BIOP, I just don't know what the VOP is for. My belief, and someone from my office believe, judges, it's still from the old March violation of probation. I don't know if there is a new violation from that March date, the one that he already resolved. So that's why I'm just bringing it to the court's attention. That I don't know if this is a new violation, and he's unaware of a new violation when I spoke with him on the phone, and I don't see one reflecting on the clerk's system, Judge. I don't know if the state may have more information.
It doesn't have anything to do with the clerk system. There's a warrant.
there's a warrant signed by Judge Lynch on March 30th.
Okay, thank you, Your Honor.
All right. Mr. Singletary, since you have the no bond holds, that means that your division judge is the one that will address it with you shortly. All right, good luck to you, sir. Stephen Syriacs. Is count 1 on his supposed to be retail theft?
Essentially, yeah, it's a fancy way of just saying
Okay.
petty theft. You know?
Mr. Syriacs, good morning.
Morning.
You're before the court this morning on 4 charges. Count 1 is retail theft. Count 2, grand theft auto. Count 3, resisting an officer or obstructing without violence. I find probable cause, and I will hear the party's recommendations. Is the state seeking anything beyond the standard bond?
Yes, I'm asking for a $1,000 bond on the theft. First off, Your Honor, as the court's very familiar with Mr. Syriacs, he picked up all his felony thefts and ad charges, and he went before the court, and he begged and pleaded to give him an ROR to pretrial so he could get out, so he could start his job. And now, with everything we're going through, he goes into a CVS with another individual, claiming to have a virus so he could steal beer.
This court did not release him, just so you know.
Okay.
The defendant is
Well,
being
I
supervised
meant
by pretrial services. In case number 202741 CF10A, felony petty theft. 202827 CF10A, felony petty theft. 22560 CF10A, felony petty theft. 22968 CF10A, felony petty theft. 203038 CF10A, 3 counts of felony petty theft. And 22387 CF10A, grand theft auto. Your Honor, we're asking that the defendant's pretrial status be revoked in all of these open cases based on this court's finding of probable cause today. It's the original.
All right, Mr. Syriacs. Had this conversation not too long ago. Based on pretrial's request, based on the recency of similar charges, circumstances, and information provided, I'm going to grant pretrial's request to revoke Mr. Syriac's pretrial services. I'll read those case numbers one more time for the record. That is 20002387 CF10A, 2000303F CF10A, 200002968 CF10A, 200002560 CF10A, 200002827 CF10A, and 200002741 CF10A. In all of these cases, I'm going to order that Mr. Syriacs be held no bond so that his division judge can determine how he or she would like to handle these cases further. With respect to the cases before me today, Mr. Linder, I heard the information that you provided, but I didn't hear, did you have a recommendation beyond the $1,000?
I'm fine with the 1,000 on 1, 1,000 on 2, obviously no return. Yeah, actually, you know what? No, Your Honor, with the no bond holds, that's fine.
1,000 on 1, 1,000 on 2, is that what you said?
Yes, it is.
All right, defense, in light of the no bond holds, any objection? All right, then in the case that's before me today, the bond on count 1 will be set at $1,000. The standard bond will remain on count 2. There will be a no return order to the CVS location at issue in this case, and the no bond hold will have to be addressed with the division judge. Good luck, Mr. Syriacs. Javier Permenter. All right, good morning, Mr. Permenter. Sir, you're before the court this morning on 2 charges. Count 1, accessory after the fact and a 3rd-degree felony. Count 2 is 2nd-degree petty theft, first offense. I find probable cause.
And Your Honor?
Go ahead.
I'm not gonna have any objection to an ROR on count 1. There really is, I mean, even if the court wants to put a finding in OPC, I'm fine with that too. There's really no allegations that he was an accessory to the actual grand theft of the vehicle.
Okay.
However, one on, on the theft, I'm going to be requesting a $1,000 bond.
Okay.
the court should be aware, and it's up to your Honor's discretion to take action sua sponte. He is out right now on a, let me see, I just want to see what the charge is. I believe it's a robbery with a firearm or deadly weapon. He is in grand theft auto, DWS habitual offender. He's in career criminal court before Judge Bober. He was just released February 28th. He's also out on a felony theft. He's gone to prison as a habitual offender for uttering a forged instrument, grand theft. He's gone to prison for felony theft, robbery by sudden snatching, grand theft auto, strong arm robbery, felony battery, great bodily harm. So
What's the case number for the pending case?
the robbery case, it is 19-10339 CF10A.
Defense?
Sure, that would be something to focus on the other cases. I do agree with the state that he does have there is no PC for the count 1 and the count 2, the petty theft judge. I'd be asking for a standard pretrial in that case. He is represented by regional conflict counsel judge on the other cases.
All right, at this time, in light of the nature of the charges and the recency in which these new allegations have arisen compared to Mr. Permenter's last release date, the court is going to sua sponte revoke his bond in case number 1910339 CF10A. I'm going to order that he be held no bond in that case so that Judge Bober can further address the matter. In the case that is before me today, I will find no probable cause as to count 1, so that will be an ROR. Count 2, bond will be set at $1,000. There will also be a no return order to the CVS location that is at issue in this case. Good luck to you, Mr. Permenter. John Gardner. All right, good morning, Mr. Gardner. Mr. Gardner, you're before the court this morning on one charge of aggravated fleeing and eluding. I find probable cause. I'll hear the parties' recommendations, beginning with the state.
Your Honor, I'm requesting a $2,500 bond on count 1. This is based on the allegations in the case, the driving pattern. I believe there's an allegation there was a 1-year-old in the vehicle when he was exhibiting this driving pattern. Additionally, under the name John Kelly in 2006, he had a robbery with a firearm or deadly weapon. He was sentenced to 10 years state prison to be followed by 10 years probation.
All right, defense?
Your Honor, Mr. Gardner is 31 years old. He's the proud father of 2 young children, including a 2-year-old. He works in a 2-year-old and a 4-month-old. He works in the warehousing, stocking industry for the past 5 years, which has obviously been very negatively impacted by the pandemic. We recognize the state's statement regarding a child being in the car, but as we can all see, he wasn't charged with any sort of counts of child endangerment. Any sort of allegations were not included in the charging documents. He is the main family supporter of his young children. All of his family's here from South Florida, so he does have strong ties strong ties to the community. Mr. Gardner assures me and advises that he will be in good contact with his attorney, will come to all required court dates. We're asking that Mr. Gardner please be released on his own recognizance.
That is absolutely not going to happen based on these allegations. I'm not going to take the time to read the allegations that are included in the probable cause affidavit into the record, but I do find it very concerning that besides the fact that these are fleeing and eluding charges to begin with, I find it extremely aggravating whether he was charged with anything related to the child or not. The probable cause affidavit does include information indicating that a 1-year-old child was sitting in the middle of the rear seat, completely unrestrained at the time that Mr. Gardner allegedly fled the scene from law enforcement. I'm not sure if the 1-year-old referenced in this affidavit is one of the children that you referenced, counsel, but I do find that very aggravating.
Oh, we understand, Your Honor. Obviously, his employment has been impacted, so he would have financial constraints in posting a high monetary bond. We're asking if the court is so inclined that he please be ROR to standard pretrial so he can be supervised in the community.
The bond will be set at $1,500. Good luck, Mr. Gardner.
Thank you.
Yes.
We did prove concept for what we discussed earlier.
Okay, thank you. Next will be Maurice Paterkin. All right, good morning, Mr. Paterkin.
Anything other than these 2,000?
You're before the court this morning on 2 charges. Count 1, aggravated assault with a deadly weapon without intent to kill. Count 2 is carrying a concealed firearm. I find probable cause, and I'll hear the parties' recommendations, beginning with the state.
Your Honor, I'd be requesting a $4,000 bond on count 1. I ask that the $1,000 bond on count 2 be left in place based on the allegations. He has a carrying concealed weapon from 2018 that was pled down from carrying concealed firearm. Request no victim contact, no possession of any firearms, weapons, ammunition. Nothing further.
Yes, Your Honor. Mr. Paterkin is only 20 years old. His entire family is in South Florida. He is a high school graduate with plans to work in real estate. He does currently work supporting the family business with his uncle, which is moving furniture. Mr. Paterkin would have financial difficulties posting a high monetary bond, so we recognize the seriousness of the allegations, so we're asking that Mr. Paterkin please be ROR to standard pretrial.
And Judge, for count 2, I would point out to the court that there is no, mention that the firearm was concealed. It could have been in plain view. So I'd be asking the court to consider that on its monetary bond or non-monetary bond conditions.
Your Honor, considering that the gun wasn't seen at one point and then the victim then sees the gun, it had to have been concealed.
Not necessarily, Judge. It could be in plain view in the car.
The bond on count 1 will be set at $2,000. The bond on count 2 is going to be set at $500. There will be an order of no victim contact, as well as an order that Mr. Paterkin possess no weapons, firearms, or ammunition. Mr. Paterkin, I need you to understand that with respect to the no contact order, that means that you're not to be in the same place at the same time as the alleged victim. That also means no phone calls or text messages and no third-party contact or social media contact with this person. Do you understand that?
With the other victim?
The alleged victim, yes. Do you understand?
Right.
Okay.
Understood,
All
Your
right.
Honor.
All right. And Mr. Paterkin, there's also going to be an order that you possess no weapons, firearms, or ammunition. That means if you are in possession of any of those items, until a judge says otherwise, they are to be surrendered to local law enforcement. Do you understand that?
Understood, Your Honor.
Okay. All right. Thank you very much. Good luck. Is John Toomey still medical? Yes.
Yeah, he's back. I just don't know if he's there or not.
He's on medical loan, Your Honor.
Okay. Thank you, Deputy. What about Christopher Pinkney?
Your Honor, can we check?
Medical loan, Your Honor.
BSO Pix is saying that Mr.
That's what he said.
On the docket, it may say loan for Mr. Toomey, but in BSO Pix, it's saying he's at North Broward.
I'm sorry, it's saying what?
He's at North Broward.
Okay, I'll check with North Broward. Can I have the paperwork to me real quick? Hold on, top. All right, I'll come back to this. Okay, Pinckney is a medical reset. All right, and I already found probable cause on his. We're just waiting on bonds. Okay, let me go to North Broward for a moment. North Broward, for my deputies there, can you tell me if you have John Toomey there at the North Broward facility?
What's the last name?
Toomey, Toomey.
Okay, stand by.
Thank you.
Yes, I did do him.
Just happened.
Okay. Just want to confirm with them so I have them there.
Why is this be written twice? For Dean?
I believe in Toomey's case, I believe we already have probable cause finding. It's just
Like it's the
waiting
same
on
case
bonds.
number, same.
That is correct, Judge.
Are you sure?
Yeah. That's it. So, no. Well, I guess this is 2 counts.
Well, I'm waiting on North Broward to confirm that. The next case I have is Dean Lietzau. Is he a medical reset today?
I spoke to him, Your Honor.
You did? Okay.
Yes, Judge, it looks like.
Okay. Okay, I'll be right there. I'm just waiting on North Broward for something.
Your Honor, I'm trying to call the public defender. Can she pick up? Hello?
Okay, why don't,
Someone else is calling. I don't know.
okay, you guys have your phone hung up?
Looks like-
All right, Deputy, you can try to recall them. Their phone is hung, okay.
Thank you.
Thank you. All right, let me go to Maine, and we'll do Mr. Litzau's case while we're waiting on that. All right, good morning, Mr. Litzau. Okay, and what's the correction on his case?
Judge, on count 6, if you can take out the CF-10A, that's a Highlands County violation.
You mean count 5?
106. Oh, what number is it? I'm sorry.
Count 5?
Count 5?
Yes.
Yeah, you can scratch out CF-10A, that is a corrective action.
Okay, all right, thank you, okay. All right, Mr. Litzau, you're before the court this morning on 5 charges. Count 1, false ID given to law enforcement. Count 2, burglary of an unoccupied conveyance unarmed. Count 3, third-degree grand theft. Count 4 is an out-of-county felony hold from Highlands County. And count 5 is a felony probation violation with a no bond hold out of Highlands County. I find probable cause, and I will hear the parties' recommendations on count 2.
Your Honor, in light of the no bond hold out of county, I'd be requesting $1,000 bond on count 2.
Okay, defense?
Yes, Your Honor. Mr. Letzau is 50 years old. He's lived in South Florida for the past 40 years. He is a painting contractor with 3 children, 2 minor, including a 12-year-old who is home because of what's going on, and a 2.5-year-old. He does have a medical condition which makes him particularly susceptible to what's going on with the pandemic. Mr. Latzau reports that once his Highland County case is handled, and obviously he'll come to any required court dates, be in excellent communication with his attorney. So we're asking for a reasonable bond so he can be released to Highland and have that taken care of.
So what's the recommendation?
ROR, that's my go-to. Thank you, Your Honor.
Mr. Linder?
Nothing further, Judge.
All right, in light of the no bond holds, I'm not going to grant the RR. I also just want to say on the record that since he has the no bond hold, he's probably going to remain in custody in light of what's going on and the fact he has no bond holds, and if I did grant an ROR, he would not be getting any time served accrued on that charge. So in light of that, I am going to set the bond on count 2 at $1,000. I'll leave the standard bonds on 1 and 3, and there will be a no return order to the Home Depot location that is at issue in this case. All right, good luck to you, Mr. Witzel.
Attach this to that paper I just gave you.
And, Your Honor, I believe, pretrial, I think, was it count 5 was deleted?
No, it was a correction to the case
Oh,
number.
just a highlight.
Just a
Thank
correction
you.
to the case number. Yes,
I have a
Mr.
question.
Witzel. Yes, sir.
Is Highlands County gonna come get me first?
Is Highlands County transporting right now? They're not transporting right now, Mr. Litzow, so that means that you'll have to address the Broward case, okay? Right now, they're not doing any transport.
Okay, all right, thank you.
All right, thank you, sir. Good luck. Okay, did we get any clarification from North Broward on Toomey?
Judge, unfortunately, he's unavailable because he's in the infirmary, so he won't
Okay.
be available for at least an hour at least.
Okay, that's fine. We'll reset him. I just wanted to know what's going on with him.
Of course.
All right, we'll reset him to tomorrow. Okay, next will be O'Dane Wellington.
And Your Honor, Mr. Felipe Jaramillo, he filed a substitution of counsel, stipulated substitution of counsel on March 27th.
Have you spoken with him?
He's representing. No, Judge, I reached out to him, but that was before we started the docket.
No, if you like, I could reach out to him.
Okay, all right. Mr. Wellington, I'm going to put your case on a brief recall so that the attorneys here can reach out to your private counsel and see if he wants to be present for this hearing. And then I'll call you back up in a few minutes when I have an answer, okay? So just hang tight for a few minutes. All right, next will be James Philbin.
Medical reset.
All right, I see that this is a felony violation of probation on Mr. Philbin's case, so I'm going to make a probable cause finding in absentia since that's the only thing on here, and then he can be set up with his division judge. All right. And next will be Louis Damiani. All right, good morning, Mr. Damiani. You're before the court this morning.
Good morning, Your Honor.
All right, good morning. Okay, Mr. Damiani, you're before the court this morning on 6 charges. Counts 1 through 4 are each a separate charge of burglary of an unoccupied conveyance, unarmed. Counts 5 and 6 are for dealing in stolen property and false owner information provided for pawned items. At this time, I will hear from the parties. We'll begin with the state.
Your Honor, Mr. Damiani's history, 2015, aggravated fleeing and eluding with the VOP. 2014, burglary of a conveyance and grand theft between $5,000 and $10,000. On counts 1, 2, 3, and 4, State be requesting a $1,000 bond in each count. No victim contact, no return.
All right, defense.
Yes, Your Honor. Mr. Damiani is only 23 years old. He currently, because of all that's been going on, has not been working because his father is severely ill. He has multiple sclerosis. His mom is working, so Mr. Damiani is the person who has been taking care of his father, getting his medications, coordinating doctor's visits. Mr. Damiani is trained as a mechanic, did go to trade school for that. It's just him, his mom, and his father living in the home right now. Mr. Damiani reports that, advises me that he will be in full compliance with any required court orders, will come to court when required and be in good communication with his attorney. We're asking that he please be released on his own recognizance to standard pretrial release.
Did you say that he resides with his mother?
Yes, and his father, so they all live in a condo together.
All right, for the record, I find probable cause I'm willing to release Mr. Damiani without a monetary bond, but it will be with a GPS monitor.
May I have a moment to speak to Mr. Damiani? Are you willing to set a monetary bond, Your Honor? What's the option?
I'm willing to. Would I be, does my mom have to come to court though? Because my mom can't make it to court.
No, Mr. Damiani, your mother would not have to come. What would happen is that pretrial supervision would have to verify your address. And once they do that, they would outfit you with the GPS monitor before you're released. You understand that?
Yes, I do. Is it okay if I could just bond out? Because I could bond out.
Okay. Well, then if you
Thank
can
you, Your
bond
Honor.
out, I don't know why the defense is requesting an ROR. All right, the bond on counts 1 through 4 will be set at $500 each, and I will leave the standard bonds in place on counts 5 and 6. There will
Thank
be,
you.
okay, Mr. Damiani, 2 more things, all right? There's going to be orders of no victim contact and no return. I need you to understand whether you know the alleged victims or not. That means no going to or returning to these locations. That means no being in the same place at the same time as the alleged victims. No phone calls or text messages to these people, and no third-party contact or social media contact with them. Do you understand that?
I understand, Your Honor. Thank you very
All right.
much. I appreciate your time.
Thank you. Good luck, sir.
Thank you.
Your Honor, we can go back to Mr. Wellington's case.
Okay. Did you speak with Mr. Jaramillo on that case?
I'm sorry?
Did you speak with him?
I did, Your Honor. He's not going to need to appear by phone.
Okay. All right, great. Okay. Hi, Mr. Wellington.
How you doing, man?
I'm well, thank you. Mr. Linder from the State Attorney's Office spoke with your private counsel, Mr. Jaramillo, just a moment ago. So Mr. Jaramillo is aware of the hearing today. He's not going to be present because I believe these are just change of charges. So he's aware of what's going on, but he's not going to be here today, okay? So I just need you to listen for a few minutes. All right, so Mr. Linder, I want to make sure I have these change of charges correct on my finding sheet especially. On count 1, is that supposed to be changed to attempted first-degree murder?
Yes, that's what your it's attempted first-degree murder of a law enforcement officer. That's what you found for at the original first appearance, Judge.
All right, let me just make the correction on the finding sheet. All right, on count 2, that has been changed to burglary with assault or battery, is that correct?
That is correct, Your Honor. If you recall, this is one of those cases where the law enforcement put the murder charge on count 1 and then they add the attempt statute on count 2.
Yes.
We just replaced the attempt with a burg bad. That's why I provided the court. So you can just, for your own edification, can see that the allegations do satisfy the offense. I spoke to Mr. Jaramillo.
Yes.
And what we discussed is since Mr. Wellington is already being held no bond on 3 of the counts, he's not taking any making any legal argument with respect to the burg bat today. He asked that I put on the record based on our conversation and that Mr. Wellington knows he will be filing the appropriate motions for an Arthur hearing to seek a bond when the court resumes normal activities and is able to set those type of hearings.
So then he can address all of them.
Exactly.
All right, on count 3, that has been changed to possession of a firearm by felon, is that correct?
Yes, that is a technical change. Your Honor, set the bond at $25,000 at his first appearance.
All right, and then on counts 4 and 5, those have been changed to kidnapping, is that correct?
Again, both technical changes. You found proof evident or presumption great for kidnapping at the original first appearance.
Okay, and then on count 6, that has been,
It's an up file from resisting without to resisting with.
okay.
Your Honor said actually there was already a $100 bond the first time. I'm fine with just keeping that in place.
The
in light of
$100
everything
bond on
else.
count 6?
Yeah.
All right, and then on count 11, that is an add charge for reckless driving causing serious bodily injury, is that correct?
Yeah. Your Honor, I would just, in light of everything else, I'd be asking for $1,000.
Okay. All right, for the record, I find probable cause in light of the discussion and the information, I will, once again, I'm going to make a preliminary finding of proof evident presumption great, and that will apply to counts 1, count 2, count 4, and count 5. Those will be no bond holds. And once again, that will be without prejudice for Mr. Wellington to have the appropriate Arthur hearing before his division judge, which has been discussed with Mr. Jaramillo. And then the bond on count 3, I'll leave at $25,000 as it was set before. On count 6, I will leave the $100 bond that was already set. And on count 11, which is the ad charge, I'll set the bond at $1,000. All right, Mr. Wellington, Mr. Jaramillo knows about all this, so he'll address it with you after the hearing. Okay, good luck to you, sir.
Yes, ma'am.
No, just, yeah. Okay, the next on my list is Georgelis Paulino. All right, good morning, Mr. Paulino.
Good morning, Your Honor.
Mr. Paulino, you're before the court this morning on 2 charges. The charges as listed are burglary of an occupied dwelling unarmed during a state of emergency. Count 2, resisting an officer or obstructing without violence. I find probable cause, and I'll hear the parties' recommendations, beginning with the state. Okay. Go ahead.
Judge, it looks like, I don't know what crime they're in, the state or the police officers are alleging in this case. They do have listed as attempt at the beginning of their police report, and then throughout the PC. I don't think he's ever actually made it into the home, 1. 2, I don't know what crime therein he was intending to commit according to the PC report. And 3, I don't know if he actually lives there, Judge. There is no advice of if he doesn't live there, maybe he was able to go into the house as he is the one that lives there. There's no meaning of that, Judge. He holds that he does live there, Judge, at the listed residence. But, Your Honor, I don't believe there's any probable cause that he was trying to intend to commit a crime therein of the listed address. 2, that he ever made it inside the listed address, Your Honor. And then then I'd make the same argument I made before about the state of emergency aggravating factor.
Well, Your Honor, first off, 1, I agree, it's an attempt. 2, as far as the intent to commit a crime therein, based on the allegation that he threatened to kill her, I think there's numerous theories that I could argue of his crime, the crime he intended to commit if he was able to gain entry. As far as him living there, well, let's see. First, the listed address on the affidavit is a different address list, the Miami address. 2, the allegations for his attempts to enter the residence would seem to indicate that he does not reside there. She also gave a statement that he was attempting to break into the home, certainly implying that he does not reside there because he wasn't trying to get in with a key or through any normal entry to the home. Again, I think the state of emergency is even greater in this situation. This woman's complying with the stay-at-home order. She's staying in her home, and that made her even more vulnerable to Mr. Paulino, considering the allegations in this case. She felt threatened to the point where her and her child were hiding in a closet in the home.
Okay.
Very briefly, if I may, Judge. I understand the state's argument about the threat to kill, Judge, but we don't know if that happened that day, that he threatened to kill her allegedly, or if she said that before, any time since their relationship, he's ever threatened to kill her. We don't know if it was that specific particular day. It's not saying that he's threatening to kill me, Judge. It's using the past tense as she was calling BSO dispatch. And then secondly, with the heightened aggravator, Judge, this has to almost and have to further or maybe arise from the emergency, Judge, the fact that he's knocking or attempting to knock or enter the home.
Okay. All right, I appreciate both of your arguments. Based on the totality of the information, I do believe that we have reached the threshold of probable cause. I am going to leave the probable cause finding in place with the indication that this is for an attempt. All right, and now let's go to recommendations for bond.
Your Honor, it does not appear he has any history. That being said, based on these allegations, I have great concern for the victim. Oh, you don't have notes. Okay, I don't know if he has history or not. But I do have concern for the victim. I have concern for the child in common. She was present, or the child in common was present when this was occurring. So I'm going to be requesting a $20,000 bond on count one. Pretrial release of the GPS monitor, no victim contact, no return.
Judge, for him to be able to be released. And if he does live in Miami, and of course, no contact. South Florida for about 3 years, Your Honor. He did live in Massachusetts for a long time, and he's down here for work, Judge.
Is he able to post any monetary bond?
Not that I know of, Judge.
Right, given the limited record combined with the very serious allegations that we're looking at here today, what I'm willing to do is I'm willing to release Mr. Paulino to pretrial supervision, but that will be with a level 1 GPS monitor, which means that he will be placed on house arrest. I am looking at both the booking information as well as the probable cause affidavit, which indicate an address in Miami. That should suffice to satisfy the no contact order that I'm going to put in place, and pretrial will of course have to verify that address before he is released. So, in light of the allegations involving the threat to kill, though, I'm just not comfortable with this just being an ROR to pretrial. So while this doesn't necessarily need to be a $20,000 bond that the state requested, I am going to place a $5,000 bond, and if Mr. Paulino does post that, then he will be placed on pretrial supervision with a level 1 GPS monitor. There is also going to be an order of no victim contact as well as a no return order. All right, Mr. Paulino, I need you to understand that if you do post that monetary bond, you're going to be placed on a level 1 GPS monitor. As you heard me say, that means that effectively you will be placed on house arrest. That means that you're not to leave your residence without pretrial's knowledge or approval of that. There is going to be an order of no victim contact as well as a no return order. Since you'll be on house arrest, that no return order should not be an issue for you, but please understand that means that you are not to go to or return to the location at issue in this case. The no victim contact order means not being in the same place at the same time as the alleged victim, but that also means no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand what I've explained to you?
Yes, Your Honor.
All right, thank you, sir. Good luck.
Thank you, Your Honor.
Lorenzo Starling.
Yeah. It's not a separate document. It's part of the second document.
morning, Mr. Starling.
Morning.
All right, Mr. Starling, you're here this morning on 5 charges. Count 1, loitering or prowling. Count 2, possession of burglary tools with intent to use. Count 3, riding a bike at night with improper lights that is not for magistrate. Counts 4 and 5 are felony probation violations which have no bond holds. I find probable cause, and in light of the no bond holds that will have to be addressed by the division judge, I will leave the standard bond in place on count 2. There will also be an order of no return to the location that is at issue in this case. So Mr. Starling, since you have the no bond holds, that means that your division judge will be the one to address that. So that should be done shortly. You can discuss it further with your attorneys after the hearing today. Good luck to you, sir.
Okay.
Yes,
For
sir.
the trespassing, will I get a bond? You said I would get a bond for that?
There is a... You don't have a trespassing charge. You have a loitering or prowling charge, which does not have a bond attached to it. And you have a possession of burglary tools, which has a $1,000 bond attached to it. So right now your bond is $1,000, but you have the no bond holds that the division judge is going to have to address before you're released.
Okay, thank you.
All right, thank you. Okay, now I'm going to, let me go to North Broward and see if they have these last 2 cases before we do our Spanish cases. All right, North Broward, I have 2 cases that you guys requested to be put on the end of the list. On page 12, Nicholas Becker, and on page 20, Derek Sanders. Do you have either of those individuals ready?
On those cases, may we please go sidebar if they're ready?
Okay, oh, I have Brian Nichols is at North Broward as well.
Thank you.
Is there something that you need me to go sidebar on now? To advise
Yes,
you?
while they're pulling them, yes,
All right,
please.
let's
Thank
go
you.
sidebar for 1 moment. All right, do I have my deputy at North Broward? Yeah, I'm going to be doing the Spanish interpreter cases next.
Your Honor, since the public defender hasn't been able to speak to these clients while they're being pulled up, do you want to do the Spanish in the meantime so then I can talk to them
That's
without
fine.
delaying?
That's fine.
Thank
All right.
you.
So I will leave those on recall for a moment.
North Broward. Thank you.
Okay. All right, so my first, let me see what I got here. My first Spanish interpreter case is going to be Jonathan Lopez. So and I believe is he at Maine? Let me get the interpreter on the line.
We have Salad and Gonzalez Torres.
You guys have Salas
And Gonzalez Torres.
Okay, which facility is Mr. Lopez at? Somebody tell me. Jonathan Lopez.
Looks like he's at Conti, Your Honor. It's on page 11.
Conti, do you have Jonathan Lopez on page 11?
Prison approaching, Your Honor.
Thank you, Deputy. All right, let me call.
Okay, because you can't leave this guy from
Good morning, Mr. Hernandez. This is Judge Cawthon. How are you this morning?
I'm fine. Thank you for asking, Judge.
I have 3 cases that I have 4 cases that we need an interpreter on in first appearances, but I think the connection that we have right now is not very good. It seems that you're breaking up. Can you hear me okay?
I can hear you fine.
Okay, you know what? I can hear you better now, so hopefully it stays that way.
Okay.
All right. Would it be helpful for me to give you the names before we get started with them?
Of course, Judge.
Okay. Okay, so the first one that I have is Jonathan Lopez, and that's Lopes.
Okay.
The second is Daniel Salas, and that's Sales.
Got it.
The third one is Eligio, that's Eligio. And the last name is Gonzalez Torres.
Okay.
And then I have one more. Let me just get the name for you. It's on my second look docket. And the last one is going to be Alba Gutierrez.
Got them all.
Okay.
Thank you.
All right, so we will start with Mr. Lopez. I have him present. Let me just swear you in as we're getting started. Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
I do, for the record, Moises Hernandez.
All right, thank you, Mr. Hernandez. Okay, good morning, Mr. Lopez.
Buenos días, señor López.
Mr. Lopez, you're before the court this morning on an ad charge.
¿Se encuentra usted ante el tribunal en la mañana de hoy para un cargo adicional?
This is for an immigration hold.
La razón es una orden de detención de inmigración.
I find probable cause.
Determino que hay causa probable.
And Mr. Lopez, this has a no bond hold, which means that you will go before an immigration judge in order to address this matter.
Y señor López, esto lo que significa es que usted tiene una orden de detención sin derecho a fianza y eso conlleva a que tendrá que aparecer ante un juez de inmigración.
Good luck to you, sir.
Buena suerte, señor.
All right, and let me go to the main jail. Our next gentleman will be Daniel Salas.
Vamos a la cárcel principal. El próximo caballero es el señor Daniel Sales.
All right, good morning, Mr. Salas.
Buenos días, señor Sales.
Can I have the deputy at main turn the speaker on for me, please?
Buenos días.
El alguacil, ¿puede por favor encender el volumen?
Thank you. All right.
Sí.
Okay. Mr. Salas, you're before the court this morning on one charge of touch or strike battery, domestic violence.
Señor Sales, se encuentra usted ante el tribunal en el día de hoy por un cargo de una denuncia de agresión por violencia doméstica.
I find probable cause.
Determino que hay causa probable para proceder.
And at this time, I'm going to hear the parties' recommendations, beginning with the state attorney.
Y en estos momentos comenzaré a escuchar las recomendaciones de las partes, comenzando con la fiscalía.
I'm not showing that the defendant has any priors.
El acusado no tiene antecedentes.
Therefore, the state will be requesting a $500 bond based on the facts of the case.
Por lo tanto, la Fiscalía Estatal solicita una fianza de $500 basado en los hechos de la denuncia.
All right.
Ajá, ¿y ese necesita un abogado no?
¿Cómo fue?
¿Y ese necesita un abogado para meter en eso no? ¿O solo para pagar?
Do I need an attorney to pay that bond?
So, Mr. Salas, I have someone from the public defender's office here in the courtroom.
Señor Sales, aquí tengo a alguien de los defensores públicos, de los abogados de oficio que están en la sala.
And they're here to represent your interests this morning.
Y ellos se encuentran aquí presentes para representar los intereses suyos en la mañana de hoy.
Are you able to afford the $500 bond?
¿Puede usted costear la fianza de $500?
Sí, pero ese se puede ¿Para cuándo se puede pagar eso?
Yes, but where would I have to pay that?
So the deputies at the jail can give you instructions on how you need to do that. Do you have your wallet or any credit cards there in property when you were arrested?
Los alguaciles que se encuentran presentes ahí con usted les darán instrucciones sobre cómo proceder. ¿Tenía usted consigo cuando lo detuvieron la billetera o una tarjeta de crédito?
No.
No.
Okay, so who's going to be posting that bond for you?
Bueno, ¿quién va a pagar la fianza por usted?
Porque solo yo puedo comunicar con mi esposa.
Can you put me through to my wife?
You speak into the microphone so the interpreter can hear you.
So, Your Honor, if I can lay a non-monetary bond argument for the defendant.
Su señoría, si me permite presentar un argumento para imponer una fianza que no conlleve pago de dinero.
Mr. Salas, Judge, is 25 years old, and he's been in South Florida all his life.
El señor Salas lleva 25 años en el tribunal y tiene 25 años en la Florida y tiene 25 años de edad.
He works in roofing, Your Honor.
I'm sorry?
He works in roofing.
Él trabaja de techero.
And he has a place to live with families and friends in Fort Lauderdale that isn't the listed residence.
Y tiene un lugar donde puede vivir con familiares o amistades que no sería la dirección donde se encuentra actualmente.
And Judge, in light of all that, I'd be asking either for an ROR or standard pretrial for him to call.
A la luz de eso, su señoría solicitaría que le permita salir libre de sin fianza bajo las condiciones normativas.
All right, I will release Mr. Salas and place him on standard pretrial supervision.
Bien, lo vamos a colocar bajo supervisión con antelación al juicio.
Mr. Salas, there are a couple of very important things I need you to understand.
Señor Salas, hay un par de cosas que tengo que decirle que son muy importantes.
Number one, since you are going to be on standard pretrial supervision, you will be released today.
Número uno, usted estará bajo supervisión. Judge, I have a phone call from another courtroom.
Okay.
That's okay. Don't worry about it. They hung up.
Okay.
Thank you. I'm sorry.
That's all right.
So I won't respond to them. That's okay. I'm sorry, Judge.
Okay, that's okay. That's okay. Okay. Do you need me just to repeat myself?
No. Usted estará, lo soltarán bajo libertad, pero estará bajo supervisión. Thank you, Judge.
That's okay, not a problem. All right, so Mr. Salas, you will have to report to pretrial supervision within 24 hours of your release.
Señor Salas, usted tendrá que reportarse a las autoridades de probatoria de libertad bajo supervisión dentro de las próximas 24 horas una vez lo suelten.
The piece of paper that the deputy handed you has instructions on where you need to go.
El documento que le acaba de entregar el alguacil tiene las instrucciones sobre el lugar al cual tiene que presentarse.
If you fail to report to pretrial as I have instructed you, a warrant will be issued for your arrest.
Si usted incumpliera con las instrucciones que aparecen y no se presenta, emitiré una orden de arresto en su contra.
Additionally, I need you to know there is going to be an order of no victim contact.
Además, quiero que sepa que habrá una orden en la cual no podrá tener contacto con la víctima.
That means until further order of the court, you are not to be in the same place at the same time as the alleged victim.
Eso lo que significa es que hasta que se disponga lo contrario por el tribunal, usted no podrá estar en el mismo lugar a la misma vez con la persona que fue víctima suya.
That also means no phone calls or text messages to this person.
Eso también significa que no puede hacer llamadas telefónicas, no puede enviar correos electrónicos ni tener contacto con por ningún medio social con la persona.
And no third-party contact or social media contact with this person.
Y tampoco puede tener contacto a través de terceras personas o por los medios sociales.
Do you understand everything I've explained to you?
¿Entiende usted todo lo que le he explicado? Yes.
Un poco, pero para marcar cómo es para venir a pagar mi fianza.
Yes, but I need to know how would I go about paying my bond.
So, Mr. Salas, since I'm putting you on standard pretrial supervision, that means that you will not have to post a monetary bond.
Señor Salas, en vista de que le estoy imponiendo una supervisión con antelación al juicio de forma estándar, eso significa que usted no tendrá que pagar una fianza.
Do you understand now?
¿Entendió ahora?
Sí, entonces, ¿para cuándo puedo salir entonces?
Well then, yes. But then, when can I leave?
The jail will be processing you for release today, and you need to follow the instructions that I have explained to you. So do you understand everything that we've talked about today?
Las autoridades de la cárcel estarán procesando su salida en el día de hoy y usted tiene que seguir todas las instrucciones que yo le impartí y las instrucciones que le puedan impartir ellos. ¿Ha entendido usted?
Sí.
Yes.
All right, good luck to you, sir.
Muy bien, buena suerte, señor.
Gracias.
Thank you.
All right, and our next case will be Eligio Gonzalez Torres.
El próximo caso será el de Eligio González Torres.
All right, good morning, Mr. Gonzalez.
Buenos días, señor González.
Buenos días.
Good morning.
Mr. Gonzalez, you're here this morning on 3 charges.
Señor González, se encuentra usted presente por 3 acusaciones.
Count 1 is a misdemeanor violation of probation.
El primer cargo es un delito menos grave de incumplir con su libertad bajo condicional.
Count 2 is operating without a valid driver's license.
La segunda denuncia es por operar un vehículo de motor sin una licencia válida.
And count 3 is an immigration hold, which has a no bond hold.
Y la tercera denuncia es una orden de detención de las autoridades migratorias que no conlleva fianza.
I find probable cause.
Determino que hay causa probable.
Do the attorneys wish to be heard on anything in light of the no bond hold?
¿Acaso desean los abogados que se les escuche sobre algo debido a la luz de la orden de detención sin fianza?
Not from the defense.
All right.
Nada de parte de la defensa.
Okay. Then I will leave the bonds as they have been set.
Pues muy bien, dejaré las fianzas según se pusieron.
And Mr. Gonzalez, with respect to the immigration hold, which has a no bond hold,
Ahora, señor González, con relación a la orden de detención de las autoridades migratorias que no contempla el pago de una fianza,
you will go before an immigration judge so that you can further address that matter.
usted deberá comparecer ante un juez de inmigración para poder atender ese asunto en su fondo.
Good luck to you, sir.
Buena suerte, señor.
All right, our next case is from the second look docket today, and that is Alba Gutierrez. I understand.
All right, yeah.
All right, okay, and I understand the attorney is going to be appearing via Zoom on this. Okay, so I'm just going to wait for you guys to get that set up. Okay.
Dostani, who will be hearing. And I'm here whenever you're on.
All right. All right. Good morning, Ms. Gutierrez.
Buenos días, señorita Gutiérrez.
Buenos días.
Good morning.
All right, and I have Ms. Dostani is on the line on behalf of the Public Defender's Office.
Y tengo al señor Sani en línea en representación de los abogados de oficio.
I will hear from the parties.
Escucharé de las partes.
Ms. Etienne, I just need you to speak into the mic so everyone can hear.
Yes, Your Honor. On this case, bond was already reduced to ROR with a level 2 monitor.
Yes.
Sí, su señoría. En este caso, se redujo la fianza a una libertad antes del juicio por su propio reconocimiento con un nivel 2.
But BSO has not released her because she does not have an address.
Pero las autoridades del alguacil del condado no la ha liberado porque no tiene una dirección residencial.
Defense has asked to stipulate to pretrial release on all other conditions with her. Sorry, go ahead. Defense has
La
asked.
defensa ha solicitado, I'm sorry.
Go ahead. You can translate.
La defensa ha solicitado que se estipule que se libere con antelación al juicio basado en las denuncias.
With her to follow up with an address.
Y para que ella pueda darle seguimiento al asunto con una dirección.
The state would be objecting as we have spoken with the victim.
Y la Fiscalía Estatal estaría en desacuerdo ya que hemos conversado con la víctima.
The victim is in fear of the defendant, and if the defendant does not have an address.
La víctima le tiene temor al acusado o a la acusada, y si la acusada no tiene una dirección,
the victim is in fear that the defendant will come back to her.
La víctima teme que la acusada volverá a presentarse ante ella.
That is all from the state.
Eso es todo lo que tiene que decir la Fiscalía Estatal.
All right, Ms. Dostani, I will go to you now for your argument.
Yes, Your Honor.
Sí, señor Sani, procederé a escuchar su argumento.
And Ms. Dostani, I'm sorry, I'm just going to ask you to speak up and go slowly since we have the interpreter on the line as well.
Y señor Sani, le voy a pedir que hable en voz alta y lentamente porque tenemos un intérprete.
The terms of her pretrial are no victim contact.
Las condiciones de la liberación es que no tengas contacto con la víctima.
And considering the conditions of the jail and the surrounding circumstances regarding the COVID-19 outbreak, Ms. Gutierrez sitting in custody is not safe for her nor anybody else. We would be requesting, Your Honor, to release her ROR. Since the victim is scared for contact, there should be no victim contact as per pretrial.
I'm sorry, Judge, I couldn't hear everything because it's either distorted or too far from the microphone or...
Okay. Is there any way to turn the volume up on that so that the interpreter is able to hear? Okay, Ms. Dostani, let's try it one more time.
Can you hear me now, Judge?
Okay, are you able to hear her better, Moises?
A little better, Judge. Thank you.
Okay, all right, I'm sorry. Ms. Dostani, could you just repeat some of that so I can see if we're able to get it through for the interpreter?
Yes, Your Honor. Since one of the conditions of pretrial release would be no victim contact, Ms. Gutierrez would not have any contact with the victim, and the victim should be rest assured that there would be no contact. Holding Ms. Gutierrez essentially right now she's being held no bond because she cannot provide an address.
Parte de las condiciones del liberar a la señora Gutiérrez sería que no tenga contacto con la víctima. Y la señora Gutiérrez no va a tener contacto con la víctima antes de que se inicie el procedimiento judicial en su contra. Y ella tendrá la obligación de reportar dónde se está quedando cuando consiga la dirección.
Considering the nature of the circumstances surrounding the COVID-19 outbreak and the conditions inside the jail, this is an extraordinary condition, and holding Ms. Gutierrez in custody further not only is detrimental to her health, but others around her.
Y tomando en cuenta o en consideración las condiciones del coronavirus en la cárcel y las circunstancias que se están dando, el mantener a la señora Gutiérrez detenida en la celda la expone a ella a una situación dañina y también la expone a los demás que están alrededor de ella.
And if I apologize, Your Honor, at this time, the offer for Ms. Gutierrez does not include any additional Broward County jail time. She would be placed on standard probation, and she would have no victim contact. So keeping her in custody essentially is serving more time than even the plea offer requires.
Y de hecho, su señoría, ante la naturaleza del delito, el mantener a la señora Gutiérrez más tiempo detenida en la cárcel significaría que estaría cumpliendo un tiempo mayor a lo que dispone la pena. Go ahead.
Anything further, Ms. Dasani?
No, Your Honor, that should be all at this time.
Your Honor, if the state
Algo más, su señoría, no, su señoría.
All right, I'll hear the state's response.
Your Honor, the reason the defendant was placed on a level 2 GPS is due to the fact that the victim herself.
La razón por la cual a la acusada se le impuso un nivel 2 de seguridad con el equipo GPS es que la víctima, go ahead.
The victim believed herself that if she was home alone, that the defendant would have killed her. And at the time, sorry, go ahead.
La víctima entiende que si ella hubiera estado sola en la vivienda, que la acusada la hubiera matado. Go ahead.
And Judge McHugh stated that if the defendant was not able to provide an address as far as for her level 2 GPS, then she would be held in jail.
Y la juez McHugh dijo que si la acusada no pudiera conseguir una dirección para que le pusieran el monitor GPS del nivel 2, pues entonces tendría que quedarse detenida.
All right, a couple of things.
Muy bien, hay un par de cosas.
Number one, while I understand and we're all aware of the present circumstances involving the pandemic.
Número uno, mientras que yo soy consciente y todos tenemos presente la situación actual con relación a la pandemia,
This court still has a duty to address and maintain the community and alleged victims' safety and any risks to their safety.
Este tribunal, aún así, tiene la obligación de tener presente y atender y sostener cualquier medida de seguridad a favor de la víctima.
Based on the allegations and the circumstances of this case, I do not... Go ahead.
Go ahead, Judge. Go ahead. Go ahead.
Based on the allegations and circumstances of this case, I do not believe that that citing coronavirus outweighs the safety risks that may be posed to the community in this case.
Basado en las alegaciones y en las circunstancias actuales, no es de mi parecer que la situación con el coronavirus tenga un mayor peso que las consideraciones de seguridad a favor de la víctima.
Furthermore, Judge McHugh has ruled on this issue as recently as March 16th.
Más aún, la juez McHugh emitió su determinación tan recientemente como el 16 de marzo.
Since that was only 2 weeks ago, I'm sure she herself was aware of any risks or concerns involving the pandemic.
En vista de que eso fue a duras penas 2 semanas atrás, ella misma tiene que haber tenido conocimiento y haber tomado en cuenta los riesgos y las inquietudes al respecto.
Since there have been no material changes to the circumstances or information provided in the last 2 weeks,
En vista de que no ha habido cambios dentro de las circunstancias ni en la información que se tenía disponible en las últimas 2 semanas,
this court is respectfully going to deny the defense's request and leave Judge McHugh's ruling in place at this time.
este tribunal denegará respetuosamente la solicitud de la defensa y dejará en efecto y en vigor la orden de la juez McHugh.
To be clear, if Ms. Gutierrez is able to provide pretrial with an address different than that of the alleged victim, she will be released.
Para que tengamos claro este asunto, si la señora Gutiérrez tiene la forma de brindarle a los servicios con antelación al juicio una dirección que no sea la misma dirección que la de la víctima, entonces podrá salir.
Thank you, Ms. Gutierrez, and good luck to you, ma'am.
Your Honor, if we
Muchas
have Ms.
gracias, señora
Gutierrez
Gutiérrez,
and
y
the interpreter, is
y
there
buen
any
día a
way you can
ustedes.
convey the offer to Ms. Gutierrez because she does not speak English?
I can allow the interpreter to convey the plea offer, but I will not be taking a plea today.
That's totally understandable, Judge, just so she knows that there's a plea offer on the table because her case was unfiled up until last week.
All right. Ms. Gutierrez, I'm being told that the state has a plea offer that your attorney would like for you to consider.
Señora Gutiérrez, su abogada me indica que la fiscalía le ha hecho una oferta para resolver su situación actual y su abogada quiere que usted esté enterada de la misma.
I'm going to allow the state attorney to convey that to you so that you are aware of it, but understand. Go ahead.
I'm sorry, Judge. Go ahead.
Okay, but understand that I will not be taking a plea today. This is just for you to understand so that you can discuss it with your attorney in the future.
Voy a permitir que la Fiscalía Estatal le informe la naturaleza de la oferta que le hacen, pero debe tener usted presente que yo no estaré considerando ninguna oferta en estos momentos, solamente dejo que le comuniquen la naturaleza de la oferta para que usted pueda discutir la misma con su abogada en los próximos días.
Ms. Etienne, are you able to convey that offer at this time?
Yes, I am. The plea offer is a withhold of conviction.
La oferta que hace la Fiscalía es una suspensión de la condena en el... Sí, go ahead.
12 months probation, 29 weeks batter's intervention course or program.
12 meses de libertad condicional o probatoria y un curso de 29 semanas para los agresores.
Mental health evaluation with follow-up and no victim contact.
Una evaluación sobre la condición de salud mental con seguimiento y no tener contacto con la víctima.
And that's all.
All right.
I'm sorry?
She said
That's
that was
all.
it.
Y eso es todo.
All right. Ms. Gutierrez, were you able to hear all of that?
Señora Gutiérrez, ¿logró usted escuchar todo?
Sí.
Yes.
All right. Ms. Dosani, anything further?
No, Your Honor, that should be all. Thank you.
Okay.
Ms. Dosani, this is Jen, actually. Does she have your phone number so you guys can discuss the plea offer?
I believe so, but if I could give her my number once again.
Okay, Deputy, do you have a piece of paper that she can write her attorney's telephone number down on?
Yes, I can. Hold on.
Okay, just give me 1 moment.
Go ahead, Your Honor.
Okay, all right, Ms. Dasani, go ahead, please.
It's 954.
954
What were the next three?
831
831
86
86
86, what were the last two?
32.
Okay,
32.
all right, so Ms. Gutierrez, that is a telephone number for Ms. Dasani, your attorney. You can call her when you have the opportunity to discuss the plea offer.
Bien, señora Gutiérrez, ese número telefónico es el de su abogada, la licenciada Sani, y usted se podrá comunicar con ella para hablar y conversar sobre la oferta que le hace la fiscalía.
Okay, what was that, Deputy?
Can she call her now? I can give her one quick phone call.
Ms. Dasani, you want her to go ahead and call you now?
Yes, Your Honor.
Okay, all right, thank you, Deputy, I appreciate that. She can go ahead and call her.
No problem, Your Honor.
Usted tendrá que llamarla.
And Judge, if she does choose to resolve the case, can we reset it to this afternoon so that she will, it sounds like it's a non-jail
You'll have to
offer.
take that up with Judge Siegel. He's the one in charge of the afternoon docket.
Okay,
Don't set it without his permission.
of course, Judge. I'll discuss it. I'll be here this afternoon.
All right,
We can discuss it then.
before I let Mr. Hernandez go, do we have any other cases that require a Spanish interpreter? All right, Mr. Hernandez, I appreciate all of your help this morning. We all appreciate you.
Thank you very much,
All right, thank you. Have a good
Same here.
afternoon.
Good to be at service.
Thank you. All right, before I proceed with our hearing docket, let me go to North Broward. We had a couple of cases left on our first appearance docket. All right, hi, Deputy.
Hey,
Okay, so I have 3 of them for you guys. Tell me who you have. I've got Brian Nichols, Derek Sanders, and Nicholas Becker.
I got Mr. Gordon here.
He might be on my hearing docket. I need to address these other 3 first, though. Do you have any of
I
them?
bel let me check my list right quick.
Okay, thank you.
Your Honor, because of the transportation issue, I wasn't able to speak to them, so.
Okay.
Your Honor,
Yes.
Mr. Heckles, Mr. Jackson, and Ms. Becker.
Yes.
Those are all 3 possible COVID-19s.
Okay.
Right now, Open Dorm is being cleaned out,
Okay.
and it's another 30 minutes until it's back open again.
Okay, so then why don't I guess we'll go ahead and do the hearing docket, and then we'll come back to those 3.
Thank you.
Okay.
Okay, all right,
No
thanks,
problem.
Deputy.
Can you give us 2 minutes just to switch over?
Yep, go ahead, go ahead.
May address a couple issues.
Go
with you
ahead, I'm
before
just
we-
gonna have you, if you're putting them on the record, just speak into the mic, because it's very hard.
This is Chief Assistant Public Defender Jennifer Edgley. The first question, Judge, for these bond hearings, just for purposes of having a evidence on the record, would the court accept our proffer of ties to the community and other relevant facts
Yes.
to the court's determination? Thank you, Judge. The other issue, we have reached negotiated resolutions on some of these cases with the state
Okay.
that will involve our clients being released from jail today. So we would ask that we address those cases and have those pleas taken today so that we can have them released.
As long as the state is in agreement with that, that's fine.
Thank you, Judge.
Okay. Yes?
Yeah.
Yes. Come on up. Yep, come on up.
This is on 2710 CF10A.
Oh, this is the one.
Schwarzreich and I spoke this morning. These are the conditions we agreed to.
Yes, okay.
For the record, I've already provided Ms. Hardy with the victim's contact number, and I've spoken to him multiple times. He's aware, so you know he is aware
Okay.
of the disagreement.
Okay.
They should have no problem verifying his address.
Okay, great.
Mr. Schwarzreich gave me the defendant's, he'll be residing with his mother. Gave me the defendant's mother's name, her address, and phone number, so they should have no problem verifying.
Okay. All right. All right, thank you. Thank you for being able to work that out with Mr. Schwarzreich. Okay. All right, I'll give that to you. Thank you. Okay, so we're gonna go on a very brief recess so that I can allow the attorneys and clerks to get all of their orders, their things in order, so we can proceed with the hearing docket. So I'm gonna go off the record for a moment, and we'll be back on camera in a few minutes. All right, we are back on and ready to proceed with our hearing docket. Those three cases that I have left on first appearances we'll do at the end when North Broward is ready. As far as the hearing docket goes for this afternoon, I'm going to start with our felony cases, and then we'll go to the misdemeanor docket afterward. So the first on my list on the felony docket will be Andrew Sanra.
Your Honor,
Yes.
North Broward,
Yes?
the open dorm is back up. We're gonna go and call those guys over for you.
Okay, great. Thank you so much. I appreciate
All
it.
right. You're welcome.
Thank you. All right, so which facility do we have Andrew Senra at? Thank you.
Morning, Your Honor, Conti facility.
Thank you, Deputy. All right, good morning, Mr. Senra.
Good morning.
All right, Mr. Senra is here on a 30-day motion. Mr. Linder?
I'm sorry, your state has not filed an information. He's entitled to release of this
All
charge.
right, is there anything else holding Mr. Senra?
That I don't.
Let me just check with confinement. All right, Mr. Senra, on the case that's in front of me today, it's a petty theft case. The state has not yet formally filed this charge, which means that you are entitled to an ROR. That means that you're going to be released today. I just need to inform you that just because it hasn't been filed today doesn't necessarily mean that's the end of the case. So it's going to be your responsibility to be in contact with your attorneys in the clerk's office so that you know if there are any future court dates you have to be present for. Do you understand that?
Yes. Yes, ma'am.
All right. Thank you very much. Good luck to you, sir.
Thank you.
All right. Next will be Jabari Days. Good morning, Mr. Days.
Good morning.
All right, Mr. Days is also here on a 30-day motion. State, have the charges been filed?
Yes, Your Honor, as presented, and it is reflected in that.
Okay. All right, Mr. Days, since the state has filed these charges against you, that means that your next step will be to go before your division judge for an arraignment hearing, and you'll be able to get notice of that date and discuss it with your attorneys after today. All right? Good luck to you, sir. Lorenzo Jones. All right, good morning, Mr. Jones.
Good morning, Your Honor.
All right, is Mr. Jones here on a second look? Yes, okay, I see the bond is $3,000 right now. All right, and I'll hear from the defense on this.
Filed by our office, it looks like he's not able to afford the $3,000 bond, Judge, so I'd be asking the court to maybe consider a non-monetary condition such as pretrial.
I'm looking up his history, and if counsel wants to question right now, I mean, we don't know anything about ties to the community, work.
Counsel, have you spoken with Mr. Jones?
Judge, I haven't, unfortunately.
Okay, you want a few minutes to speak to him?
Yes, please.
All right, Mr. Jones, the public defender here in the courtroom is going to call you on the phone there at the jail facility so that he can speak to you privately, and then I'll bring you back up.
Yes, ma'am.
All right.
Thank you.
You're welcome. All right, our next case is Kelvin Clark. Do we know where Mr. Clark is? All right, thank you. Okay, good morning, Mr. Clark.
Good morning, Your Honor.
All right, Mr. Clark is here on a second look hearing as well. His bond is presently set at $3,000. All right. Have we had an opportunity to speak to him?
No, Your Honor. I'm trying to call the jails, but it's not going through.
Okay. We probably should have done that when we were on our break. All right, Mr. Clark, I'm going to put your case on a brief recall so that the attorney can call you and speak to you privately, and then I'll bring you back up, okay?
Yes, Your Honor.
All right, thank you. Okay. Are we ready to proceed on Mr. Swain's case? All right, good afternoon, Mr. Swain, or good morning.
Good morning, ma'am.
Still morning?
Good afternoon. How are you?
All right, I'm well, thank you. All right, Mr. Swain is here on a second look. Count 1, is set at $750 and count 2 is $500. Okay. All right. Mr. Linder, let me go to you first on Mr. Swain's case. I know he was with us a few days ago. I don't remember his prior history. Okay.
Your Honor,
Yes.
I can tell you he just had 6 counts of felony theft dropped 9 days ago because there appears to be continuing miscommunication between the case filer and the arresting officer.
Okay.
He had criminal mischief from last year that was pled out February 13th. A theft from last year that was pled out January 15th of this year. He's got
Currently out of work right now because we've been shut down. What were you doing before that? Working at the W Hotel. What were you doing there? Dishwasher.
Okay.
Where can you live? Excuse me? Where can you live? I live with my sister. Where's that at?
Your Honor, and I don't know if a violation of probation warrant's going to be coming down the pike, but he is on probation till January 15th, 2021, before Judge Malika for indecent exposure.
Okay.
I'm not sure if you're going to talk to
Felony theft 2019, felony theft 2018, criminal mischief 2018, felony theft 2017, grand theft 2017, felony theft 2017, 2 counts of felony theft 2016, grand theft 2015, grand theft, petty theft, grand theft, robbery, felony battery.
Okay. All right. What was the most recent arrest? I know he was released recently. When was the arrest?
The most recent arrest was January 31st. That was on all the petty thefts that he was ROR on, no info, and a capias on the criminal mischief case that was resolved.
Okay. All right. Mr. Swain, do you have a permanent address?
Yes, ma'am, I do.
And who do you live with at that address?
My mom and dad,
All right. How long have you lived there with them?
all my life.
Just so you know, he's been on pretrial, once a year for the last 3 years, and he's back in
Okay.
You need the address, ma'am?
Not right now, Mr. Swain. Not right now. Thank you.
Okay, you're welcome.
When was the most recent time he was on pretrial? All right, in light of all the information that's been provided by pretrial, the pending allegations, and the prior history for today's purposes, I'm going to deny the request and leave the bonds in place as they were set a few days ago.
Ma'am, we can't put me on pretrial release 1?
All right, Mr. Swain, I can't do that today, but if you need to address it further with your attorneys, then you can talk to them about it, and they'll file whatever's necessary, all right? Good luck to you.
I don't see what the problem is with pretrial release, though.
Okay, well, Mr. Swain, I do see a problem with it, okay?
Could you tell me what it is, ma'am?
The problem is that you've been on pretrial supervision 3 times, and you violated every single time, including the last time when you were on a GPS monitor. You're on probation right now, which you're in violation of, and though I don't have a signed warrant from Judge Malika yet, there is a possibility that that could be coming down the line. You were released from custody just over a week before this new arrest came up. And so based on all that information, I'm going to leave the bonds as I set them a few days ago. All right? Good luck to you, sir.
You gotta understand, Judge.
Mr. Swain,
with
that's
this,
gonna be it, sir. I'm sorry,
this
that's it for
corona-
today. All right. Okay, so I'm just waiting on our last two, I had, on the second look docket, I had a, Rodriguez Aparicio. Did we already address his case?
Yes, yeah, he is, he's on the misdemeanor docket.
Oh, okay, okay, that's fine, all right.
Rodriguez Aparicio has been released.
Has been released, okay. Is he bonded? Rodriguez Aparicio, they said that he was released. All right, are we ready to go on the other two?
There's three. He's also present in Maine.
Okay. All right, so Mr. Clark is here on a second look. As I said before, his bond is currently set at $3,000, so.
Judge, so he was working as a dishwasher at the W Hotel. Unfortunately, he was laid off due to the pandemic. Right now, he doesn't have any monetary support. He can live with his sister in Fort Lauderdale. Your Honor, he's 20 years old. He's been in South Florida for the last 20 years in his entire life. And from what I can look online, Judge, I don't see any priors.
Okay. Let's go to the state.
It's first in my JAS system. I'll put in Mr. Cooks. I just want to check to see if Mr. Jones has anything, so when we get to his case, I can go right ahead. What?
Judge,
Yes, Mr. Clark.
there's
Oh,
no
North
problem.
Broward. Yes.
The 3 inmates on their way.
Okay, great. Thank you, Deputy. I appreciate it.
You're welcome.
Your Honor, with respect to Mr. Clark, I would have no objection to pretrial release supervision.
Okay, all right. So then, Mr. Clark, in light of that information, I'm going to release you to, is that standard pretrial, you're not objecting?
Yeah, I'm not asking for it.
All right, I'm going to release you and place you on standard pretrial supervision. It's very important that you understand, Mr. Clark, that though you're going to be released today, you must report to pretrial supervision in person by tomorrow. The deputy will give you a piece of paper with instructions on where you need to go. It's very important that you understand that if you do not go there and report as I'm instructing you, a warrant will be issued for your arrest. Do you understand that?
Yes, Your Honor.
Okay, all right, Mr. Clark, good luck to you, sir. Okay. And are we ready to go back to Mr. Jones's case?
Wasn't able to get a hold of them, Judge. It
You
looks
were
like
not?
those magistrates keep going on. So every time I call, it just hangs up.
Where is he at, Conti?
Yes, Judge.
Okay. Conti, are you able to call, are they able to call you here?
They should be able to.
Okay, just hang up your phone for a second. Deputy at Conti, can you call the public defender here in the courtroom? He's not able to call to you for some reason.
Yes, no problem.
Thank you.
You're welcome.
All right, I'll give him a moment to do that so that we can just get that case done. Yes. They're gonna call you.
Your Honor,
Yes, deputy.
with Mr. Jones, who's currently in custody on the phone with an attorney.
None of the attorneys in the courtroom are on the phone.
It's possible that it's a Judge McHugh hearing. She is having some of our clients call in from the
Is there a
jail. So it's possible
crossover?
that's what's
Okay. Okay, so are we able to,
That's the only other hearing I'm aware of.
Your Honor, I don't think that would be Mr. Jones's case, because his BCCN number shows he has no other Broward offenses.
The only hearing that I know that's going on
unless
in the
he hired a
courthouse as
private
well.
attorney in the past 10 minutes. I mean.
okay. Is deputy, he's on the phone right now speaking to someone?
Yes, Your Honor.
Could you ask him who the attorney is that he's speaking to? We'll get there, guys.
Hey, Mr. Jones.
For the record, and also for the record, we're being requested like this sophomore, but to find out what the name of the person is, so we have that. Magdala?
Your Honor, Magdala Jean Bruce.
Magdala Jean Bruce?
She is our attorney in domestic violence.
Okay, so he must be on the phone with her for maybe a different hearing?
He's not on our docket, and I don't believe he has a DV case. So let me text her and find out what's going on.
Okay, so you know what, I'll just, well, I don't know, do you guys want me to move on to the misdemeanor docket, or you want to get that straightened out first? It's an issue with...
You just start on the misdemeanor docket.
Let's do misdemeanor docket, Judge.
All right, so Deputy, I'm not sure what's going on with it. I'm going to let the attorneys here work it out, and I'll come back to him when they're ready, okay?
Yes, Judge.
Thank you. All right, so let's go over to the misdemeanor docket while we're waiting on those last few felony cases.
Case that I can call is Tavari Igus. That's on page 7 of Your Honor's docket. It's attorney Kim Siegel, and Mr. Igus is at Conti.
All right. Conti, can I have Tavari Igus, please?
Approaching.
Thank you.
Good morning.
Good morning, Mr. Igus. All right, and do I have Miss Siegel on the line? There's no sound.
There she goes.
Okay, there we go. All right, Ms. Siegel. Okay. Okay, so I have Mr. Igus here. We've got him on the hearing docket, and I see that his bond has recently been reduced to $1,500. Is that correct?
Yes, that's correct, Your Honor.
Okay. All right, so Ms. Siegel, let me hear from you first, and then I'll go to the state if they want to tell me anything additional.
Yes, Your Honor. I actually had been on this conference call for a while now, so I heard in response to one of my colleagues stating that there was no major changes since Judge McHugh had looked at the case from March 16th in her case.
Okay.
In my case, Judge McHugh, he was in front of a magistrate on March 25th.
Okay.
Before I'm told that nothing has changed, there's been no major changes since his bond was reduced last time. I just want to inform the court, as you know, Your Honor, just yesterday, we had the administration in this country saying anywhere from 100,000 to 240,000 people can die of this virus. Just not even an hour ago, we just learned for the first time, and I know all our ears started to perk up when a deputy went on this live feed and said there's 3 suspected cases of COVID viruses. Judge, we have people in on misdemeanors. I know what the state is gonna argue in Mr. Igus's case, and I'm gonna come back to that. But right now, this man is charged with and has a bond in this case. It is $1,500.
Okay.
If he had money, if he had a private attorney, he would have been out already. The only thing holding him in is that he does not have the finances to pay the bond. Your Honor, we're asking you in this case and all misdemeanor cases, these could be death sentences for people in these jails. It's a petri dish.
Okay,
You
Ms.
have to
Siegel,
let
Ms.
them
Siegel,
out and
let me
give them a
just
chance.
let me
They're
just stop you for a
innocent
second.
unless
Hang on.
proven guilty.
Hang on.
I talk to these people
Okay,
every
Ms.
day, and I
Siegel,
feel
please,
powerless
one
to
moment.
get them
I need
out
you
of
to
jail.
stop, Ms. Siegel.
We're
Does
asking
she
for
not
an
hear me?
ROR on this case and everyone
Is
in
she not
other
able to
cases
hear me?
that
I think she
doesn't
can't
have
hear
a felony attached to it.
Hey, Pam,
Yes.
can you hear the judge?
No, I can't, Your Honor.
Okay, I'm not sure.
Okay, I'm not sure why that is.
Can you turn up the volume a little bit, Pam? The judge.
Go ahead.
Okay, are you able to hear me?
I hear very low, but yes, I can, Your Honor.
Okay, I'll try to speak up a little bit for you, okay? So, Ms. Siegel, I understand everything that you're saying to me here, okay? And I'm not going to make any blanket statements with respect to these cases. In the case that I heard previously that you're referring to, there were some exceptional circumstances, and there was a reason that Judge McHugh had a specific condition of release on there. I do see in Mr. Igus's case, it looks like he only has a monetary bond set, and I understand that, okay? I'm aware of these situations. We're doing this on a case-by-case basis. So I assume he has not been able to afford the $1,500 bond, so do you have an alternate recommendation in his case?
Yes, Your Honor. I actually had been on the phone with his mother who works at Wawa, his sister. They've been trying to get money together to pay it. They just can't. I'm gonna ask you to please put him on standard pretrial release. If you feel more comfortable, because it's a domestic violence case, we're gonna call in more often. He will have no problem doing that. I had a long talk with him about no victim contact. I'm gonna cut this off before it starts. My understanding from the state is that the victim is claiming he has called her from the jail. I talked to my client about that. My client has no money on the phone. I can make that argument later once the state brings up what they're gonna bring up. The victim has a lengthy history that's not that credible. My client knows to stay away, so please give him standard pretrial release so he can get out today.
All right, okay, so now let me go to the state and I'll hear their response.
Yes, Your Honor, the state has spoken with the victim, and she has stated that she is in fear of the defendant. Before the incident, he threatened to kill her, sent text messages saying, "You're gonna die." And Your Honor, as far as the facts of the case in itself, the defendant stomped and kicked the victim on her head as she was on the ground. The victim sustained several injuries, including bloodied out lips, a contusion under the right eye, and complained of pain in the back of her head. So we feel that the monetary bond is more than sufficient and do not agree to the defendant being released pretrial.
All right, and what are, does Mr. Igus have any prior history that I need to be
Yes.
aware of?
He does.
Okay.
He has a 2019 unlawful use of name adjudication, 2018 burglary of a dwelling occupied, adjudicated. 2017 felony battery, prior conviction, adjudicated. A 2016 attempted murder, first degree, was acquitted by trial. A 2016 battery violation of pretrial, adjudicated. A 2016 battery, adjudicated. A 2014 aggravated battery on a pregnant woman was dismissed. 2013 possession of marijuana, withhold of conviction. 2011 resisting without violence, was acquitted. And a 1993 grand theft and burglary of a dwelling, adjudicated.
Okay. All right. Okay. So Ms. Siegel, you're in speaking with the family. They're not able to post any monetary bond at all.
No, his mom works at Wawa, is my understanding, and they just don't have the finances right now, especially with the lack of work.
Does he live with his mother?
No, at this point, he doesn't. He may be able to go with a sister or a friend, but his mother also is having she's having financial problems enough so that she doesn't have a permanent roof over her head. She's been staying with other people.
Okay. Well, I may be willing to entertain a non-monetary release, but based on the information that the state has provided to me, I would be more comfortable placing him on a GPS monitor. Is that something that you've discussed with him?
Your Honor, he is not gonna know where he's staying until he gets out based on this virus with a lot of people. Your Honor, another thing, this case isn't filed. You know, I have many clients who are willing to just plead this stuff so they can get out, because the offer usually in these cases is the legislated, standard 12 months probation. They're willing to take pleas on things that they can fight just to get out of jail. But unfortunately, the cases still aren't, they're not being, they're filed within the statutory time period, but they're not rushing to file them. So he can't even plead to get out. Perhaps a special condition of a I don't know if you want a mental health evaluation, you want a substance abuse.
Well, his mental health and his substance abuse are not what I'm concerned about.
Your Honor, may I just bring a couple other pieces of information to the court's attention, since counsel has argued that you should have confidence that he will respect any no contact order. One, the 2016 case you revised of the violation of pretrial release conditions, that was a no contact order. And also in civil court, in family court, 3 different women between 2012 and 2017 have sought injunctions, orders of protection against Mr. Igas.
Perhaps there's a mental health component. Perhaps maybe we should send him to Henderson as part of the special condition of a pretrial release to standard, so he can get help if that's the case.
Excuse me, Judge. Could I say something about the 16 case?
Mr. Igas, hold on. Okay, I've got your attorney, Ms. Siegel, is on the line. She's speaking on your behalf. So just let her do her job. I don't want you to say anything that might be harmful to your case right now, okay? So just listen, because we're only talking about bond and release conditions, okay?
Okay.
Okay, all right. Has he been on pretrial? I think that Mr. Linder referenced that he was on pretrial in 2016.
It wasn't he was charged with the violation of the release condition of the no contact.
Oh, okay. Okay, so let me ask pretrial supervision, has he ever been on pretrial? That's okay. In 2018? Was it just standard pretrial? All right. You never returned the GPS to pretrial last time? Okay. All right. Well, Ms. Siegel, you've told me that he's got family in the area. He's got a sister. He's got a mom. If he went out without a monetary bond, I'm going to put him on a GPS monitor. If he's got family in the area and a support system, then that shouldn't be a problem for him. So I'll give you the option. He's either got the monetary bond or he's going to get a GPS level 2. So what? So what would you like to do? I'm giving you the
I'm
option.
sorry, I would like a chance to talk to him, but I'll go back to the point, if he had money, he'd be out already.
And I'm giving
In
him an
spite of
option that
everything
doesn't
we've heard
involve
about
money.
him, it's a monetary problem, and it's the only reason he's in custody. There has been no conditions other than this money, and if he had money and he had a private attorney, he'd probably not be having this conversation right now, Your Honor.
Okay,
I will
and I've
talk to my
addressed that.
client, I will see what he would like to do. If you'll give me a second, I'll call him offline, please.
Okay, go ahead. All right, Mr. Igas, she's gonna call you on the phone privately at the jail so you can speak, and then I'll bring you back up.
Okay.
All right.
And Judge, just for the sake of efficiency,
Yes.
we are going to be adopting the arguments that Ms. Siegel made in reference to COVID. I would also supplement the record just with statistics that I know from the New York City jails, that the rate of transmission of COVID in the New York City jails has been 87 times higher than the national rate of transmission. And so our goal here is to get our clients out because these are extraordinary times. Other than that, we will continue with our hearing. If I may call James, actually, I'm gonna call Wilner Augusti, and
Okay.
that's on page 2 of Your Honor's docket with Attorney Dion McFarlane. Douglas?
I'm sorry, what page is he on?
This is page 2.
Page 2, Wilner Augusta.
And actually, I see, for some reason, Miss Douglas.
Hi, may I speak
Oh, there
to,
she is.
Is this
Hold on,
Mr.
we need to
Igas?
turn
Hey,
Ms.
Kim,
Siegel's.
mute your line, Kim.
All right. Okay.
She got it.
All right, and I have Mr. Augusti here. Okay. All right. And I have Miss. All right. Good afternoon, Miss Douglas. And I have Mr. Augusti here. Mr. Augusti,
Yeah.
I have your attorney, Miss Douglas, is on the line here with me. So I'm gonna
Okay.
hear from her first. So I'm just gonna ask you just to listen for a few minutes, okay?
Okay.
All right.
Okay, so, Mr. August is here on a violation of probation, no bond hold. We're requesting that he be released on his own recognizance, Your Honor. Based on the information that we're looking at, this violation, he hasn't picked up any new charges in Broward since 2016 when he had this case. The violation was essentially for failing to submit his monthly report, cost of supervision, and failure to appear to his appointment. There was a competency evaluation that was done, and we were supposed to go back to court to discuss that. In this case, Mr. August, he's a 50-year-old, 20-year resident of Florida. He's been here for a long time. He lives with his wife and 6 kids in North Miami Beach. Mr. August seemed to have had some issues with recalling certain situations because of medical issues, has seizures and so on. So I think that might be directly related to this whole probation issue. He went on probation in April of 2019, and the violation came about in September. So up to that point, he was in compliance. Like I said, I don't believe he's a threat to anyone at this time, and we're just asking that he be released on his own recognizance. I've asked also, we've been in negotiations with the state with regard to what they're looking for from him, and we're still in negotiations, but part of it is that he was, we haven't been able to really get it done because, of course, probation is not available at the same time that the state is available to discuss the plea agreement.
Okay, so now I'll go to the state for a response.
Your Honor, my concern is, and I believe the reason Judge Mollick could probably put the warrant in no bond is, what confidence do we have of his future appearance? He just stopped reporting to probation. The warrant was signed by Judge Mollick in mid-November 2019. Law enforcement wasn't able to serve it on him until the end of February of this year. There has been a competency evaluation filed, so that is an additional concern, that if there are some other issues, what assurances are there that he's going to willingly come back to court? I can tell you this case, this DUI, the underlying DUI, involved an enhanced breath. There was an injury, and it was a crash. There was property damage and an injury.
Does he have priors?
I'd have to check, Your Honor. Yeah, and I'm just looking over the notes from his last hearing when it was argued to Judge Malika that he has seizures and that might be why he didn't show up. Judge Malika, from what I see here, was not motivated by that, found that he was advised in person by probation to appear for his appointment. One moment.
I've spoken with Judge Malika. I know her position.
I'm checking here, see if there's a...
And if I may, while they're looking into that, Your Honor, at the hearing, Judge Monica did not make a ruling at the time because Mr. August was not available for probation as well as the state to let him know what they were looking for. Probation was willing to reinstate him, and extend the probation so he could finish up. And the state wanted him to do 60 days and SAP. Since then, I've discussed with the state, they're willing to take off SAP off the board. However, we're still looking at 60 days. He's already been in for 30 days. However, we don't think it's gonna serve anybody any good purpose to have him sitting in jail for another 30 days on a situation like this. Like I said, it's a failure to appear, to submit written reports.
It's a failure to appear 3 times to 3 separate probation appointments.
Violation.
I've read the warrant that was signed by Judge Malika. He did not appear at his probation appointments for over 3 months. It's not an issue of written reports only.
I'm not hearing.
The issue is not just that he failed to submit written reports, he failed to report to probation completely for over 3 months.
Correct, Your Honor. And Mr. August, when we were in court, when we were able to be in court in person, he had said that he wasn't remembering about the certain things. He had an interpreter at the time. I've actually spoken to him. I don't speak Creole, but my understanding is he said that he would be willing to do what he needed to do in terms of coming in and finish up whatever he had to do as far as complying with whatever terms. Obviously, he's unable to do. I don't know if SAP is still being offered.
Yes, it is.
But in jail at this time. But Mr. August, like I said, he's not somebody who just goes out and commits crime. So we're just asking the court to give him a chance to, come in and get this fixed, because it's pretty much at this point a matter of, just figuring out if the court would be willing to terminate his probation and allow him time served. His probation was supposed to end in January 20th of this year. So he would be off probation had he not had whatever issues came up where he didn't appear.
Well, maybe if he had complied with probation, then he would have been off of it.
Ms. Douglas, may I just, this is Assistant Public Defender Jen Edgley. Listen, did you say competency is pending on this case, Ms. Douglas?
If you could say that again?
There's competency proceedings pending?
The evaluation came back, it said that he is competent. The doctor, however, did mention the issues of seizures and medications that he needed to be on. So he didn't do a neurological evaluation or anything like that, so we don't know if that might be related to any kind of memory problems.
Ms. Douglas, do you have any competency concerns at this time?
Who's next?
Ms. Douglas?
Hello?
Do you have competency concerns?
We had competency concerns at the time. We thought perhaps it might have been a language communication issue when we were in court when he was arrested initially. However, when the interpreter came, the judge and I still had the concern that he wasn't understanding, based on what he said, why he was in court, why he was arrested. And so the judge ordered I asked for, and the judge ordered the competency evaluation.
Does he need
But
an
the-
interpreter?
Go ahead.
Dion, does he need an interpreter?
He says that he understands, the conversations we've had since then. We seem to have communicated quite okay. Obviously, he does not necessarily want to go back to probation is what we discussed. Especially considering that he's already been sitting in jail for, 30 days already, and the state was off, and I believe the state's off of 60 days. But, like I said, he would have been off probation, and, we would have asked the court to just revoke and allow him and terminate probation had we, with the 30 days that he'd already served before he could get back into court when we were last scheduled at the end of this month.
All right, let me go to Mr. Linder. Were you able to check for priors?
Yeah, I'm having an issue with the system. I can tell you I pulled his driving record.
Yes.
I've not seen anything of concern since this DUI, Your Honor.
Ms. Douglas, does he have a residence that he's going to be staying at if he's released?
He lives at 16931 Northeast 5th Avenue, North Miami Beach.
Does anyone else reside there with him? Not sure if that-
I didn't hear that.
Does anyone else reside at that address with him?
Dion, who does he live with at that address?
Oh, he lives with his wife and kids. He says he has 6 kids, and his wife, they've been living there as a family.
And Judge, based on what Ms. Douglas has said, he's done, it sounds like 60 days in jail on this case. We would ask that the court would just ROR him and allow him to deal with this violation of probation after this crisis is over. He does have a family, he has ties to the community. He served a considerable amount of time on this charge, and so we'd ask for an ROR.
It's 30 days, just for the record, not 60 days. His arrest date was February 29th.
29.
I must have misunderstood. I thought she meant he had 30 days before on the substantive. I do apologize.
That's okay. All right, anything further from the state?
No, Judge.
Mr. August ever been on pretrial supervision? Yes, it is. Mm-hmm. All right, I understand that he hasn't had any new violations since the 2016 charge, which the state has confirmed. My concerns right now are, I understand that the expert, according to what Ms. Douglas has said, has determined that Mr. August is competent. I know that the hearing hasn't actually gone forward with Judge Malika yet to discuss that issue, but the information that's been provided by Ms. Douglas as far as the history of this case and the fact that he wasn't reporting to probation is what's giving me some concern and pause as to what to do here. I just want to make sure we're not setting Mr. August up for failure or to pose any sort of a danger to the community or anything like that based on the nature of the offense that we're dealing with. So, in order to keep track of him and make sure that we avoid any of those issues, I would be willing to release him to his residence on pretrial, but I would like to put a GPS monitor on him just so that we're able to know what's going on with him and where he is as the proceedings go on.
Would that be level 2?
Yes.
Thank you, Judge.
All right, so in Mr. August's case, I'm going, go ahead, I'm sorry.
And before you finalize the ruling, Your Honor, he lives in North Miami Beach, and as he has mentioned to me, he hasn't been driving since he got into this issue. I don't know how he's gonna be able to report to pretrial, within 24 hours if he gets released from North Miami.
He's going to be on a GPS monitor, so that's not going to be an issue. Pretrial verifies everything with him before he's released.
Okay, that, I think that would work with him.
As long as he has somewhere to go, other than that, he's sitting in custody. No longer.
Yeah, the address will be verified before he is released. Okay, so
Yes, and it's the same address as listed in the court files.
all right, I'm going to put him on a level 2 GPS monitor. There is going to be an order of no driving. And I am going to add a condition of random drug and alcohol testing based on the nature of the offense and the fact that he'll be out of custody. And Ms. Douglas, you don't have any concerns as to him being advised of these conditions without an interpreter?
If he could get an interpreter, but like I said, I've had a conversation, an in-depth conversation. I think we communicated very well. Mr. August is standing right there, so if he has concerns, then he could, let the court know.
Mr. August, have you been listening to everything we've been discussing here?
Yes, I do.
Okay, and I'm just gonna address you directly for a moment so that I know that you understand what I'm saying, okay?
I really understand, but if my English is not too well, if you have any interpreter, that would be fine. That would be good for me because I don't want to make any mistake by my understanding.
Okay, how does the Public Defender's Office want to proceed? And this does not need to be an issue in any of the other cases we're going for.
Just to let Mr. August know that if we'd have to wait and put his case off if he needs to wait to get an interpreter. Like I said, we communicated very well. I don't know if maybe, he just feels more comfortable having an interpreter around. It's really up to him.
Judge, can we place this on a recall and then we'll speak with him and make sure he understood everything?
All right.
Do we know, is a Creole interpreter available to phone in if necessary?
I believe that those have to be set up with the interpreter's office ahead of time.
Okay. We'll place this case on recall, Judge.
All right, Mr. August, I'm going to call you back up in a few minutes, okay? The attorneys need to discuss something and I'll call you back up. For all of my other PDs that are on the line, if you have cases where you have concerns about an interpreter, you need to address those issues ahead of time, not when we're at the end of the hearing, to make sure that your clients understand what we're doing today.
Judge, out of an abundance of caution, we can place this case at the end of the docket. We'll have a Creole interpreter come and interpret all the conditions. Thank you, Judge.
Thank you.
Judge, I'm ready to recall Mr. Igus. He will be accepting the release to pretrial with a GPS monitor.
Okay, all right.
And he's at Conti.
Okay. All right, and then is Ms. Siegel going to come back on for this one?
Yes, this is Ms. Siegel's case.
Yes, thank you, Your Honor. He would like to accept the GPS.
Okay, all right, and Mr. Igus, I've got you back here. So, okay, I'm going to, in Mr. Igus's case, I will release him and place him on pretrial supervision with a level 2 GPS monitor. And I believe that there was already an order of no victim contact in his case, but just in an abundance of caution, Mr. Igus, I'm going to say to you again, the no contact order means that with respect to the alleged victim, you're not to be in the same place at the same time as this person. That also means no phone calls or text messages to this person and no third-party contact or social media contact. Do you understand that?
Yes, ma'am.
Okay, all right. Thank you very much, sir. Good luck to you.
Thank you.
Thank
Thank
you.
All
you.
right, thank you, Ms. Siegel.
Thank you, Miss Siegel.
And Judge, we're ready to call Juan Carlos Morales. This is also Attorney Siegel's case on page 2 of Your Honor's docket, and Mr. Morales is at Conti.
Morales is on page 5, you said? Or excuse
And he
me.
also has a second case with Miss Douglas as well. That case is on page 5 of Your Honor's docket.
Okay, so Morales has 2 cases and he has 2 different attorneys. Is that what you're telling me?
That's correct, Judge.
Okay. Which one are we gonna do first? All right. Ms. Siegel's got which one? Page 2 or page 5?
Page 2, Judge.
Page 2. All right. Okay. Good afternoon, Mr. Morales.
Good afternoon.
All right, and I see that Mr. Morales, he's got the 2 cases. We have a misdemeanor case and a domestic violence case. He's got a $1,000 bond in Judge Malika's case and a no bond hold in Judge McHugh's case. All right. Ms. Siegel, or excuse, now I have Ms. Douglas on there. Which, are we doing Ms. Douglas or Ms. Siegel?
Yes, I go, Your Honor. My client does have a bond on Judge Monica's case. It's $1,000. We're just requesting that, it be reduced to, a more manageable amount. Or of course, the monitor, or if the court is inclined to release him ROR. He's been in jail for, quite a long time, since January 25. On these cases, Mr. Morales has no issues coming into court or reporting to probation if necessary. As far as the $1,000 bond, if the court isn't willing to release him RR, we're just asking for some other kind of pretrial release on non-monetary terms.
Your Honor, I think we're putting the cart before the horse on this one. He's being held no bond
Correct.
on a felony misdemeanor VOP. Judge McHugh, as recently as March 18th, denied the defense motion to set bond in that matter. As long as he's being held no bond in that, I don't see any reason to address the bond in the DUI case.
All right, I guess let's let Ms. Siegel weigh in on her case. I do see that there is a March 18th denial from Judge McHugh, leaving the no bond hold in place. So if you have some information that was not provided to Judge McHugh, then I will hear it. Otherwise, I'm gonna leave her ruling in place.
And Judge, the challenge with these domestic violence cases is these hearings took place without our clients present, and so that's why we're here for the rehearing. I just wanted to clarify. Go ahead, Ms. Siegel.
Your Honor?
Yes.
Yes, there's a couple things I'd like you to know, and I wish we were in front of Judge McHugh, but,
I've spoken
she
with
is
Judge
familiar
McHugh
with this
already.
case, but we're getting the second look, as you just heard, because, our clients weren't present. Not only that, I've already told you, and we all in the courthouse know how circumstances have drastically changed since the last time these clients were in front of you. This man has been in custody 105 days. Yes, he violated probation. Yes, he did pick up these DUIs. It was the second time he violated probation. What I think wasn't told to the judge at the time, because when he was put on the docket, was he's on probation for a violation of pretrial release in 2015. In 2015, he violated pretrial release. He was charged with engaging in a criminal activity on a case that actually became no pros. So he picked up this charge, the case was no pros. Unfortunately for him, he still pled this out, along with an assault and a resisting that is no longer in front of your court. As we sit here today, the 2015 case that I have him on is a violation of pretrial release and a violation of probation on that pretrial release. He's been in custody a total of 105 days in total on this charge. Judge McHugh told him, she wanted him to do SAP. He has done SAP since he's been in for 66 days during this time since the warrant was served. He has a job waiting for him. He's been working at the same company for 12 years. It's a construction job and it's the same company for over a decade. He has a 6-year-old child out there who he not only financially supports, who he is extremely worried about her health, the health of him as her father, why he's in custody. The fact he has so much time in I would love if the court would offer him a revoked time served offer in this, if you weren't inclined to do that based on it being Judge McHugh's case. But based on the fact he did SAP, he's been in so long, we're just asking for an ROR during these trying times.
Just so the public defenders are aware, I have spoken with each of the division judges on these cases because in cases where the judges have ruled recently, I don't think that it's appropriate to overstep and essentially overrule any of their rulings if they were made on material grounds that weren't just technical issues. So I just want everyone to be aware that whatever information you're providing to me, I have discussed these cases with the division judges and I have notes from each of them so that that is clear to everyone.
Thank you, Judge.
All right. Does the state want to say anything else on the domestic violence case for Mr. Morales?
Just so Your Honor is aware, most of his priors and current pending felony batteries are against the same victim, his wife. And the victim in this case is her son and the victim's mother. The defendant has 5 prior battery allegations, some declined. A 2017 battery where he was adjudicated 13 days. Felony facts of the case, per the state attorney on this case, are bad. So we're requesting no release.
Okay.
And Judge, I do understand that the court has had contact with each of the division judges. The concern that we have is that with the COVID situation is rapidly changing. And so the determinations that the judges made in the last 2 weeks without our clients present, we're in a different place now where the White House recently announced that there would be at least 100,000 deaths from COVID.
Ms. Edgley, I understand your office's position on everything, and we may not agree on all of that, but I want you guys to understand that I'm taking into consideration everything. I'm not just considering the pandemic, and that's not the situation that we are in. A lot of these crimes involve alleged victims, and these people, I'm not trying to create a situation where people are in custody because they are poor. That's not the issue here. So I understand the arguments. You guys have made your record with respect to the COVID issues and the pandemic. Don't think that I'm not hearing you. I just want you guys to understand that's not the only issue that we are considering here today. Just because someone is in custody on a misdemeanor doesn't necessarily mean that they need to be released because of what's going on. So I want to make that clear, and you guys can make your record, and that's fine. That's why we're here today. But we're not in a situation where we are forum shopping to get certain judges to overrule other judges' rulings. I have discussed these issues with the division judges. I have reviewed the files myself. I'm listening to everything that you guys are saying to me. But when I'm considering bond and release conditions, we have multiple issues on that list, and the pandemic is not the only thing. Okay.
I understand, Judge. We have been, and just so you know where we're coming from, we've been trying to get these cases heard for 2 weeks with our clients present.
I'm very aware of the situation.
It's been very, very difficult to get these cases heard. We would ask that the court would consider the non-incarceration options. There are ways to protect victims, such as a GPS monitor, and so we'd ask the court to consider
we're going to do that in the cases that I feel that is appropriate. All right.
Understood, Judge.
In Mr. Morales' case, I am going to deny the request and leave the no bond hold in place. With respect to the case that he has with Judge Malika, since he has the no bond hold, Ms. Douglas is his attorney in that case. It's up to her. The only issue that I foresee there is that if I do grant her request for an ROR and let the no bond hold, he won't be accruing any time served on it. So I'm not sure if she wants to change her position in light of the no bond hold.
And Your Honor, things might change, so we're just asking if the court would consider an ROR on Judge Malika's case, regardless.
Judge, we would just ask for a nominal bond
Can we
of $1.
put that on recall, please?
I'm not putting it on recall. That's it. All right.
I
I'll
think we
set
should keep his bond in place, would be my advice as attorney on the other case, so he gets credit for his time in.
Right. Or the court could issue a nominal bond to $1, for example, so he gets credit.
If you want the dollar bond, that's fine.
Thank you, Judge.
Thank you.
All right.
Yes, the dollar bond.
All right, that's fine. I've discussed that one with Judge Malika as well. He'll have a dollar bond in her case. All right, on Judge Malika's case, that is 20001019 MU10A. He'll have a dollar bond, and his no bond hold will remain in Judge McHugh's case.
And Judge, the next case we
Yes.
can call is Marquise Jackson. Mr. Jackson has two cases, one with Attorney Siegel on page 3 of Your Honor's docket, another one on page 7 of Your Honor's docket, and that is with Attorney Belkis Izquierdo. This will be a negotiated resolution to both cases.
On both cases?
This one? No. You have a global offer.
All right.
Yeah, I have a global offer for Jackson.
On the next one is gonna be Marquise Jackson. There's two cases on the docket. All right, State,
Yes,
is
Your Honor.
there an offer in Mr. Jackson's cases?
Yes, Your Honor. It's a global offer for both cases.
What's the offer?
It's 9 months probation, 9 months inpatient mental. That's what I have.
It's not.
And Judge, Mr. Jackson is not up yet. He's at North Broward. Mr. Jackson?
All right, let's go to North Broward.
And Judge, North Broward does want us to address the 3 individuals we reset from earlier today. What was the sanitation issue?
That's fine, Judge. We can interrupt our proceedings for that.
Or will you?
Let's do Mr. Jackson first, since I've got everybody here, and then we'll go to the others.
This.
All right, hold on one second. North Broward, do you have Marquise Jackson available?
Jackson refused, Your Honor.
Well, I can't take a plea if he's not gonna be present, so what do we wanna do?
This is Jackson refused.
Yeah, Kim, I know it's not the offer.
Yes, Marquise. Is
Mar-
it Quentin or?
Is it Quinn and Jackson?
No, Marquise Jackson.
Marquise Jackson. 1 second, Your Honor.
Do they have two Jacksons? What was that? I'm sorry.
They didn't tell me the his name. Marquise.
Oh, yeah.
Marquise? There is no Marquise somewhere. We don't have a Marquise.
Are you sure he's at North Broward?
I checked this morning, Judge. I can double check again. Can you double check my tablet just died?
Yes, Your Honor, he's at North Broward. I spoke to him this morning.
Okay, I'm just waiting on the deputies to locate him.
Your Honor, we can't bring him right now due to the guys that we have in the magistrate right now, the covets. We had to take care of them first before we could contaminate the area and then bring the other ones.
Okay, let's put Mr. Jackson's case on hold and address our 3 cases that are left on the first appearance docket. Okay. All right, the first one, North Broward, does it make a difference to you which one of the 3 is called first?
No, it does not. We have Sanders. So, ready.
All right, let's do Derek Sanders. All right, counsel, have you spoken to them?
All 3 of them.
Okay, good. Very good.
Yeah. I appreciate you. Step right on that X right there.
All right, good afternoon, Mr. Sanders.
Good afternoon, ma'am.
All right, Mr. Sanders, you're before the court this morning on one charge of possession of alprazolam.
Yes, ma'am.
All right, I find probable cause and state, I see there's a $1,000 bond here. Are you
I
seeking?
don't have anything to request at this time.
Okay, so let me go to the defense then first. Go ahead.
Judge, so he's been in South Florida for 22 years, his whole life. He does live in Hollywood. He can live with one of his friends, Brad. Right now, he cannot afford a $1,000 bond.
Okay.
So I'd be asking the court to consider a non-monetary bond at this time.
It's fine, Judge.
He does live on the reservation, Judge.
Okay, does he have any priors?
He does, but nothing, from what I can tell, significant that the court should be concerned. There's a drug prior.
All right, is there any objection to an ROR? Okay. All right, Mr. Sanders, I'm going to ROR you, which means that you will be released today.
Yes, ma'am.
I just want to make sure that you understand, okay, just because you're going to be released today doesn't necessarily mean that's the end of the case. So it will be your responsibility to be in contact with your attorneys in the clerk's office so that you know about any future court dates you may need to be present for. Do you understand that?
Yeah. Yes, ma'am. Will I get a letter in the mail on the reservation?
Yes, so I just want you to make sure that the clerk's office has the correct mailing address for you. As long as they have the
Okay.
correct mailing address, then they'll send any court notices there, okay?
All right, for sure.
All right, thank you. Good luck, sir.
All right, appreciate it, brother.
All right, North Broward, I've got Nicholas Becker and Brian Nichols. So whichever one you've got, bring them on up.
All right, 1 second. How are you bringing? We have Becker coming.
Okay, perfect. All right, good afternoon, Mr. Becker.
Good afternoon.
All right, Mr. Becker, you're before the court this morning on 3 charges. Count 1, aggravated battery with a deadly weapon. Count 2, resisting an officer, obstructing without violence. Count 3 is trespassing on an unoccupied structure or conveyance.
I plead
All
not
right,
guilty
hold
to
on,
all.
hold on, Mr. Becker.
Okay.
Mr. Becker, let me just hear from the attorneys first. Today's just your bond hearing, okay? All right, let me go to the state first.
Your Honor, I'm requesting a $10,000 bond on 1, no victim contact, no return. Just on the face of it, I'm concerned. He goes on to private property, residential property he has no business being on. When he gets confronted, and I know there's been a lot of talk today about the current environment, this area is shut down for the protection of the people that live in this development. He's confronted by one of the residents because he's not supposed to be there. And his response is spraying the person in the face with Lysol with bleach in it, in the person's face, eyes, and chest.
Three people were
Mr.
recording me
Becker,
in the shower.
Mr. Becker,
In the
please,
shower.
Mr. Becker,
In the shower.
Mr.
It wasn't
Becker, enough.
It's wrong.
Deputy, can you please turn the mic off for a moment? I don't want Mr. Becker to say anything that's going to be harmful to his case. Mr. Linder, please continue.
Thank you. He has no ties to the community from what I can tell. He has priors somewhat recently out of Nevada, California. I'm showing what appears to be pending out of California, a late November arrest for possession of personal identification information with intent to defraud, vandalism, damaging property, out of the state of Maryland, malicious destruction of property from 2015. In Nevada, under the name John Doe, he, was arrested January 23rd of this year, and that appears to that was on a resisting an officer, resisting public official, and trespass. So it does appear he's transient as well.
All right, I'll go to the defense.
Judge, the reason why he has so many different areas, he does for work as a model judge. He does do for a lot of freelancing work, and so that's why he sometimes travels in and out. He's lived in South Florida for a long time, 2016 and 2018. Has recently come back after a tour overseas, and that's why there's these concerns of his health. And so, Judge, I'd be asking for maybe a level 1 pretrial judge. He can live with his friend in Milton Manors during this time. Doesn't look like anything else in his prior was violent, and it looks like this one, the allegations are he did throw bleach onto someone. That was the deadly weapon that they're alleging.
Has a local address that he can stay at,
He's advised me that he could stay in Wilton Manors, one of his friends, yes, Judge.
and he understands that a level 1 GPS would place him under house arrest.
He does now, Judge, yes.
Mr. Linder, did you have something else you want to add?
I want to make sure he understands, and if he also needs to understand if this friend says, you know what, thought about it, he can't come here, he's going to sit in jail, and he won't be able to bond out.
All right. Deputy, will you please turn Mr. Becker's mic on? Mr. Becker, I just want you to listen to me carefully, okay? I don't want you to say anything that's going to be harmful to the case, so just listen to what I'm saying to you.
Yes, ma'am.
All right, what your attorney is recommending is that I release you and place you on a level 1 GPS monitor. If you have someone's house that you can reside at for now, then pretrial supervision would have to verify that with that person before you're released. And if you're on a level 1 GPS monitor, that effectively means that you're on house arrest for the time being. Do you understand that?
Yes, but I don't think that's going to be possible. I'm staying with my friend on house arrest. I don't think that's possible. The community that I apparently allegedly had no business being in, I actually lived there, and technically I'm still on the deed in one of the properties. That's technically also why I'm here. I also have a pending legalities in California. It's a very complicated issue. And also just to throw it out there, I never threw bleach on somebody.
Okay, Mr. Becker, I don't want you to say anything about the facts of the case today. I know that you're frustrated, but these are things for you to discuss with your attorney after the hearing today, okay? Do you understand?
I have no place to go after today.
Okay, so you don't have a friend's house to go and stay at?
Not under these the requirements that I'm gonna have to oblige by. I'm not gonna be able to do it. He's letting me stay there as a friend to be helpful with my situation until I go back to Asia for work. The only reason I came back to South Florida was because I knew I was gonna be homeless temporarily, and I thought I would be better off here.
Okay.
And that's what it is.
Okay. All right. Thank you. Okay. All right. For the record, I do find probable cause. Based on the information that Mr. Becker's provided, I don't believe that the level 1 GPS is going to work for him or be beneficial to his situation. All right. I'm going to set the bond on count 1 at $3,000. There's no bond attached to counts 2 and 3. And there will also be orders of no victim contact and no return. Mr. Becker, I just need you to understand that these orders mean until a judge says otherwise, you're not to go back to that location. And whether you know the alleged victim or not, that means no being in the same place at the same time as this person, no phone calls or text messages, and no third-party contact or social media contact with that person. Do you understand?
Yes, ma'am.
Okay. All right. Thank you
Yes,
very
Judge.
much. Good luck to you.
Thank you.
All right, and next will be Brian Nichols.
On his way, Your Honor.
Thank you. All right. Good afternoon, Mr. Nichols. Mr. Nichols, you're before the court this afternoon on 2 charges. Count 1, resisting an officer, obstructing without violence. Count 2, failing to obey police or fire department. I find probable cause, and I will hear from the parties. Does the state wish to be heard? All right, I'll go to the defense.
Judge, I asked for an ROR in this case. He was recently working for DoorDash, and that's, you know, the best that he could do, Judge. He does currently live in South Florida, but that's the best I've got from him, Judge.
That's fine, Your Honor. I'm just gonna Mr. Nichols can hear it. It's the second time this month he's been arrested for resisting without violence. He was ROR last time. I mean, and it ended up we didn't file the charge. It's you know, it's up to him if he wants to keep coming back or not.
All right, so based on the information that has been provided, I'm going to ROR Mr. Nichols. Mr. Nichols, I need you to understand that you're going to be released today, but that does not necessarily mean that's the end of the case. So it will be your responsibility to be in contact with your attorneys in the clerk's office so that you know about any future dates that you need to be present for. Do you understand that?
Okay.
Okay, and I just want to advise you, because of the information that Mr. Linder just brought up, if you continue to pick up new arrests, then you may not be ROR'd next time, okay? So I'm not sure what's going on, and I don't want to discuss it with you. I just want to give you the warning, because this is the second arrest in such a recent amount of time, that that's a potential consequence. Do you understand?
Okay.
Okay, all right, thank you, sir. Good luck.
Your Honor?
Thanks.
Yes,
May I be excused?
yes.
Thank you.
All right. Are you doing the Lorenzo Jones case?
Oh, I can tell you right now if it's okay. I have no objection to
Pre-trial, okay. For Lorenzo Jones. Which facility was Mr. Jones at? Conti? Let me go to Conti for a moment. Oh, yes, okay. All right, yes.
Actually, Judge, I was able to speak with Mr. Jones.
Okay.
Let me just find my notes, right?
All right. Hi, Mr. Jones.
Good afternoon, ma'am.
Okay, all right, so you were able to speak with him?
Yes, Judge. Actually, he wasn't even speaking with somebody else on the phone, Judge.
Mhm.
So he has no idea what we were talking about when I spoke to him about that.
Okay. All right, so let me just look here. So, Mr. Jones, just to go back on what we were talking about, you're here on a second look hearing today. The bond is presently set at $3,000, and I believe that the recommendation for standard pretrial was made before. Is that correct?
Yes, Judge.
All right, and the state has no objection to that at this time? All right, so Mr. Jones, I'm going to release you today and place you on standard pretrial supervision. That means that you'll be released today, but you must report in person to pretrial within 24 hours. One of the deputies will give you a piece of paper with information on where you need to go. Please understand that if you fail to report to them as I'm instructing you, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
Okay, all right, thank you very much, Mr. Jones. Good luck to you, sir.
Thank you.
All right. All right, Mr. Linder, you're out of here. Let's continue with our misdemeanor docket. Let me go back to North Broward. North Broward, are you going to be able to bring Marquise Jackson in now, or am I going to have to wait?
Once again.
Thank you.
Your Honor,
Yes, deputy.
we haven't decontaminated the area as of yet. I have
Okay.
Mr. Jackson here, but
Yeah.
he can't come in. He
Okay.
can't come in at this time.
Okay, so will you just
Can you
let me
add him
know when
on?
you guys are ready?
Can you add him on for this afternoon or tomorrow, maybe?
Judge, we need, the offer is going to amount to his release, and so if we can just recall at the very end of the docket, that'd be great.
Yeah, okay. All right, deputy, how long are you guys gonna need?
I'm not sure. The service company is here to clean, so once they're done, I don't know what's the estimated time. I would say, give me about 45 minutes at the most.
Okay, if we're done with my docket by the time we get back to this and North Broward's not ready, then I'll leave it for Judge Murphy to do with the
Wonderful.
afternoon batch, okay?
Thank you, Judge.
All right, okay, thank you, deputy. I'll come back and check up on you guys in a bit.
Thank you.
Thank you. Okay.
Judge, we can call James Buies.
Okay,
That's on page 2 of your Honor's docket. That's with attorney Magdala Jane Blues.
All right, and which facility is Mr. Buies at?
He is at Conti.
All right, let's go to Conti.
Approaching.
Thank you. And is the victim here? I'm sorry? Okay. All right, good afternoon, Mr. Buies.
Good afternoon, ma'am.
All right, so let me just see what's going on here first. It looks like Judge McHugh granted the motion on the 19th. It was supposed to be an ROR to level 2 pretrial and no victim contact. All right, so before we go to the issue involving the victim being heard, let me just first go to defense counsel and let me hear what's the issue.
Your Honor, good morning, Your Honor. The issue is, I believe you say pronounced his last name as Bias, although it's pronounced spelled B-U-I-S. I spoke with him earlier. He informed me that the judge had ordered because the judge had ordered a GPS and he is technically wasn't living in Broward County. He doesn't have an address here that he can provide to the courts. However, he has informed me that if he is able to on his own, can probably stay at a hotel until he finds a permanent home here. In addition, Your Honor, I've left a voicemail for individuals over at Pompano Beginners. I understand that they have bed availabilities there. And Mr. Which at this time, Your Honor, he does not have a local address in Broward County to provide to the court.
So you're working on getting him placement in a program, though? That's what I heard?
Well, it's just availability that they have because he's technically in Broward County, he would be considered homeless. So it would be to help him as far as shelter, Your Honor.
All right, let me go to the state for a moment. Tell me what's going on, state. I'm just going to ask you to, I know that you guys are all crowded around the desk. I'm just going to ask you to speak into the microphone so everyone can hear because it's a little bit difficult today. And we're going to have to speed these up a little bit because we have to be out of here before 1:30. There's going to be no exceptions to that. Go ahead.
At the last hearing, the motion for defense is the modification of the bond was granted. Judge McHugh released him on his own recognizance level 2 pretrial services with the GPS monitor. The reason being for the underlying warrant where he was violated for was leaving the county without permission from probation, and in addition for picking up a new charge, and in addition, I informed the judge when I made contact with the victim regarding the hearing. The victim stated that the defendant has still been getting in contact with her. So with that being said, the judge granted their motion, but granted their RR with level 2 GPS monitor. The state is requesting that you just leave Judge McHugh's rulings as it is.
Okay, that was all discussed at the hearing on the 19th?
And Judge, would it be possible to ROR him and have him update pretrial services with the address when he secures the hotel he'll be able to secure upon his release?
I'm sorry? Yeah, if to be on a level 2, if he's gonna be on any sort of GPS monitor, they have to have an address before they can release him. That's the issue.
Would it be possible to release him onto just standard pretrial release, then he'll be fitted for the monitor once he has that address and can provide the address to pretrial services?
If we release him standard, for example, and he never presents himself to pretrial, we would never be able to evict him in the warrant.
If he never presents himself to pretrial, it'll be a violation and a warrant will be issued in the court. He'd be right back here where we started.
Well, not necessarily. You guys know that.
And also, Your Honor, this was mentioned at the previous hearing as well, but Mr. Bias has spent over 80 days in custody combined on this case, Your Honor. Just wanted to put that out there for the court to consider. If
I'm not sure if it's over 80 days, Your Honor. He's been in.
All right.
He was in custody in Palm Beach. He was arrested for the new charge January 11th, but Judge McHugh did not sign his warrant until February 20th. So on this case, he's only been in custody since February 20th.
Does the state have an offer in the alternative?
Actually, Your Honor, he was in custody before from August 8th until October 2nd of 2019 when he originally was charged with this case.
Which was part of his plea. He pled out to 12 months probation with credit for time served for that.
Okay.
For that time he was in custody. The offer would be revoke 180, Your Honor.
I'm sorry?
Revoke probation 180 days.
180 days?
Broward County Jail.
180 days in the county jail?
Mr. Bias, would you consider a jail sentence at this time?
I would, but do I get credit for the time I was in Collier County when I was served my warrant January 12th?
He would.
Yes, Your Honor.
Credit.
Also at the last hearing, that was brought up. It appears that when the warrant was issued here, I believe it was issued on February 20th of this year. However, it wasn't served until March 17th when he was arrested of this year also. And he has been in custody at Collier County since the warrant was issued. I believe he was in custody in Collier County since from January 11th of this year, Your Honor. We would ask if the court would be inclined, Your Honor, to give him the credit for those 26 days.
I'm not sure that I even have the ability to do that.
Your Honor,
You do, Judge.
may I please, only because I was there for that hearing, I'm the trial partner, and work on this case as well. I actually was the one, I believe, who argued it and argued for his time served to take judicial notice of. Actually, Judge McHugh said that she would take notice of from the time the warrant was signed, because he was already in custody, even though he was in custody in a different jurisdiction. I believe we came up with 85 days based on that, and that was at a hearing last week with Judge McHugh, but the state can attest to it. Whatever state attorney was there, that's exactly what Judge McHugh said.
Your Honor, she, the state doesn't agree, but Judge McHugh stated that she would take notice of him being in custody from the time she signed a warrant, which was February 20th.
I believe that's what Ms. Siegel just said.
Correct.
Okay, so then he would get, since it seems that the parties are both telling me the same thing, his credit for time served would be from the date that the warrant was signed, which was what, February 20th, you said? Is that correct? All right, so he would get that credit.
And Judge, could we put this on a brief recall just so his attorneys can speak with them, and we'll add it to the end of the docket?
I have no problem putting these on a recall, but as I said before, if we get down to a time crunch, then you guys are gonna have to ask Judge Murphy if he'll hear them. If not, then I'm not sure what you're gonna do.
Understood, Judge.
All right. Mr. Bias, I'm gonna put you on a brief recall so that your attorney can discuss the offer with you, and then we'll bring you back up, okay?
Yes, ma'am.
Thank you.
Thank you, Your Honor.
Next judge we can call Jerry Hendricks. He's present at Conti, and this is with attorney Anshara Dosani.
Okay, and he has 2 cases. Is she handling both?
Yes, Judge. And this is going to be a global resolution.
All right. Good afternoon, Mr. Hendricks.
Hello, how are you, ma'am?
I'm well, thank you. All right, and state you have a global offer in both of Mr. Hendricks's cases?
Yes, Your Honor. It's 12 months probation, condition of 3 months Broward County Jail, 10 incomplete SAP, 29 weeks batterers intervention program, mental health evaluation and follow-up, and no victim contact. And to run concurrent.
All right, and Ms. Dasani, have you had the opportunity to discuss that offer with Mr. Hendricks?
Yes, Your Honor.
Okay. And Mr. Hendricks, you understand all of the conditions and provisions that are included in this global settlement offer?
Yes, ma'am.
Okay. All right, so I'm gonna ask you a few questions before we're done. This will pertain to both of the cases, all right?
Yes, ma'am.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And now you can put your hand down. And Mr. Hendricks, once again, you understand everything that we've discussed here so far this afternoon?
Yes, ma'am.
Okay. Is anyone forcing you to resolve these cases?
No, ma'am.
All right. Are you under the influence of drugs or alcohol?
No, ma'am.
Okay. Do you need any more time to speak with your attorney?
No, ma'am.
Okay. All right. And do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Okay. Have you ever been treated for mental or emotional illness?
Mental health.
Okay. Is there anything about any mental illness today that impacts your ability to accept this plea?
No, ma'am.
All right. And do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
Okay. And Mr. Hendricks, what plea do you wish to enter? Guilty or no contest?
No contest.
All right. I accept your plea and find that it is freely and voluntarily given. And once again, I just want to make sure that we have this correct. I want to make sure I have everything included on his sentence. That's going to include 12 months of probation, 3 months in the Broward County Jail. Did you say early release upon completion of SAP, or is it just completion of SAP?
To include SAP.
To include SAP, okay. And there will be a mental health evaluation. There will be an order of no victim contact, and he is to complete a batterer's intervention program. Is that correct?
Yes, Your Honor.
Okay. All right. All right, Mr. Hendricks, that's going to be
Your
it for
Honor, I
today.
apologize. I think the state and I came to a resolution by saying that Mr. Hendricks would get a BART evaluation within 24 hours of his release, because he has served, if you look at time served, he has 77 days in custody.
Okay.
And special conditions only 3 months.
She never responded to me, so this is the offer that I thought we agreed on.
Your Honor, that was the offer that was conveyed to me, and I did indicate to the state attorney that Mr. Hendricks was willing to take that offer. I believe Ms. Edgley also spoke to the supervising state attorney, and we all came to that resolution.
Ms. Edgley, do you care to weigh in?
So I did have a conversation with Stephanie Newman, who's the chief of the Domestic Violence Division, and we discussed this as a possibility, and my understanding were that the attorneys were going to discuss and come to a final agreement. So,
And because I didn't hear back, I just assumed that this
And
was the offer.
the offer that, the email that was conveyed to me did not include any indication that I needed to respond back. The email that I have that was sent to me yesterday at 3 p.m. included SAP or BART. So I believe that the state attorney misstated the offer on the record.
When I don't hear of an acceptance of an offer, I can't assume that it's accepted.
so has the offer changed since you sent
No,
the
it's
email?
the SAP or the BARC, but I didn't know, she
Oh.
never responded.
So it'll
how am I
be
supposed
BARC.
to read her mind. Yeah.
And Your Honor, we have been going back and forth on this, so this was not new, this was not anything. We were talking about a resolution, so we were in discussion.
So can we agree to the BARC and resolve the case? Okay.
So it's going to be a BARC evaluation instead of SAP, is that correct?
To be completed within 24 hours of release.
Okay.
Okay.
All right, Ms. Dasani, you understand?
Yes, Your Honor.
All right. All right, Mr. Hendricks, thank you very much. Good luck to you, sir.
Thank you.
Let's not wait until we're done with the plea colloquy to try to adjust the sentence that's been addressed already. Thank you.
Next, Judge, we can call. Oh,
I would have to apologize because I couldn't hear correctly, but that is on me.
All right, thank you, Ms. Dasani. Who's next?
Judge, next is Sean Carter. That's on page 4 of Your Honor's docket. This is with Attorney Danielle Curtis. And she's present, Judge.
Hi, Your Honor.
All right, hi, Ms. Curtis. Okay, and I have Mr. Carter here. Good afternoon, Mr. Carter.
Good afternoon, Your Honor. How are you?
I'm well, thank you. All right, so it looks like Judge Gottlieb has already addressed this motion, and he granted it, placing Mr. Carter on standard pretrial with a tab monitor, no victim contact, and random testing. So what I'm seeing here, Ms. Curtis, is that Mr. Carter doesn't have an address he can provide. Is that the issue?
Yes, Your Honor, and also, he's been in custody for 64 days now, Your Honor. He has family, he has his daughter that lives down here, Your Honor, that he was in communication with, as well as his sister. He's willing to do, Judge Gottlieb placed him in the SAP program. He successfully completed 2 weeks so far, Your Honor, and he's willing to do a program and stay sober once he's released, so we're requesting that he be ROR, Your Honor.
Well, that would
I
be
wanna
with standard
graduate.
pretrial and random testing and no victim contact, right? That's what you're saying?
Yes, Your Honor, I'm just asking without the
The tab.
GPS monitor.
Okay.
I'm graduating the 23rd of April, and I would like to graduate the SAP program.
Okay, I'm very happy to hear that, Mr. Carter. So let me go over to the state attorney and let the state weigh in if they wish.
Yes, Your Honor, just so the court is aware, it was on 2/11 that the defense filed a motion to reduce bond, and then on 3/20 they filed a motion for him to be RR that was denied, and then we're here again on the same motion.
Judge, I can add information about what happened on 220 because I was actually there with Miss Curtis when this
I know what happened. It's
motion was just okay. So we deleted from the. It was supposed to be deleted from the
It's
docket.
fine. I understand.
Thank you, Judge.
All right. Remind me, state, because I remember Mr. Carter came to me for his first appearance. What are his? Does he have any prior history?
Yes, Your Honor. He has a 2020 trespass where adjudication was withheld, 2020 disorderly intoxication, adjudication withheld, 2020 trespass, on a structure / conveyed, conveyance occupied, adjudication withheld. He has a 2019 trespass, adjudicated, a 2018 failure to leave property upon order by owner, adjudicated, 2017 trespass, adjudicated, 2016 trespass, adjudicated, 2013 possession of cannabis, adjudication withheld, and a 2010 petty theft, adjudication withheld.
Okay. All right. I'm going to grant the defense's request. I'm just going to modify this to remove the tab monitor so that the address won't be an issue. So Mr. Carter will be placed on standard pretrial supervision. He will be subjected to the random drug and alcohol testing as Judge Gottlieb already ordered, and the order of no victim contact will remain.
Thank you, Your Honor.
All right, so Mr. Carter, you're going to be released and placed on standard pretrial. One of the deputies is going to give you the information on where you need to go. Please be sure to report to standard pretrial as instructed in that paperwork, because if you fail to do so, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
Okay, all right, good luck to you, sir.
I cannot finish the program now.
And that was another thing, Your Honor. He wanted to stay and finish the program.
Well, his attorneys have presented other information. I'm not gonna continue going back and forth on these. All right, who's up next?
Judge,
Ms.
next we
Eckley?
have an agreed order on Mr. Kevin Scully. That's on page 6 of your Honor's docket, and this is with Attorney Siegel. I did provide Madam Clerk with the agreed order RORing him.
Yes, Your Honor, the state will be not filing the charges. The paperwork just hasn't reached the clerks yet.
So this agreed order that's been given to me just says the defendant shall be released ROR based upon the stipulation of the parties. Is that
That's correct, and we did
Correct.
review it together.
Is the state declining? Is that what's happening?
Correct.
Your Honor, based on what the state just said on the record, that they're not gonna be filing charges in this case, I just wanna make sure that no contact order is put into place.
On Mr.
Is not
Scully's
put into
case?
place.
Well, if they're declining, once they file that, then the no contact order will be lifted. If it hasn't been filed yet, then it doesn't get lifted yet.
My understanding, the clerk has not updated the site yet, but it has been filed, I could be wrong, but they're dropping the case, it's not that she.
Okay, well, as soon as that
No
paperwork comes
contact
through,
order, she has told the state that already.
all right, once that paperwork comes through, then it will be lifted. Okay, so Mr. Scully, per the agreement of the parties, you're going to be released today, all right?
Thank you.
All right, thank you, sir. Good luck to you.
Thank you so much.
All right, who's next, Miss Edgley?
And Judge, we can recall James Buies on page 2 of your Honor's docket. He would like to think about the offer, and so we'll just delete it from the docket today.
All right, so do I need to bring him back up, or are we gonna be good with that?
We can call over and let him know.
Okay, all right,
Thank you,
so
Judge.
on Mr. Buies or Bias, however you pronounce it, we'll just take no action, and I'll let you guys figure out how you wanna do that.
And Judge, I believe the only other one, we have Mr. Jackson, who we're waiting for the cleaning crew at North Broward, but are we setting that before Judge Murphy?
It'll depend on whether North Broward
Okay.
is ready to go by the time we're done.
And then the only other one that we can recall would be Mr. Auguste Wilner on page 2 of your Honor's docket with Attorney
All right,
Douglas.
let me get the Creole interpreter on the line.
Thank you, Judge.
And he was at, Mr. Auguste's at Conti, correct?
Yes, Judge.
All right, so we'll recall Mr. Auguste, and let me just get our interpreter on the line.
Oh, sorry.
Your call has been forwarded to an automatic voice message system.
I'll try one more time.
Your call has been forwarded to an...
You're getting another one?
Sure.
Okay. When you're ready, just give me the number.
And Judge, I'm looking at the email that Mr. Goldberg sent me today for what was supposed to be on the second look. The only one that I'm comparing it with the docket that I have in front of me.
Mhm.
The only one that I see that is not on this docket that we received in court is for Carlette Hope. Is that one going to take place this afternoon?
So I was going to ask you guys about that because she's supposed to be on the docket, so I'm not sure.
Okay, let me.
Oh, she's not. I have a couple of other ones where I'm waiting on the interpreter. Miss Edgley, let me just ask you, because I have a couple of other ones on this list.
Of course, Judge.
Besides Marquise Jackson, I just want to know what we're doing with them. Alba Gutierrez, was that one taken off the docket? Looks like it was denied.
Judge, I believe that was the one where the offer was extended. I believe she's interested in resolving the case. Let me just confirm with Ms. Dosani.
Okay. And then I also have a Dennis Smith.
Dennis Smith is actually released, so we can delete that one from the docket.
Okay. All right. Thank you. All right, let's try our other interpreter.
Hello.
Good
Good
afternoon.
afternoon. Maxine speaking.
Good afternoon, Martine. This is Judge Cawthon. How are you this afternoon?
I'm fine, thank you. And you?
I am well. I was given your information because we need a Creole interpreter on one of our cases. Are you able to do that for us?
Oh, sure. What time?
Okay, well, now if you're available.
Oh, sure, yeah.
Okay, all right. So if you are ready, I'll go ahead and give you the gentleman's name, and then I will just swear you in over the phone.
Okay.
Okay, his first name is Wilner. It's Wilner.
Okay.
And the last name is Auguste, Auguste.
Okay.
All right. And do you swear or affirm to interpret from Creole to English and English to Creole to the best of your ability?
I swear. Martine Moline Pellissier, Martine Moline Pellissier, Haitian Creole, certified Haitian Creole interpreter.
All right.
For the
Thank you.
record.
Thank you so much. Okay. All right. I have Mr. Auguste here. All right. Mr. Auguste, I have a Creole interpreter here to assist so that I know that you understand everything that we're saying this afternoon.
Monsieur Auguste, nous gagnons un interprète créole qui est là pour capable aider ou pour nous assurer nous pour comprendre tout bagaille. Je dis.
Okay.
Okay?
Okay.
All right.
Okay.
So to repeat some of the things that we were discussing earlier with your attorney.
Pour nous répéter deux trois bagailles que nous t'ai parlé de yo déjà avec avocat ou.
I'm going to release you from custody, and you will be placed on a level 2 GPS monitor on pretrial supervision.
M'bral faire ou laguer ou sous niveau 2 et sous supervision avant et procès.
That means that pretrial supervision is going to verify your home address, and then they will fit you with a GPS monitor.
Ça veut dire supervision avant procès, yo aller vérifier adresse ou la caou et puis yo aller gagner au moniteur un GPS moniteur que va mettre sous.
As a condition of your release, you are not to be driving any motor vehicle until further order of the court.
Comme condition pour yo laguer ou, c'est que vous pas conduire aucune machine connière.
And you will be subjected to random drug and alcohol testing.
Et yo pral faire ou passer des tests drogue, alcool de temps en temps, par hasard.
Do you understand everything that I've said?
Est-ce que vous comprenez tout ça, M. Doulayo?
Bon, oui, moi, je comprends. Et le problème qui gagne, moi, c'est papa, moi, j'ai une madame avec 6 timons.
Yes, I understand them. The problem is that I am a father. I have a wife and 6 children.
Et moun sa yo ta comme gado depuis m'pas ka conduit depuis 2016, c'est presque c'est ta comme gado et c'est un travail n'a passé parce que depuis m'pas ka conduire m'pas ka travailler tout.
Okay, those people, you know, I haven't been able to drive since 2016. It's really very difficult for me because I can't drive. I'm really having difficulty.
Et madame mwen genyen yan, se li kap fet ti jou travay nan hotel. Ti jou travay nan hotel, pa ka peye yon kay pou nou rete. Alors, problem ki vini rive, adres sa mwen ba yo, se adres yon fure madame mwen ki la depi ki achete kay, depi nou vini isi, se adres sa nap utilize, et là nous recevons toutes mail nous pour ne pas perdre aucun mail.
Okay, the wife that I have, my wife, she only works a little bit, and the money that she's earning can't pay for a house. We've been living with my wife's brother, and we receive all the mail, everything. That's where I receive it at that address.
Mais ça pas veut dire exactly c'est l'âme dormi levé parce que m'pas arrêter caillon mon avec système.
That doesn't mean that that's where I sleep. That's where I live because I cannot live there in that house with 6 children.
C'est caille la pas caille moi c'est caillon frère madame moi li.
Because that house is not my house. It belongs to my wife's brother.
Okay. All right, hold on, Mr. August. Hold on. Your attorney wants to speak.
Right. I did explain to Mr. August what the pre-trial release would entail, that he had to have a verifiable address. This is the address that he gave me. And I did let him know that that would be the condition of the pre-trial. Otherwise, and that of course that we wouldn't be able to discuss too many other things except what was on for today because you had a long docket. So he just wanted to know if the level 2 GPS would mean that he couldn't work because he has a wife and 6 kids to support.
Okay. All right. So, Mr. August, what it means for you to be placed on the GPS monitor is that you will give your address that you will be staying at to pretrial supervision.
OK. Ça veut dire que pour vous mettre dans niveau 2 GPS, moniteur GPS, c'est que on va pas adresse que vous va arrêter à on va pas l'adresse ça pour nous capable gagner lit pour capable gagner supervision avant procès.
And if you are going to be working, then you will just have to provide a schedule to pretrial supervision so that they know where you're going to be.
Alors si vous prenez le travail, vous prenez adresse côté ou pral bay horaire travail ou pour capable gagner lit pour capable surveiller ou avant procès.
But it's very important that you understand that you are not allowed to be driving.
Mais l'important pour comprendre que ou pas gain droit conduire, ou pas droit conduire.
Do you understand that, sir?
Est-ce que vous comprenez ça, monsieur?
Oui, moi entendez, moi comprendre, mais yon seul bagage qui gagne, moi même pour de vérité et c'est on doit arrêter comme ça, yon ami relève pour m'y faire un jour travail avec, moi pas gagner un travail fixé depuis au fin pour tout bagage là même depuis 2016 là, pas un travail fixé côté malé.
Okay, yes, I hear you and I understand, but one thing, to tell you the truth, a friend can call me and tell me to go do 1 day of work because since 2006 I don't have like a fixed job.
Okay, well, Mr. August, right now you are being held in custody, no bond. And these are the conditions that I'm willing to release you under. There's no negotiation here.
Alors, Monsieur Auguste, qu'on y a, il y a aucun bon en détention et ou pas gain caution, sans pas capable payer caution. Et ces conditions, ça, que ma barou là, que je capable de quitter ou aller laguer, ces conditions, ça, pour qu'à respecter. OK?
Bon, moi, pas de problème avec ça, mais yon seul bagage, c'est et horaire travail là, et puis avec Kaila.
Mr. August. Mr. August, one
And I
moment.
did try to, get it in a nutshell when I called him, on the break. I explained to him that the options are either to stay where he is, no bond, or accept the pre-trial, and that's where we are now. So we're, at this point, I think, it's just a decision as to. He did say he was willing to do the no driving, the randoms. He was concerned, and you did explain what the GPS monitoring would be. So I think he just has to understand that that's the option, either remain there or accept what you're giving him.
I know it's hard to hear right now. All right.
Yes, Judge, I'm sorry.
Okay, that's okay. Mr. August, I'm going to say this to you, and I need to know that you understand and that you make a very clear choice.
Monsieur Auguste, je vais répéter ça ba ou et je voulais assurer qu'on comprenne pour capable faire un choix clair.
Either you can remain in custody, no bond, or you can accept the conditions that I have explained to you.
Ou bien ou rester en détention et ou pas gain caution pour payer ou bien ou capable accepter conditions que m'a ba ou là yo.
I don't want an explanation. I just need you to tell me which option you would like to take.
M'pa besoin aucune explication, juste besoin connaître qui est dans choix ça yo ou vle.
Okay.
So what would you like to do?
OK, qui sont ta aimé fait?
Are you willing to accept the conditions of release that I have explained to you?
Est-ce que vous d'accord pour accepter conditions et que pour me laguer ou là que que me saute déjà yo?
C'est pas accepter, m'pa ka faire, m'pa ka prendre décision, m'pa ka faire décision juge là simplement moi dire OK à faire des
It's not that I don't accept. I can't make a decision for the judge. It's just that I'm telling you that.
moniter à horaire travail là m'pa gagner horaire travail parce que qu'importe mon carré les mails font le travail par contre qui
That I don't have a schedule. I don't have a fixed schedule. They can call me anytime to go to work.
Mr. August, you will have to give a schedule to pretrial supervision and abide by that schedule. If you do not think that you can abide by the terms that I'm setting out for you, then I will just leave things as they are.
Monsieur Auguste, c'est pour bailler un horaire de travail et pour nous capables de gagner un horaire de travail. Si vous pensez qu'on n'est pas capable de faire ça, on va quitter les gens et là,
bon, moi, pas de problème, juge là. Si ou même, ou ba mi horaire, là, plus bon pour moi, parce que là, ça m'a posé ça pour faire.
Well, I don't have any problem. If you give me a schedule yourself, I can abide by it.
If the interpreter would let him know that the court is not telling him that he has to get a job, but that if he has one, he needs to let pretrial know.
Okay. Le tribunal l'a pas dit fort, je au travail. Il dit que si vous gagnez un travail, faut faire nous connaître qui aurait ou.
Oh mon Dieu. Laisse-moi dire, m'pas gain, c'est pas horaire, m'pas ta travail, mais faut m'ta compte qui le m'a venu font call qui le a venu chercher, m'pas connaît. Si c'est juge là que bon mon horaire, m'a dit mon n'a pas qu'à aller tel là.
Okay, I don't have a schedule. I don't know when I work. If the judge wants to give me a schedule, then I can follow that schedule.
Okay, counsel, I'm not confident that Mr. August understands what I'm explaining to him, and in light of the history of this case, that gives me even greater concern as we're sitting here today.
Est sûr que Monsieur Auguste comprend tout ça m'a essayé expliquer là et ça va un problème parce que l'homme pensé à 10 ans dossier à payer déjà un problème pour me capable résoudre les dossiers genre ça.
This is especially in light of the fact that the competency hearing has not been completed with Judge Malika.
Et puis tout c'est que audience pour capable connaître s'il y a une capacité pour lui pas fin yo pas fin faire les gens yo et maintenant et c'est là.
Okay, I would like hold on Mr. Augusti. I would like to hear from the state attorney, please.
So, Your Honor, just
into the microphone
because I do speak Haitian Creole.
Microphone.
Oh, sorry, I do speak Haitian Creole. Based on my comprehension of the defendant, his problem is he doesn't know exactly when he's going to get work, and he doesn't want to violate as far as pretrial goes, because if he doesn't give them enough notice, if he finds out the same day, so that's the issue that he's having.
So, pretrial, how can we give you instructions on how to address that when he gets a call out work?
to be turned in the Friday prior.
It's, you'll have
No.
to use it.
Mr. Augusti, can you hear me?
Hello?
I just hear you now.
Okay, so you won't be able to go to work when you get a call the same day. That's not something that pretrial's able to do. However, if you get a set schedule, oh, sorry, you're interpreting. Go ahead.
Ok, ou pas capable aller travail si yo relo même jour pour aller travail, ou pas capable faire comme ça.
So if you get a call and your pretrial officer says you can't go to work,
Si yo relo et puis officier avant poste ou dit qu'on pas capable aller travail, yes.
then you can't go to work.
Alors pas capable aller.
So that's your choice. You can go out on pretrial and only work when you have permission,
Ou capable prendre avant procès ou et seulement travail là yo bon permission pour travail
or you can remain in jail.
ou bien capable rester dans prison.
Okay.
Do you understand?
Est-ce qu'on comprend?
Oui, je comprends.
Yes, I understand.
Okay. So would you like to be released on pretrial?
Alors, est-ce que t'as aimé yo la gueule pour avant procès? Yo quitte aller, yo la gueule.
Il est bon pour moi.
Yes, it would be good for me.
Okay. Thank you, Judge.
Okay. All right. Thank you, Mr. Augusti. Good luck to you.
Thank you.
All right. Now, yes. You got, okay, what's happening with Alba Gutierrez?
So that's going to be a plea. She will be accepting the state's offer.
Okay.
And she's at Conti.
All right. Conti, do you have Alba Gutierrez?
Is the Creole interpreter needed still, Judge?
I believe, is that it?
Yes.
Okay.
We don't need a Creole
All
interpreter.
right. Martine, thank you so much. I appreciate your assistance.
Thank you, Judge.
Have a nice afternoon.
We do need a Spanish interpreter for Miss Gutierrez. Should we take the plea with Judge Murphy?
Yes, you should.
Okay, sounds good, Judge.
All right, Conti, don't worry about Miss Gutierrez. She's going to be coming in later.
But don't send her back because we're going to start in 15 minutes. So if we can resolve it right at the beginning of the docket, that'd be great.
Yes. She's not in Conti. There are no females in Conti, so I don't know where she might be a Paul Ryan. All right, and who was the last one?
That was Marquise Jackson.
All right, let's go back.
I think we're still waiting for the cleaning, but if they're ready for him, we
Let
can
me
address
just
him.
see.
That will also be a plea.
North Broward, I just want to touch base with you. Are you able to bring me Marquise Jackson, or are you still cleaning? Okay, I'm guessing that means they're still cleaning.
Yeah, there's probably cleaning crews in
All
there.
right, and then the only other one that I wanted to address is the Carlette Hope, because she's not on the docket.
So I'll just ask to address this one with Judge Murphy today. Sometimes they don't bring people down, so we'll just call the jail and ask them to bring Mr. Hope down.
Okay. All right. Then miraculously, that brings us to the end of our first docket for the day.
Thank you, Judge.
For Carlette Pope, what was it that Ms. Edgy said?
We're addressing it this afternoon, Dion.
Right. She's not on my docket right now. Okay. So court will be starting back up again at 1:30 with Judge Murphy, who will be presiding over the felony docket and the misdemeanor add-ons that we've discussed. I will see everyone tomorrow morning for first appearances. Thank you.
All right, good afternoon, everyone. This is Judge Michael Lynch. We're doing the 1:30. I have two dockets. We've got the regular felony bond motions and emergency motions, and then I also have a number of misdemeanors. So if you could, when you call the case, let me know if we're on the misdemeanor or felony docket. Have they been going straight down the docket? Okay.
Yes, for the most part, Judge. We do have Jennifer Edgley, Chief Assistant Public Defender. We had two cases carry over from this morning that we weren't able to address. One we've been able to deal with.
Okay.
One is going to be a plea.
Okay.
And I'm not sure if that person is available because the courtroom in North Broward had to be cleaned because of
Okay.
the COVID considerations, and so that's the reason why they weren't available. I can call and see if they're available now.
Okay, if you want to check on that, then we can handle that from this morning and get that out of the way. In the meantime, I'm just going to start going down the felony docket, if that's okay with everyone. So on page 4, we have Kirk Thomas.
Main jail, Your Honor.
Main jail. All right. Good afternoon, Mr. Thomas.
Good afternoon, Judge. Your Honor.
Let me just pull the motion. All right, and this, Mr. Thomas is represented by Miss Early. Let me see if I can get Miss Early on the phone.
Yeah. Good.
Yes. Yep, so he's up for this afternoon.
No, I'd rather not take that. I don't, this is about reason.
Good afternoon, Miss Early. This is Judge Michael Lynch. I have you on speakerphone in open court on the record. How are you?
I'm blessed, how are you?
Very good. I'm calling in regards to Kirk Thomas. I have the defendant's emergency motion for release, ROR, or in the alternative to release on a GPS monitor.
Yes.
All right. And which state attorney is going to be?
I am.
All right. Mr. Schneider, good morning. Good afternoon.
Good afternoon.
All right. And Ms. Early, I have reviewed the motion. Let me hear what you have to say.
Well, and Your Honor, apologies up front. I'm actually heading back to my office for my lunch break, but I'm going based on my memory. With this case is going through 3 separate prosecutors. You were in the process of scheduling depositions in this case. The alleged victim has since moved to Arizona, and I spoke with the most recent prosecutor, Mr. Davidson. And based on my conversation with her, I know that you said Ms. Maria Schneider is covering this hearing, but based on my conversation with her, and I don't know Maria's position, that she didn't have an issue with the ankle monitor, considering this is the 3rd time we had to, actually the 4th time we had to reschedule the depots before the pandemic. Moreover, Mr. Thomas is an older gentleman in frail health, and this is way before the COVID-19. In fact, he was at NBD for a while due to his health. He has since been transferred to me, but my concern is that he informed me that one of his cellmates, and again, for the record, Mr. Thomas's appearance has been waived because the jail is currently closed.
I've got him. No, Miss Early. I'm in the magistrate courtroom. Mr. Thomas is appearing via closed circuit. Okay.
Okay. Well, hey, Mr. Thomas.
Hello, Miss Early.
Okay, so I was asked
asking if we can have Mr. Thomas released on a GPS ankle monitor. This will make it easier for me to prepare this case for trial. Moreover, after speaking with the prosecutor in this case, because the alleged victim lives in Arizona, she doesn't know, or we don't know, when we'll be able to reschedule the deposition at this time. So coupled with his health, coupled with his the way the case is going, I would ask the court to put him on an ankle monitor.
Okay, and Stan?
Your Honor, the state objects. I'd like to first give the court a brief overview of the facts of this case.
Sure.
The defendant stabbed the victim twice, then fled the scene, was chased by the victim and the police. He was in a van. He bailed out of the van while it was still moving and crashed into a parked vehicle. He then continued on foot and was finally apprehended by the police several blocks away, where he resisted arrest, struck the officer, and began to pull on the officer's duty belt and duty weapon. While the defendant was running away, he dropped a black bag that had a knife with electric tape wrapped around the handle. This defendant, nonetheless, Your Honor, has been released previously. He was in custody on September 1st of 2018. He was released on PTR level 2 on January 14th of 2019. January 14th, and immediately he began to violate. He violated the conditions of PTR by leaving on 3 different occasions, not being what he was supposed to be. He was taken into custody. However, on August 29th of 2019, he was released again, back on PTR level 2, this time with a curfew, and he was supposed to go to a program, I believe. He was told not to go anywhere else. Well, that was on August 29th. By September 20th of 2019, he had violated PTR again by getting arrested, this time for resisting arrest and trespassing, and obviously, clearly, he was not at home, as he had been warned by the court not to do. He scores a minimum of 33 months in Florida State Prison. I think that the facts of this case indicate that he is a violent person and that he is a threat to the community, and the fact that because of his age and all of these things, he has on multiple occasions been given the opportunity to be out on PTR on a monitor, and he continually fails to abide by those. I don't think there are any conditions that we can impose at this time that would keep the community safe. The victim has been located. We will be available hopefully soon to be able to go do the deposition, and we'll be able to move forward.
Okay, do you have any information on Mr. Thomas's prior criminal history?
Yes, Your Honor. His prior criminal history consists of a felony for harassing phone calls, improper exhibition of a weapon, battery, criminal mischief, a bunch of trespasses, harassing a witness, stalking, more trespassing, resisting with violence, leaving the scene of an accident, more resistings, more resisting. That's pretty much it.
All right, and Ms. Rowley, where would yes?
If I may,
Sure.
I would like to clarify the issues with pretrial release, because I was the attorney of record since the beginning. Regarding the 2 violations or the allegations of violations, there were some issues with his ankle monitor, and that was addressed before Judge Bailey. So although it was listed as a violation, or that he did not abide by the curfew, that was addressed before Judge Bailey, and it was determined that he had to switch out his ankle monitor not once but twice. Furthermore, Your Honor, regarding the disposition of some of those of his past criminal history, I would like the state to confirm whether or not all of the allegations listed were either non-crossed or dismissed.
All of the ones that I have just listed are convictions.
Okay.
I haven't mentioned a single one that is not a scorable offense.
All right, and let me ask, is the alleged victim in this case does live out of state at this point?
At this point, yes, the alleged victim is out of state, Your Honor. But while Ms. Early's explanation would explain the first violation of PTR, certainly doesn't explain the second.
No, I mean, I agree with that.
I'm sorry, hold on. I can't hear. I didn't hear, because can I mute MBB or main jail, because I can't hear her explanation at all.
Yeah, I can't, and I don't know if I can do that or.
If you do that, then the gentleman won't hear us.
Yeah, no, I can't. So.
Okay, well, can you just speak up,
Yeah.
because there's a lot of noise in the background, and I can't hear to make a proper argument.
Not a problem. The issue was that your explanation would cover the one violation of pretrial, the alleged violation of pretrial, but not the other one, not the original one.
The second one,
And
actually.
the other one meaning a new law violation with the trespass and the misdemeanor resisting without violence, that one?
Correct.
Yes.
And in addition, he wasn't home.
Wasn't home and picked up a new offense, new felony offense. All right. Respectfully on Mr. Thomas, I don't think there's anything that I can do other than hold him in custody that would protect the community and ensure that he would appear. So respectfully, the motion is denied.
Thank you, Your Honor.
Thank you.
All right.
All right. Next will be Andrew Hernandez, represented by Gary Cole. All right. All right, so do we have Andrew Hernandez? All right, let me, thank you, thank you. We're gonna get Mr. Cole on the line.
Hello,
Good afternoon, may I speak to Mr. Cole, please?
speaking.
Mr. Cole, good afternoon, this is Judge Michael Lynch. I have you on speakerphone in open court on the record. How are you? You there?
Yes, I'm good, thank you.
Okay, I'm calling in regards to Andrew Hernandez.
Oh, wait a minute. Are you calling a Gary Cole, who's a criminal defense lawyer in Fort Lauderdale?
I am. I just realized I absolutely called the wrong Gary Cole. Mr. Cole, I'm sorry.
It happens a lot.
You have a good day. I'm going to call the other Mr. Cole.
Thank you very much.
Sure.
Bye-bye.
Bye. We're really starting off well here today.
Good afternoon, Walton.
Good afternoon. May I speak to Gary Cole, please?
Speaking.
Mr. Cole, good afternoon. This is Judge Michael Lynch. I have you on speakerphone in open court on the record. How are you?
I'm good, Judge. How are you?
Very good. I'm calling in regards to Andrew Hernandez.
Yes, sir.
All right, and we're in the magistrate room, so I do have your client in front of me. Good afternoon, sir.
Good afternoon, Your Honor.
All right, and I do have the motion here, and Mr. Cole, go ahead. Mr. Cole, what would you like me to consider?
Judge Siegel initially reduced the bond. It's all in the motion, $50,000 fully collateralized. Unfortunately, the family does not have the assets to fully collateralize the bond. My understanding now is that the defendant's uncle does have the funds to post $5,000 with a bail bondsman. He's allowed to do that. Also, in addition, I provided attached to the motion that my client does have chronic asthma, and I actually just received a letter within like the last 30 minutes from the facility that treats him. Judge, can you hold on? Let me get to another phone.
Yeah, no problem.
Okay.
All right.
And I did email it to the assigned prosecutor as well as Judge Siegel, and basically letters from Lower Keys Medical Center from a Dr. Jerome Covington. It states, I'm writing in reference to the above individual who's been seen by me in the past and has had multiple visits to the ER room in Key West. This is to note that he has a past history of asthma, which at times was problematic. In addition, he has many visits for severe GERD, which could result from a persistent problem with anxiety. Judge, attached to my motion were a couple of documents from the CDC indicating that people with moderate to severe asthma are more susceptible to not only the coronavirus, but also the repercussions from that virus. I also attached to my motion that at the time there were a few reported cases of the coronavirus entering into the jail facilities. So based upon his, Mr. Hernandez's particular condition, Judge, I would ask that you delete the full collateralization regarding the bond. Allow him to be released. He does have a job waiting for him as a first mate on a commercial fishing boat out of Key West, which is obviously good for him because that would allow him to go back to work.
All right.
And there was a position in the original motion that he surrender his passport, and Mr. Hernandez does not have a passport.
Okay. All right. State.
Your Honor, the state objects. This is a trafficking cocaine case. The facts are, briefly, that the defendant expressed an interest to a confidential informant. He wanted to buy cocaine to take back to Key West. He showed up with $15,000 and he tried to purchase 641 grams of cocaine. So we're talking significant amounts. Given, the fact that he had that kind of cash and a significant amount of cocaine was involved, we would ask that the bonds remain the same. This has been addressed with his assigned judge, and the judge said that the bonds, he did reduce it to, and he did say that they have to be fully collateralized, and we would ask that the bonds remained as is.
All right. Any criminal history?
Just some misdemeanors. It's not terribly extensive. Battery, possession of cannabis, leaving the scene of an accident.
All right. Over state's objection, I'm going to grant the motion to modify the conditions of release and delete the requirement that it be fully collateralized. And I'll indicate if he doesn't have a passport, he can't attempt to get a passport. So, Mr. Hernandez, let me explain to you. One of the conditions was originally that you were to surrender your passport. I understand you don't have a passport. I'm going to order that you not attempt to get a passport. You understand?
Yes, sir.
Okay.
Yes, Your Honor.
All right. And I am granting your attorney's request that'll allow your family member to post bond, okay?
Thank you.
All right. And we need to give Mr. Hernandez a status date. And
And Your Honor, we would ask that NEBIA requirements be met. Is the court not going to require that?
Mr. Cole, your position?
Judge, I would ask not again. Here's my understanding. Mr. Hernandez's uncle has his own business in Key West, and he will be providing the funds for the bondsman.
Okay. I'm not going to require the Nebbia. All right? So you can post the bond and you'll be out. I'm going to give a status date in front of his judge, which is Judge Siegel, for May 19th.
Thank you, Your Honor.
Thank you. Have a good one.
Excuse me, Your Honor?
Yes, sir.
I had court on April 24th.
We need to give him a new date, Judge. We've been giving new dates when we release people.
Yeah, I'm giving May 19th. So if the courthouse is open, go to your April date. If it's not, you're coming in May 19th. Sound good?
All right.
All right.
All right. Thank you, Your Honor. Just making sure.
No problem.
Judge, may I call a case from the misdemeanor docket?
Sure.
This is going to be Clint Thomas on page 9 of Your Honor's docket, and Danielle Curtis is the attorney. He's at Conti.
Approaching, Your Honor.
All right, thank you.
Judge, my understanding is this is going to be a negotiated resolution.
Okay, great. Mr. Thomas?
Hey, what's going on, Your Honor?
Good afternoon.
Good afternoon, sir.
All right.
Oh.
Ms. Curtis,
Hello?
are you ready to address Mr. Thomas?
Hello?
I think they're having trouble
Hello?
hearing the judge.
I think,
I'm sorry about that.
no, that's okay. Good afternoon. How are you?
Can you hear Danielle?
I can hear you now.
All right. So,
Hi, Your Honor.
good afternoon. We're here on Clint Thomas. Mr. Thomas is on the TV screen right in front of me. And my understanding is this is going to be a negotiated resolution?
Yes, Your Honor.
resolve this case today because one of the offers does include probation, and probation is not currently doing any intakes. So we're not going to be able to resolve that today.
Wait a minute. Probation's not doing any intakes?
That's what I was told. Melissa told me that they.
That's news to me. I mean, my understanding, yeah, I mean. Sure. So what I would do is, for instance, if he resolved his case and there's a probation offer, one of the conditions of his probation is that he must report to the probation office on Oakland Park Boulevard and 441. And I'm going to say he must report within 24 hours of release. If he doesn't do that, he's already violated his probation.
Okay, perfect. Thank
Okay?
you, Your Honor.
Sure. So, State, can you tell me what the negotiations are?
Yes, Your Honor. For case number 183295MM40A, it is an adjudication, court costs, 6 months probation with the special condition of an 8-hour anger management course, a letter of apology to the victim, and no victim contact. And for case number 1811992MM10A, it is an adjudication, court costs, and no return.
I'm sorry, Your Honor.
Yes.
I just wanted to make sure I heard right for the case 180032959 408. For the probation, he was supposed to get time served towards that.
All right. Is that
No, Your Honor, those are not the notes I have.
State's telling me no?
He's
Okay,
entitled
I'm gonna go ahead and email the assistant Louis Garcia. He told me to reach out to him if there was any issue, Your Honor.
Okay, so what I can do is I can put that on recall. One other thing, because I just realized, I indicated that I'd be sending people to probation on Oakland Park. I don't know, where do they report for county probation? Right across the way? All right, what's the actual address over there? 540 Southeast 6th? Okay. Is it 3rd? Okay. So now that I've messed that all up, 540 Southeast 3rd Avenue. Okay. All right, so let's put Mr. Thomas on recall and until we get that straightened out, okay?
All right, Your Honor, thank you.
Thank you. All right, so now we're on Jean Baptiste, page 5. Paul Ryan.
Approaching, Your Honor.
Thank you. The motion I have in front of me is for an Arthur hearing, which we're not doing, but let me get Mr. Rotterman on the line. This is on Jean Baptiste on page 5.
Thank you for calling the law office of Glenn R. Rotterman. Your call is very important to us. Please remain on the line. Your call will be answered momentarily. calling the law office of Glenn R. Roderman. This is Alpona. How are you doing today?
I'm very good. How are you?
Okay, thanks for asking.
Great. May I speak to Glenn Rodderman? This is Judge Michael Lynch.
Okay, let me see here.
I'm calling because
Moment.
he's got a motion for bond set today. On
Motion for bond set? Okay.
yeah, on Jean Baptiste. So I'm calling from the courtroom. Okay.
BAPTIST?
BAPTISTE.
I'm sorry, the line keeps cutting out, so I just want to make sure I get the correct information.
It's Jean. It's listed as Jean Baptiste. BAPTISTE.
BAPTISTE, okay.
Yes.
Let's see here. May I have your last name, Judge?
Lynch. LYNCH.
LYNCH, okay. Just in case we're disconnected before connecting the call, may I have your phone number?
I'll have to call you back.
Okay. Give me
You're
one
on.
moment,
Yeah,
please.
you're in open on speakerphone in open court. Okay.
Oh, thank you. One moment, okay?
Sure.
Hello.
Mr. Rodman, good afternoon. This is Judge Michael Lynch. I have you on speakerphone in open court on the record. How are you?
Yes, hi, Judge. It's unusual to be practicing law, and I'm sure judging like this.
Yeah, it's a little strange. So I'm calling in regards to Jean Baptiste. Ms. Baptiste is on the television in front of me. Good afternoon, sir. How are you?
Good afternoon, man.
Okay. And Mr. Rodman, I've got this. It's titled a motion for bond Arthur hearing, which I didn't believe were being set on this docket.
They're not, Your Honor.
Okay.
I
Yeah.
I don't know, is there assistant state attorney also?
Maria
Yes.
Schneider on behalf of the state.
Yes. Maria Schneider is representing the state on this.
Yeah, hi, Maria. Good afternoon.
Good afternoon.
Okay.
Your Honor, yeah, initially I filed this motion, I guess about 2 or 3 weeks ago before all the, interference with, the virus and all. And, I met with my client and his family recently, and I was able to extract some information from him, which I thought would be relevant for the court's consideration in terms of a bond with whatever conditions are necessary. And if I can just give you like a 2 or 3 minute synopsis.
Judge,
that
we
would be
object.
wonderful.
This is an Arthur hearing. It's a first PBO.
Mr. Rodderman,
No,
so this docket, as I was informed, is strictly for bonds for nonviolent offenses, and this clearly would not be something that should be on this docket. So unfortunately, I'm not going to be able to address this motion today, okay?
Okay, yeah, I just didn't know because my assistant was telling me 3 or 4 different judges were handling it, and I, figured that, okay, well, I know that initially I was told that there was a bond set at the first hearing, which obviously would be unusual in a PBL, and there was some conditions that were also set at the first hearing as well, back, I believe, about a month ago, February 25th. So at that point, I realized, well, that's unusual. So I went ahead and filed a regular motion for bond reduction, and then, of course, I refiled it as an Arthur hearing, knowing full well that, the proof, evidence, presumption, grade was the standard, and the state would go forward. I would go forward, the state would go forward and either show it or not show it. But, so I understand your position, Your Honor.
All right, and Mr. Otterman, I appreciate that, but unfortunately, it's not going to be able to be addressed on this docket. So respectfully, I'm just, I'm not ruling one way or the other. I'm just deleting this from today's docket, okay?
Okay, all right. right, thank you, Your Honor.
Sure. Take care. Be safe.
Yeah, you too. Bye-bye.
Okay. So we're back on the misdemeanor docket. On page 9. And I'm sorry, where do we have?
Is it Conti?
Conti. All right, so we're back on Clint Thomas and just waiting for Mr. Thomas to get up to the podium.
Approaching.
All right, Mr. Thomas, good afternoon again.
Afternoon, sir.
All right. Okay, so the offer is 5 months probation?
It's 6 months with 10 years, so I don't.
Yeah, but I have to be able to give an amount of
So 5 months.
5 months. All right, so to be clear, the state's offer on 183295 MM40A is an adjudication, 5 months probation, court costs, special condition, 8-hour anger management, letter of apology, no victim contact. On the other case, which is 1811992 MM10A, the offer is an adjudication, court costs, no return.
Okay.
Well, hold on, I'm speaking to your attorney first.
Oh, okay.
Yes, Your Honor, that's correct.
Okay. All right. Mr. Thomas, best you can, raise your right hand for me. Swear to tell the truth, the whole truth, nothing but the truth.
Yes, sir.
All right, you can put your hand down. Please state your name, spell your last name for the record.
Clint Thomas, Clint Hillary Thomas, last name Thomas, Thomas.
All right, and my understanding is you'd like to resolve both of your cases today, is that correct?
Yes, sir.
All right, and the state made the offer that I just mentioned, but I'm going to say it to you again. On 183295 MM40A, the offer is an adjudication, 5 months probation, court costs, and the court costs with me are not a condition of probation on any of these. 5 months probation, special condition, anger management, 8-hour course, letter of apology, no victim contact. On case number case number 1811992 MM10A, the offer is an adjudication, court costs, no return. Is that your understanding of the state's offer?
Yes, sir.
Is that what you wish to accept to resolve both cases?
Yes, sir.
All right, how old are you, sir?
32.
Okay, how far did you go in school?
8th grade.
All right, you read and write English?
Yeah.
Have you had enough opportunity to discuss both cases as well as the offer with your attorney?
Yes, sir.
Has she answered all your questions for you?
Yes, sir.
And are you satisfied with her representation?
Yes, sir.
All right, very good. In case number 183295 MM40A, you're charged with battery. That's punishable by up to 364 days in the Broward County Jail. You understand the maximum penalty you're looking at?
Yes, sir.
All right, on 1811992 MM10A, you're charged with trespass of structure conveyance of first-degree misdemeanor, punishable by up to 364 days in the Broward County Jail. You understand the maximum penalty on that?
Yes, sir.
All right, the minimum penalty on each would be a withholding court cost. You understand?
Yes, sir.
Since I am placing you on probation on the one case, if you were to violate the terms of probation, the state could prove that it was a willful and substantial violation, you would still be looking at up to the maximum penalty. Do you understand?
Yes, sir.
Are you currently under the influence of alcohol, drugs, or medication?
No, sir.
Any history of mental health problems?
Not at the moment. No, sir.
All right. That was a joke, that first one you said, right?
Not at the moment.
Yes. Let me ask you again. Do you have any history of mental health problems?
No, sir.
Okay. Other than what I told you I was going to sentence you to, has anyone made you any promises or guarantees to get you to change your plea in these cases?
No, sir.
Has anyone threatened you or coerced you to get you to do this?
No, sir.
Are you doing this because you believe it's in your best interest to resolve your cases this way?
Yes, sir.
You understand, if you didn't want to resolve your cases this way, we would have a trial in either one or both cases. The state would have to prove your guilt beyond a reasonable doubt to a jury of your peers. But by entering these pleas, you're giving up your right to have those trials. Is that what you want to do?
Yes, sir.
All right, if you're not a U.S. citizen, taking these pleas will result in your deportation. You understand?
Yes, sir.
Also, if these offenses or any prior criminal offense are considered sexually violent or sexually motivated in nature, you subject yourself to involuntary civil commitment. Do you understand that?
What's that part? Involuntary civil
If you have any prior criminal history involving something of a sexual nature, you subject yourself to involuntary civil commitment.
Oh, no, I don't have that history, sir.
Okay, I have to advise every single person that. That's the only reason I'm telling you that, okay? But you
Yes, sir.
understand. All right. And, State, are you aware of any evidence that if tested for DNA would exonerate the defendant? Defense? All right. And, State, you have a factual basis? Defense, you stipulate for the purpose of the plea? All right. Based on stipulation of counsel, I find that there is a factual basis to accept the plea. Sir, how are you pleading to these charges?
I mean, what would be the...
You have three options. You can maintain your not guilty plea, you can plead guilty, or you can plead no contest.
All right, I plead no contest.
All right, I find the defendant is alert and intelligent. Pleas are entered freely and voluntarily with a knowing and intelligent waiver of his rights with the assistance of an attorney with whom he's satisfied. I'm going to accept the no contest plea on 18-3295 MM40A. I'm going to adjudicate you guilty. I'm going to place you on 5 months probation. Special condition, anger management course, the 8-hour. Letter of apology, I'm going to order that be done within 60 days. And no victim contact. I'm also assessing court costs that will not be a condition of probation. On 18-11992 MM10A, I'm going to adjudicate you guilty, order no return, and assess court costs. Anything else, State? Defense?
No, Your Honor.
All right, sir, you have 30 days to appeal. If you can't afford an attorney, I'd appoint one for you. Good luck to you, sir.
All right, thank you, guys. Thank you, Ms. Daniel.
I'm going to give everyone a year.
Judge, next, if I may call Henry Flores on page 9 of the misdemeanor docket. He's at Conti, and it's attorney Benny Epps who will be handling it.
Okay.
It's a misdemeanor. I think we're just going to try to cycle through the misdemeanors.
Good afternoon. How are you?
Good, thanks, guys.
All right, and this is on Flores on page 9. Ms. Flores, good afternoon.
Good afternoon.
All right, and we're here. I don't have the motion in front of me. I was just given the misdemeanor docket, so let me know. I can pull it up, which I'm going to do right now, but you can tell me what you want me to consider, sir.
Well, Your Honor, Mr. Flores is essentially in on a violation of probation. He tested positive for alcohol 2 months into the probationary period and is in custody at this point. The reason we're in front of you today is he wasn't able to be present at the prior motion hearing, so he reset for today. Mr. Flores, if he were released, which is what we're asking for today, if he were released on his own recognizance, he would, as a home he could go to, would be able to live with his parents in West Park, Florida. They would welcome him back with open arms and have actually sought out the opportunity to get him to come back to stay if he were released. He's lived there for 24 years, and so that wouldn't be an issue as far as a place to go and pre-trial release conditions were to be imposed. He's got parents, as I said before, brothers, brother-in-law, lots of family that would be able to support him in anticipation of his release. Very active in the church, and as far as employment is concerned, he was the supervising manager of an AC factory, which he's not certain that he'll have that job to go back to. One, because the factory is closed at this point, or shut down because of the situation that we find ourselves in with the coronavirus, but also because he's been in custody at this point for 38 days, and so there may be some problem or issue as far as that's concerned once the factory does open back up, but they're not even sure when that's going to take place. So as far as failure to appears, he's had no issue with that in the past, and has stated that he would keep in touch with both the court and myself just to make sure that everything goes along as it should and he doesn't miss any future court appearances.
And Judge, if I may just inquire briefly, Jennifer Edgley, Chief Assistant Public Defender, will the court consider a proffer of all of these ties of community and other facts so that we don't have to go back and forth with getting testimony on the record?
Sure.
Thank you, Judge.
All right, and State?
Good afternoon, Your Honor. Will Resnick on behalf of the state.
Good
The state
afternoon.
would be objecting. Again, this was heard in front of Judge Solomon, and she denied the motion from the defense. And that was based on the fact the defendant has a 2008 DUI. And on the facts of this case, Your Honor, he was found passed out on a step with numerous open containers in front of him. The officers gave him a chance to take a taxi home. They then found him stopped at a red light. He refused to do field sobriety exercises, and at the BAP facility blew a .29 and a .31. And again, as defense stated, Your Honor, he tested positive for alcohol, which is the basis of the violation on probation. Therefore, Judge Solomon set this for a final BOP on May 15th. So at this time, Your Honor, based on the reasons stated, the state would be objecting.
Give me one moment here. On a few of these, I had received emails from the judges on a couple of the misdemeanors, and on Mr. Flores, my understanding is that Judge Solomon indicated if you found a program for Mr. Flores that she would ROR. What program have you found?
Haven't been able to find one just yet, Your Honor.
All right.
Judge, if the court would be inclined to send him to a program, we would just ask to delete it from the docket instead of the court denying the motion, and then we can reset it, if that would be.
All right. I think that probably makes the most sense. Judge Solomon obviously is in a better position to know about Mr. Flores than I am right now, and I think that would be a good thing for Mr. Flores to have that program in place. So I'm going to go ahead and delete this from the docket, and if you'd like to reset it once you find a program, you may, okay?
Thank you, Your Honor.
All right. Thank you. Thank you, Mr. Flores.
Next, Judge, we have Leopoldo Pando Gonzalez. He's at Conti, and this is attorney Ari Robinson on page 10 of the misdemeanor docket.
Approaching, Your Honor.
Okay. All right. Is this Mr. Pando Gonzalez?
Pando González, yo no hablo inglés, señor.
Okay. Un momento. Before I'm calling interpreters, do we have?
Right.
Okay, that would be great. And which attorney is going to be handling this?
This is Ari Robinson.
Okay.
Ms. Robinson?
Hi, yes, good afternoon. It's actually gonna be Ms. Belkis Guerrero actually covering for me. She's getting the division, so she wanted to handle this with me, just being on the line as well.
Okay.
Good afternoon, Judge.
Good afternoon. How are you?
Good, and yourself?
Good. All right. Let me see if I can get an interpreter. Try the next one.
Just so you have a heads up, the interpreter cases.
Good afternoon. May I speak to Ms. Sands, please?
This is Solange Sands. How are you?
Very good. This is Judge Michael Lynch. I have you on speakerphone in open court on the record. How are you?
Wonderful, Your Honor.
Excellent. I have defendant Leopoldo Pando Gonzalez. We're doing the bond motions in the magistrate courtroom, and I was hoping you could assist in interpreting.
I'll be happy to, Your Honor, of course.
Excellent. And obviously, not in the traditional fashion, but I'm going to swear you in over the phone. Do you swear to interpret from English to Spanish, Spanish to English to the best of your ability?
I do. Solange Sands, Your Honor, Saenz.
Okay. And we're on page 10, Leopoldo Pando Gonzalez. And we're set for a bond motion.
Very good.
All right.
Señor González, están haciendo una petición para su fianza.
Okay.
Okay.
All right. And defense,
Yes, Judge.
what would you like me to consider?
Judge, this morning I did speak to Mr. Gonzalez and I informed him that earlier in March, Judge Brown had reduced his bond and there was an order entered. I did inform Mr. Gonzalez of this information this morning. And he
I need you to slow down, speak up, because we also have the interpreter. So let me stop you there. Were you able to get all that, Ms. Sands?
I was not. Interpreter was able to hear that there was an earlier bond motion in March.
Okay. Defense.
I apologize, Judge.
It's okay.
This morning I did speak to Mr. Gonzalez.
Hoy por la mañana hablamos con el señor González.
And I informed him that earlier in March,
Le dejamos saber que anteriormente en marzo,
Judge Brown signed an order
la jueza Brown había firmado una orden
reducing his bond to $1,000.
y eso era que le cambiaban la fianza a $1,000.
I also confirmed with his previous public defender.
También confirmé con la persona que estaba ahí para el defensor público,
Ms. Addie Robinson,
la señora Annie Robinson,
and Mr. Gonzalez understood.
y dijeron que el señor González entendió.
In addition, Mr. Gonzalez explained.
I'm sorry, interpreter did not hear that part.
And in addition, Mr. Gonzalez explained.
Y entonces, adicionalmente, el señor González explicó
That he had the funds available
que él tenía ese dinero disponible
to post bond.
The last thing that was said was to post bond.
Thank you, Your Honor.
Sure.
Y tenía el dinero disponible para pagar esa fianza.
And I apologize, Judge.
Eso es todo, señoría.
See you soon. Bye.
Also, Judge, I have some information regarding his ties to the community whenever you're ready.
I'm ready.
También de parte de la defensa tenemos información que tiene que ver con los vínculos que tiene el acusado en la comunidad.
Judge, at this time, Mr. Gonzalez lost his job. However, he did indicate that he had the funds.
For the interpreter, the last part, he
He had the funds.
He had the funds. In addition, he has a son and his parents residing in the county as well.
An interpreter cannot hear the defense. Sorry,
Okay,
Your Honor.
that's all right. Can you, and I'm sorry, I know we're all trying our best here. Just if you could speak up as loud as you can. And repeat that last part about the kids.
Sorry, Judge?
The interpreter didn't hear what you had, the last statement you made in regards to the defendant's children.
That he has a son and his parents residing in the community.
Interpreter made out something about a son and parents. That's all, Your Honor.
He has a son and parents living in the community.
Thank you, Your Honor.
Sure.
La defensa ha dicho que el señor ha perdido su trabajo, pero que tiene dinero disponible, tiene un varoncito y tiene sus padres también que viven en la comunidad.
Anything else from the defense?
¿Algo más de la defensa?
And she responded, not at this time.
Nada en este momento.
All
Thank
right.
you, Your Honor.
State.
I spoke to the ASA assigned to this case.
Hablamos con el fiscal que está asignado con este caso
And he asked that the bond that Judge Brown set remain in place at $1,000.
y ha pedido que la fianza que pidió la jueza Brown quede vigente, serían los $1,000.
Judge Brown already heard this motion and reduced the bond from no bond to $1,000.
La jueza Brown ha escuchado esta misma petición, cambió la decisión de no darle fianza a darle esta fianza de $1,000.
Okay. And I'm sorry, defense, the one thing I didn't catch was there, what was the monetary amount that he could come up with, or is he's not able to come up with anything?
Y para pregunta de la defensa de la señoría, no sé si han dicho eso anteriormente, pero ¿cuánto se le haría posible pagar, si puede pagar algo?
Okay. And I'm sorry, defense.
De la defensa.
Judge, Mr. Gonzalez indicated that he can post bond. Yes, he can.
Judge, may I inquire of Mr. Pando? I
Yeah.
think there's...
Yes.
Mr. Pando, can you hear me?
González dice que sí, que puede pagar eso.
Sir, can you hear me?
Señor González, ¿me escucha?
Okay. Do you have money in your property or a form of payment in your property that you can post the $1,000 bond?
Señor González, usted ahí en la cárcel, en lo que tiene guardado, ¿usted tiene algunas pertenencias o tiene disponible efectivo para pagar esa fianza de $1,000?
No, yo tengo que llamar a mi hijo para que él me haga el pago.
I'm going to have to call my son so he can pay it for me.
So, Judge, he's not able to post bond at this time.
Okay.
Así que no puede pagar en este momento.
All right, so let me ask, then, defense, what you're asking me for is an ROR on this.
Así que entonces la defensa quiere que quede en libertad bajo su propia palabra.
Okay, and defense said yes, Judge.
Y la defensa ha dicho que sí, señoría.
All right, and he's still on probation on this case, correct? This is a pending VOP?
También está bajo probatoria porque tiene una acusación pendiente de no cumplir con probatoria.
All right. Over state's objection, I'm going to ROR Mr. Pando Gonzalez.
Así que, denegando la objeción del Estado, vamos a permitir que el señor González quede en libertad bajo propia palabra.
And I'm going to order that he report to probation within 24 hours of release.
Queda ordenado que tiene que reportarse con probatoria dentro de las primeras 24 horas después de quedar en libertad.
And he must continue to follow all the rules and regulations of probation.
debe seguir haciendo todas las reglas y regulaciones de probatoria.
And I'm going to set a status on May 19th.
Y vamos a tener una audiencia de evaluación el 19 de mayo.
All right. Anything else, defense?
¿Algo más de la defensa?
Judge, also, I did speak to Ms. Robinson and, Mr. Gonzalez has completed all terms of his probation.
Hablamos con la señora Robinson que nos dejó saber que había completado todo lo que tenía que ver con probatoria.
Ms. Izquierdo, we can address that later. Yeah, he's getting released.
Okay. So he'll be ROR'd.
Muy bien, entonces queda en libertad bajo propia palabra.
You know what, since it's set a little bit out, let's leave that May 11th date.
Y entonces queda la próxima fecha 11 de mayo.
All right. And Mr. Pando Gonzalez,
Señor Pando González,
you must report on, you said May 11th? Yes. On May 11th in front of Judge Brown, 9 a.m.
usted va a volver a la corte el 11 de mayo, se va a ver con la jueza Brown, eso hasta las 9 de la mañana.
Okay?
Okay.
All right.
Okay.
All right. And Ms. Sands, before we let you go, are there any other Spanish interpreter cases that are ready?
¿Alguien más que necesita ayuda de la intérprete?
Yes, Judge. We have Jose Rodriguez on page 15 of Your Honor's docket, and that is, he's at Conti with Rachel Gibbert, the attorney of record.
Let me ask a question because I was informed that I guess previously we've used, is it the PD phone with the interpreter, and that might make things easier? All right, my only concern is then I won't be able to hear either. I don't think there's a situation where we can all hear really well. So we're gonna make do. We've got what, 2 more Spanish interpreter cases that we think we have?
All right.
Hello, Your Honor. I'm Gustavo Martinez. I just wanted to advise the court I will speak on the Spanish interpreter.
Yes, sir.
3 of my cases may require a Spanish interpreter. Just letting the court know.
Okay, so we're just talking 3 on the misdemeanors. All right, thank you, Mr. Martinez.
Oh, okay. My apologies. Just letting you know. Thank you.
No, I appreciate it. Thank you. All right, so now that I've thrown myself off here, I apologize. What case, what's the next one with the interpreter?
Judge, that is Jose Rodriguez on page 15 of the felony docket. He's at Conti, and attorney Rachel Gibbert is the attorney of record.
All right.
Your Honor, he's at Paul Ryan facility, Jose Rodriguez.
He's at Paul Ryan? Okay. All right.
He's approaching, Your Honor.
Thank you. All right, and Ms. Sands, our next case is Jose Alberto Rodriguez, which is case 18-7102 CF10A on a motion for ROR.
Thank you, Your Honor.
Sure.
Good afternoon, Judge Rachel Gibbert for the record.
Good afternoon, how are you?
I'm fine, how are you?
Very good. I have the motion in front of me. He's currently being held no bond, and I guess he was originally ROR'd, correct?
It's a date hold that's holding him no bond.
Estamos aquí para petición para darle fianza. Tenía en este momento una orden de no posibilidad de fianza de parte de Miami-Dade. Anterior había tenido libertad bajo palabra.
Okay. All right, defense.
Judge, at this time, we're requesting for Mr. Rodriguez to be released either ROR or on pretrial release.
Señoría, en este momento la defensa pide que el señor Rodríguez consiga libertad bajo palabra o que quede en supervisión, en el programa de supervisión previo a juicio.
Attention officers, staff, again, if you're connected to keys or radio, please be kind enough to return to ground control at this time. Thank you.
Okay.
May I continue?
You may. Yes. Yeah, you may.
He's presently charged with 2 counts of uttering a forged instrument and a grand theft, both non-violent third-degree felonies.
En este momento las acusaciones son 2 acusaciones de delito mayor de entregar un documento o un cheque falsificado y o también hurto de grado mayor, son delitos graves de tercer grado.
He does have a pending hold out of Miami-Dade County for a pending case there. It's not a probation case or anything of that sort over there.
Interpreter was unable to hear.
All right. I'm sorry. I need you to speak up as loud as you can.
He also has a pending hold out of Miami-Dade County for a pending case over there. It's not a violation of probation from my understanding.
También tiene una orden de detención de parte de Miami-Dade, tiene otro caso pendiente, pero no creemos que tiene que ver con no haber cumplido con probatoria.
So she's been in custody now in Broward since October 9th, 2019.
Ya ha estado encarcelado en Broward desde el 9 de octubre del 2019.
He was brought over from Miami-Dade by an order that was signed by Judge Casey.
Unable to hear.
He was brought over from Miami-Dade due to an order that was signed by Judge Casey.
Thank you. Y lo enviaron a Broward por una orden que firmó el juez Casey.
So at this time, we're asking the court to allow him to be released on pretrial, whether it's standard pretrial, he can check in.
Así que por eso pedimos que por lo menos quede bajo supervisión previo a juicio. Pueden ser las condiciones normales de ese programa, donde él tiene que ir y reportarse.
Because I'm unaware as if whether or not out of counties are picking up defendants at this time.
En este momento no sabemos si los condados están enviando personas a venir a buscar a las cárceles para transferirlos a los otros condados.
All right, the indication I'm getting is that they are not picking up.
De parte de la señoría nos están dejando saber que de hecho no vienen a buscar a las personas a otros condados.
And Judge Tudor and Judge Siegel have been empowered to address these cases, so we can make note of it and get this before them.
Okay, that was, I'm sorry, I'll let you interpret first.
Sabemos que el juez Siegel y el juez Casey también están a cargo.
All right, that's what I was going to inquire, because obviously if I ROR, he's still got the hold from Miami, so then that would have to be addressed in front of either Judge Siegel or Judge Tudor.
Entonces, ya que tiene la orden de detención de Miami, aunque yo diga que quede en libertad bajo palabra, va a tener que presentarse con el juez Siegel, el juez Tudor, para ver sobre esa detención.
Okay. Anything else from the defense?
Not at this time.
Algo más de la defensa, nada más.
All right, State.
Yes, Your Honor, he has a Miami-Dade hold. We have not heard from Miami-Dade that they are willing to release that hold. It is for burglary of an occupied dwelling. The gentleman qualifies as a habitual offender. He has been declared to be a habitual offender in the past. He has multiple priors, possession of a firearm by a felon, dealings in stolen property, burglaries.
1 second for the interpreter, please.
I'm sorry.
De parte del Estado, vamos a dejarle saber a la señoría que sí tiene esa orden de detención de Miami-Dade y no hemos escuchado nada de Miami-Dade dejándonos saber que quieren que quede en libertad. El señor tiene una acusación pendiente en Miami-Dade de allanamiento de un lugar o una casa. Y es una persona que es con conocida o que ha sido designada un delincuente habitual anteriormente y tiene muchísimos antecedentes penales.
And when I say he's got a lot of priors, I mean, I'm talking like 20.
Y cuando decimos tiene muchos antecedentes, estamos hablando de más de 20.
Okay, what I'd like to hear about are violent felonies.
In terms
Bueno, mejor vamos a hablar solo de si tiene delitos graves violentos.
in terms of violent felonies, Your Honor,
Lo que tiene
No sé yo.
tiene que ver antecedentes de delitos graves con comportamiento violento.
No.
other than misdemeanor batteries, and the other thing that would cause us great concern is possessions of firearm by felon. But I don't see any actual, other than burglaries, which are considered violent offenses, I don't see any actual violent offenses.
Okay.
Lo que tiene que ver serían delitos menores, pero sí tienen que ver con posesión de o portar un arma de fuego por una persona ya condenada de delitos graves.
Okay. So, now, defense, this is what I would do. I'm willing to overstate subjection to ROR to standard pretrial, although I don't know what's going to happen, whether they're going to release that Dade County hold. Since you don't know what's going to happen with that, rather than ROR, do you want me to set a nominal bond of $1 on each count so that they're getting credit for time served while they're in?
Yes, Judge,
Entonces,
that
para
will
la
work.
defensa le vamos a preguntar, parece la señoría estaría dispuesto a darle libertad bajo palabra, pero tendría que reportarse con el programa de supervisión previo a juicio. Eso no quiere decir que le deje en libertad o que Miami-Dade permita que quede en libertad. Así que lo que podríamos hacer, en vez de darle libertad bajo palabra, darle fianza de $1 para cada de los cargos, y así, si está en la cárcel, está corriendo tiempo cumplido en la cárcel.
Okay. Would you like me to do that? Okay.
¿Hacemos eso? Okay.
All right, so I am going to grant the motion. I'm going to set bond in the amount of $1 on count 1, $1 on count 2, condition of bond, standard pretrial release.
Así que aceptamos la petición. Lo que vamos a dictar es $1 de fianza al cargo número 1, $1 de fianza al cargo 2, y tiene que reportarse bajo la supervisión normal del programa de supervisión previo a juicio.
Judge, I just want the record to be clear that we are not doing anything with the Dade County hold. I don't want the jail to get the misimpression that we are releasing that hold. I am not authorized to do that.
Absolutely.
Que conste en el acta que, para que le quede bien claro a la cárcel, que no estamos quitando la orden de detención de parte de Miami, no queremos que se confundan, absolutamente.
I don't have any authority to address the Dade County hold. That would have to be either the Dade County judge or Judge Tudor or Judge Siegel.
La señoría no tiene ningún tipo de autoridad para quitar esa orden de arresto de Dade. Así que eso tendría que ser una decisión del juez de Miami-Dade, o si no, el juez Siegel o el juez Tudor.
Okay. Does he have a future date coming up?
Y vamos a ver si tiene esa fecha para volver a comparecer.
All right. So I'm going to give a status date of May 19th.
Vamos a darle fecha para regresar a audiencia de evaluación para 19 de mayo.
Okay, so sir, you must appear in front of Judge Casey and on May 19th.
Así que caballero debe volver a la corte, comparecer con el juez Casey el 19 de mayo.
Okay.
All right.
Okay.
All right, thank you. Thank you.
Gracias.
You're welcome.
Okay. Well, yeah, I already knew to, so that some of these ones I might put them on the I got you. Thank you.
Your Honor, do you need anybody else from Fall Run?
Who do we want next?
So I'm ready to address Marquise Jackson.
Oh wait,
page-
let me let the interpreter go. I didn't know if we were doing any other.
You know what, Judge? I don't believe we have any other interpreter cases. Do you have any other than the one that we called? I think we're good, Judge.
All right.
As far as I know.
All right, Ms. Sands, thank you very much.
My pleasure, Your Honor. Stay safe. Have a wonderful day.
You too. Take care. Bye-bye.
Thank you. Bye-bye.
Okay, I'm sorry.
No problem, Judge. If I may address Marquise Jackson, he has cases on page 3 and page 7 of the misdemeanor docket. This is going to be a global resolution,
Okay.
and Ms. Siegel will be handling this case.
Okay.
This is for Marquise Jackson on the misdemeanor docket. Yes, this was the plea. There's two, case number 19-111-144 MM10A. The second one is 20-2315 MM10A. It's also on the afternoon misdemeanor docket as well.
On that 19-11144 can someone tell me what the charges are, because it doesn't list them on this docket that I have?
Your Honor, good afternoon. This is Kimberly Siegel on Mr. Jackson's behalf. That is a violation of probation for a violation of an injunction charge.
Okay.
So that's actually going to be a probation plea, Your Honor,
Okay.
which will be reinstated. And then the other one is just a plea on 2 battery charges that are not domestic violence related.
Oh. North Broward. All right. And Ms. Siegel, just give us 1 second while we get Mr. Jackson up here. And while we're getting Mr. Jackson, State, you want to tell me what the negotiations are?
It's reinstate 12 months probation, no previous citizens, 90 days Broward County Jail with a mental health evaluation and follow-up from Henderson, no witness contact.
Okay, well, all right, so on the probation case, he was on probation, so it can't be a reinstate to a full 12 months because he's served some probation. Sure.
Your Honor, he is also going to be getting credit for 73 days time served, which will also affect his probation.
Okay.
He applied the probation on January 15th of 2020. The warrant was signed on March 17th of 2020. It was a failure to appear at probation, so he didn't spend any time on probation, but he was put on it January 15, 2020, and his time in on this case is 73 days.
All right, so he's done about 2.5 months, so I can, was he originally on 12 months probation, Ms. Siegel?
Yes, he was, Your Honor.
All right, so what I can do is I can reinstate him to the same term that he was already on, with the special condition of the 90 days Broward County Jail, which he's gonna be getting credit for, what was that, 73?
That's correct, Your Honor.
Okay, adding, all the other terms and conditions would remain in effect, but he's also to get a mental health evaluation at Henderson and any follow-up, correct?
Your Honor, that was his previous offer as well.
Okay, so the probation case is just a reinstate, modify, add the condition of 90 days jail, with credit for 73.
That's correct, Your Honor, and we're gonna be asking the court for a court order. I would like him released with 10 days worth of the medicine that they have him on now in custody, please.
Okay, that's not a problem.
I prepared an order this morning, so the clerk should have it.
Okay,
Thank you,
great.
Judge.
All right, and then in regards to the 2 misdemeanor battery counts, which is 20-2315 MM10A, State, what's the negotiation on that?
So there's see a note from the ASA, it says, global plea offer with 20-2315 MM10A, revoke probation, 9 months, inpatient Henderson, no witness contact.
Wait, I thought isn't the 20, okay. So
It's running concurrent, Your Honor. It was a global offer running concurrent with the offer I just gave you.
All right, so probation case is the reinstate that we discussed. The new law offense is the 2 battery counts. Let's start there. That's gonna be an adjudication?
Yes, Judge.
Okay, and it's gonna be a term of probation, correct?
Yes, Judge, 9 months.
9 months probation. That'll run concurrent with the other case?
Yes, Judge.
All right, and what were the special conditions on the 20 case?
The same as the get a evaluation at Henderson, I'll follow up treatment, no witness contact.
Okay. All right, and we still don't have Mr. Jackson in North Broward, please.
Approaching.
Thank you.
All right, thank you. Bye.
Jackson, good afternoon. How are you?
Good afternoon, Mr. Your Honor. Hey, how you doing?
Very good. Give me one moment.
Yes, sir.
All right, Mr. Jackson, raise your right hand for me. You swear to tell the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Please state your name and spell your last name for the record.
Marquise Jackson, Marquis, Jackson, Jackson.
All right, and my understanding is you'd like to resolve both of your cases, the violation of probation as well as the new law offense. Is that correct?
Yes, Your Honor.
All right, and the state's made the following offer. On the violation of probation case, if you admit you violated, I'm going to reinstate with the same terms and conditions, but I'm going to modify and add the term of 90 days Broward County Jail with credit for 73 that you've already served. On the new law offense, which is 202315 MM10A, the state's offer is an adjudication, 9 months probation to run concurrent or at the same time as your other case, special condition, mental health evaluation at Henderson and any recommended follow-up, and no victim contact. Is that your understanding of the offer?
Yes, Your Honor.
And is that what you wish to accept to resolve both cases?
Yes, Your Honor.
All right, how old are you, sir?
I'm sorry.
That's okay.
I'm 30.
All right, and how far did you go in school?
Broward College.
Okay, and do you read and write English?
Yes, sir.
Have you had enough opportunity to discuss the violation as well as the new law offense with your attorney?
Yes, Your Honor.
Has she answered all of your questions for you?
Yes, sir.
And are you satisfied with her representation?
Yes, sir. Always.
All right, very good. Starting with the probation case, which is 19-11144 MM10A, you were originally placed on supervision for violation of a domestic violence injunction, which is punishable by up to 364 days in the Broward County Jail. You understand the maximum penalty on that?
Yes, Your Honor.
All right. On your other case, which is 202315 MM10A, you're charged with 2 counts of battery. Those are each punishable by up to 364 days in the Broward County Jail. You understand the maximum penalty on those?
Yes, Your Honor.
All right, the minimum penalty would be a withholding court cost. Do you understand?
Yes, Your Honor.
All right, since I am putting you back on probation, if you were to violate the terms of probation and the state can prove that it was a willful and substantial violation, you would still be looking at up to the maximum penalty. Do you understand?
Yes, Your Honor.
Okay, are you currently under the influence of alcohol, drugs, or medication?
Medication.
Okay, and is that medication to help you with some of your mental health issues?
Yeah, it's to help me, Your Honor.
Okay, is there anything about either the medication or your mental health issues that would cause you to not understand what we're doing here in court today?
No, sir.
Okay, and do you believe you're of a clear and sound mind to make this important decision?
Yes, sir.
And,
Yes, Your Honor.
all right, and Ms. Siegel, any concerns about competency at all?
No, Your Honor.
Okay, for the record, I don't have any concerns about competency for Mr. Jackson, but Mr. Jackson, if you're having any difficulty during the plea, you're going to let me know, right?
Yes, sir.
All right, very good. Other than what I told you I was going to sentence you to, has anyone made you any promises or guarantees to get you to admit you violated probation as well as to change your plea on the new case?
No, sir.
Has anyone threatened you or coerced you to get you to do this?
No, Your Honor.
Are you doing this because you believe it's in your best interest to resolve both cases this way?
Yes, sir.
You understand if you didn't want to resolve your cases this way, on the violation of probation, we would have a final hearing. The state would have to prove that you willfully and substantially violated the terms of your supervision. But by entering this admission, you're giving up your right to have that hearing. Is that what you want to do?
Yes, sir.
All right, on the new law offense, if you didn't want to resolve your case this way, we'd have a trial. The state would have to prove your guilt beyond a reasonable doubt to a jury of your peers. But by entering this plea, you're giving up your right to have that trial. Is that what you want to do?
Yes, sir.
All right, if you're not a U.S. citizen, taking these pleas will result in your deportation. Do you understand?
Yes, sir.
Also, if these offenses or any prior criminal offense are considered sexually violent or sexually motivated in nature, you subject yourself to involuntary civil commitment. Do you understand that?
Yes, sir.
All right. And in regards to the new law offense, State, are you aware of any evidence that if tested for DNA would exonerate the defendant? Defense?
DNA? No, sir.
All right. And I got no from the defendant, and do I have no from defense?
No, Your Honor.
Okay. And State, on the new law, you have a factual basis? And defense, you're stipulating for the purpose of the plea?
Yes, Judge.
All right. And, sir, in regards to the new law offense, how are you pleading? Guilty, not guilty, or no contest?
No contest, Your Honor.
All right. In regards to the violation of probation, I'm going to read the allegations to you. Allegation 1 is that you committed the offense of battery on March 12th, 2020 at 4180 Southwest 21st Street in the city of Fort Lauderdale, Broward County, Florida. Allegation 2 is that you committed battery on March 12th, 2020 at 4180 Southwest 21st Street, apartment B, in the city of Fort Lauderdale, Broward County, Florida. Allegation 3 is you were instructed by Judge McHugh on January 15th, 2020 to report to BSO probation, and that as of March 16th, 2020, you failed to do so. Are you admitting you violated probation in those 3 ways?
Yes, sir.
All right, I find the defendant is alert and intelligent. The pleas are entered freely and voluntarily with a knowing and intelligent waiver of his rights with the assistance of an attorney with whom he is satisfied. Starting with the violation of probation case, I'm going to accept the admission. I'm going to reinstate with the same terms and conditions, but I am going to modify and add the condition of 90 days Broward County Jail, credit for 73 that he's already served. On case number 202315 MM10A, I accept the no contest plea. I'm going to adjudicate you guilty. I'm going to place you on probation for 9 months. I'm going to order that you get a mental health evaluation at Henderson and any recommended follow-up. I'm also going to order that you have no victim contact. And I signed the order ordering the jail to give 10 days worth of medications to Mr. Jackson. And anything else, State?
Thank you, Your Honor.
Thank you. Anything else, defense?
I just don't know that I heard the word, maybe it's over this computer, but it's running concurrent.
It's running concurrent.
Thank you.
Okay, so Mr. Jackson, you have 30 days to appeal. If you can't afford an attorney, I'd appoint one for you. Good luck to you. And he's going to need to report to probation upon his release. So, sir, you must report to probation within 24 hours of your release, okay?
Okay, is there a way that I can, because I don't have any transportation, I heard that the buses are running free. Like, do you think there's maybe a way I could probably get like a ride, but I mean, I'm just saying, if the buses are not running free.
All right, sounds like he's being told, and I'm getting the thumbs up. So it sounds like you'll be able to get home, sir, okay?
Yes, sir.
All right, good luck to you, Mr. Jackson.
And Judge,
Thank you.
Thank you.
I just heard from Richard Williams, who's one of the in-court probation folks for BSO, that they are not open to the public, BSO probation. He did give me a phone number. I don't believe this should delay anyone's release, but obviously there's no place, even if they go there, they're not going to let anyone in. So I do have a phone number for them to call, but that's the best that I have, the information that I have.
Okay, how are we going to do this?
I think we just give them the phone number.
I'm gonna take the number down, Your Honor.
All right, can you tell me what that phone number is?
It's 954
Yep.
765 5123.
Okay. All right, did you get that, or do you need that repeated, sir?
Actually,
I got it.
You got it?
954-765-54123.
5123, yes.
Okay.
Okay, so I'm gonna order that you call that number within 24 hours of release.
Yes, sir.
Okay?
and Judge, I was actually just given a different number for their intake department. I do apologize.
That's okay.
It's just a live
Yeah, no,
issue that's
I gotcha.
evolving. This is the intake department, and it's 954 357 5904.
Okay. So that's the number that everyone should call,
Yes,
correct?
that's correct.
Okay. So forget that last phone number. And Mr. Jackson, I believe that deputy is helping you out there writing that down. So to confirm, it's 954-357-5904, okay?
Okay.
One last thing,
Yes.
based on his statement about free buses, will you please waive the cost of supervision in both cases?
I'm waiving the cost of supervision on both cases.
Thank you and be well.
You too. All right, thank you.
Thank you.
Thanks.
Thank you, Ms. Siegel.
Next, Judge, we have Joshua Edwards. He's also at North Broward with, I believe it's Attorney Ari Robinson, but it may be Ms. Izquierdo.
Okay, is that on, which docket is that?
Who's the next one?
Is
Joshua Edwards,
misdemeanor docket.
page 10.
Approaching.
All right.
Joshua Edwards. Joshua Edwards. Josh Edwards.
All right. Mr. Edwards?
Good evening, sir.
Good evening. How are you?
All right.
Good. All right. So, Mr. Edwards, is this, I don't have much information. I have the charges on this one at least, but is this a motion for ROR?
Yes, sir.
Yes, Your Honor.
All right. And I did note, so is it, right now he's got $1,000 bond on the battery, is that correct?
Yes, Your Honor.
Okay. And what would you like me to consider defense?
Judge, at this time, I would ask the court to please consider the fact that, Mr. Edwards, is not in jail for a violent offense. In addition, he's unable to post, bond at this time. And if we are concerned with COVID-19, I would be asking the court to please consider to release him to prevent any exposure to the virus.
Okay, and just for everyone who's listening in, I am taking notice of the pandemic, so we don't need to talk about, unless there's a very specific issue, just to save you guys the time. We don't need to do it on each one. I'm well aware of the pandemic. So, okay, and State, what's your position?
Touched the victim in her area, right down the thigh, and then was holding his erection with his hand in front of the victim.
So this motion was already addressed March 18th?
Yes, Your Honor.
And the reason why we're here, Judge, is because none of our clients were brought to the courtroom because the courthouse was closed. So we are doing rehearings today with our clients present.
Understood.
Yes.
That clarifies some things for me. Okay, very good. All right. What's his prior criminal history look like?
He has a 2018 MO possession of controlled substance with 2015 felony battery with hold consisting of 9 with hold, false statement, law enforcement officer with hold. 2014, two counts of battery. He received withholds, 2013 disorderly conduct adjudication, DUI adjudication, petty theft withhold, 2011 DWLS withhold, including stolen property withhold, and the 2009 motor vehicle adjudication.
All right.
Excuse me, Your Honor.
Yes, sir.
Mr. Edwards?
Mr. Edwards, I'll tell your, I'm gonna let your attorney advise you as well, but I'm gonna tell you that every single thing we're saying here is being recorded, it's on the record. A lot of times people say things that they think will help them out, and sometimes it can really hurt you. So I wouldn't talk about anything about the facts of the case, but if there's something you'd like to say to me after your attorney advises you, by all means.
Mr. Edwards, we're advising you not to say anything about the case, okay? Your attorney has it. Let her handle it, okay?
All right.
Okay. All right.
Is there an offer on this case, by the way?
Is he interested in resolving?
Mr. Edwards, did you hear that offer?
No, I didn't hear it.
All right, Mr. Edwards, so the offer is if you want to resolve your case, an adjudication, 12 months probation, special condition that you have no contact with the alleged victim in this case, and also that you get a mental health evaluation and any recommended follow-up. Is that something that you'd be interested in resolving for?
Is there any way we could do it without the probation?
State, are you offering a non-probation offer? All right.
Just for the record, I'm sorry, Judge, on count 2, will be the same offer, concurrent, the same special conditions.
All right, I must have looked at something, I must have been incorrect. You filed count 2? Okay. Okay.
So, but with the free processing, is there a way that I can like get time served for being in here? I mean, if you almost 13.
And Judge, he has 114 days in. I would just ask that the offer be time served. I'd invite the court into the negotiations.
Let me take a look at it.
My tablet keeps dying. And Judge, I'm getting word from Ari Robinson, who's able to appear if she needs to, that the offer was actually supposed to be a time-served offer upon completion of an evaluation, but that evaluation can't take place at the jail, so we would just ask for time served with instructions to go to Henderson and complete the evaluation.
Okay.
Even with the charges, and it might be a little bit complicated to understand, even with the charges being dropped to just 2 counts of simple battery, on those two you have $1,000 each. It's that, it's from felony charges to the charges that were, when this case started from the beginning, as felony charges.
I'm not comfortable making a non-probation offer. I want him to get the evaluation done. If he wants to accept it, I've been invited into negotiations. I'd offer an adjudication, 6 months probation, same special condition, mental health evaluation, any follow-up, and no contact. Does that interest you at all, Mr. Edwards, if I reduce the probation from 12 to 6?
Yes, sir.
Okay. All right, Mr. Edwards, raise your right hand for me. Swear to tell the truth, the whole truth, nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your name, spell your name for the record.
Joshua Edwards, JOSHUA EDWARDS,
All right, and my understanding is you'd like to resolve your case today, is that correct?
Yes, Your Honor.
All right, and your attorney invited me into negotiations. I made an offer of an adjudication, 6 months probation, special condition that you get a mental health evaluation with any recommended follow-up, and that you have no contact with the alleged victim. Is that your understanding of the court's offer?
Yes, Your Honor.
And is that what you wish to accept to resolve your case?
Yes.
All right, how old are you, sir?
29.
How far did you go in school?
12th grade.
Okay, do you read and write English?
Yes.
Have you had enough opportunity to discuss the case and the offer with your attorney?
Yes, Your Honor.
She answered all your questions for you?
Yes, Your Honor.
And are you satisfied with her representation?
Yes.
All right, very good. You're charging count 1 with battery and count 2 indecent exposure. Those are each punishable by up to 364 days in the Broward County Jail. You understand the maximum penalty?
Yes.
All right, the minimum penalty would be a withholding court cost. You understand?
Yes, Your Honor.
All right, since I am placing you on probation, if you were to violate the terms of probation and the state could prove that it was a willful and substantial violation, you would still be looking it up to the maximum penalty. Do you understand?
Yes, Your Honor.
Okay, are you currently under the influence of alcohol or drugs?
No, Your Honor.
All right, any history of mental health problems?
Yes, Your Honor.
All right, is there anything about your mental health issues that would cause you to not understand what we're doing here in court today?
No, Your Honor.
All right, and you believe you have a clear and sound mind to make this important decision?
Yes, Your Honor.
All right, and I no longer see the defense lawyer on the screen, so if you can hear me, any concerns about competency?
Not at this time, Judge.
All right, and I don't have any concerns about Mr. Edwards' competency. He's answered all my questions in a relevant manner, but Mr. Edwards, if you're having any difficulty during the plea, you're going to let me know, right?
Yes, Your Honor.
All right, other than what I told you I was going to sentence you to, has anyone made you any promises or guarantees to get you to change your plea in this case?
No, Your Honor.
Has anyone threatened you or coerced you to get you to do this?
No, Your Honor.
Are you doing this because you believe it's in your best interest to resolve your case this way?
Yes, Your Honor.
All right, you understand if you didn't want to resolve your case this way, we'd have a trial. The state would have to prove your guilt beyond a reasonable doubt to a jury of your peers, but by entering this plea, you're giving up your right to have that trial. Is that what you want to do?
Yes, Your Honor.
All right, if you're not a U.S. citizen, taking this plea will result in your deportation. You understand?
Yes, Your Honor.
If this offense or any prior criminal offense are considered sexually violent or sexually motivated in nature, you subject yourself to involuntary civil commitment. Do you understand that?
Yes.
All right.
Your Honor.
Thank you. And State, are you aware of any evidence that if tested for DNA would exonerate the defendant? No, Your Honor. Defense?
No, Your Honor.
All right, sir, you're not aware of any such evidence, are you?
No.
All right. And State, you have a factual basis? Yes, Your Honor. Defense, you stipulate for the purpose of the plea?
Yes, Your Honor.
All right, now I had an opportunity to read the probable cause affidavit. Based on my reading of the probable cause affidavit as well as stipulation of counsel, I find that there is a factual basis to accept the plea. Mr. Edwards, how are you pleading to these charges? Guilty, not guilty, or no contest?
No contest.
All right, I find the defendant is alert and intelligent. Please enter freely and voluntarily with a knowing and intelligent waiver of his rights with the assistance of an attorney with whom he is satisfied. I'm going to accept the no contest plea. I'm going to adjudicate you guilty. I'm going to put you on probation for 6 months. I'm going to order as a special condition of probation that you have absolutely no contact, direct or indirect, with the victim in this case. I'm also going to order that you get a mental health evaluation and any recommended follow-up. Anything else, State? Anything else, defense?
No, Your Honor.
All right. And, sir, you have 30 days to appeal. If you can't afford an attorney, I'd appoint one for you. Good luck to you, sir, okay?
All right, thank you.
All right, I do need you to, do we have a deputy there that can help me out with this? I have a phone number I need to give him to, okay, and it's also going to be on the dispo, but let's make double sure here. The phone number is 954-357-5904, and, Mr. Edwards, I'm going to order that you call that number within 24 hours of your release and set up your probation instructions, okay?
Okay.
All right, thank you.
With attorneys, so once get settled down.
Okay.
And this is for felony probation, correct? All right, do we have any other misdemeanors you want to call at this point, or you want me to keep rolling on the felony?
Judge, on the misdemeanor, we have David Blue on page 10. That's a medical reset, so if we can just roll this to tomorrow.
All right, on David Blue, I will reset this for tomorrow.
Next, Judge, we have Gary Delavo. He's at Conti. Attorney Andrew Lees will be handling the case on page 11 of misdemeanor docket.
Okay.
Mr. Hope.
All right. Mr. Delavo, good afternoon.
Hey, yes, sir.
How are you?
I can't complain.
All right, very good. So we're good afternoon, sir. How you doing?
Hello. How you doing, Judge?
Good. All right. So we have Mr. Delavo for a bond motion. What would you like me to consider?
Yes, Judge. At this time, we'd be asking Your Honor to release him ROR. At this time, he's being held on a misdemeanor. Judge, he's been in for 29 days since March 4th. He has a place to go where if you were to release him today, he can go live with his sister. He's currently not working because he's retired. He's an elderly gentleman. I would just be asking you to release him ROR at this time, Judge.
All right. And state.
We would be objecting to an ROR at this time. Based on the facts of this case, there was an accident where on the DUI, the defendant ran over a pedestrian, and the pedestrian had a fractured left tibia, who's our victim in this case. So it's a very serious injury. Also, the defendant does have a pending DWLS case that was on, the date of incident is March 3rd, 2020, which is after the DUI. And then there's also a pending DUI to be filed, and I know that we're just waiting on medical records for that case. And that incident occurred on July 26, 2019, which was also after this DUI.
Wait, no, it ain't.
All right. In light of all of that, I'm looking at the bonds that were set. I find that those bonds are reasonable in this situation, and I'm going to deny the motion. Thank you.
Judge, next we have Jonathan Valley on page 11 of the misdemeanor docket, and this is going to be handled by Ms. McFarland.
Okay.
He's at Conti as well.
Okay. Ms. Valley, good afternoon.
Hi, good afternoon.
All right. And do I have the defense lawyer?
Yes, this is Ms. Douglas. There she is.
Hi, good afternoon.
Good afternoon. How are you?
I'm good, thank you, Judge.
Great. So we're here on Mr. Valley.
Yes, and we're requesting that Mr. Valley be released ROR. He has been in jail for 76 days on a DUI. He went in on the 17th. He was supposed to be on pretrial release, but he didn't have a verifiable address to go to at the time. We've been trying to see if we could get him into one of these facilities. Unfortunately, Banyan and Bart, they're not taking anyone else in at this time. However, Mr. Valley understands what he's facing as far as being able to get to somewhere where he can stay. I know that Pompano Beginners is still taking people, but he did indicate that he would take it upon himself to find a facility to check himself into if he's released ROR.
Okay. All right. State.
Yes, Judge Reno here on behalf of the state. The state would be objecting to the motion for ROR. This motion was already heard in front of Judge Malika back in March 13th, where Judge Malika stated that the defendant was a danger to community. To inform the court on the defendant's priors, he has a prior 2016 violation of domestic injunction, 2016 resisting without violence, 2016 petty theft, 2014 carrying concealed weapon. He has a prior 2008 reckless that was downfall from a DUI arrest. And this case is also a DUI crash, Judge, and for those reasons, the state would be objecting to the motion for ROR.
Okay.
And Your Honor, if I could put this into some perspective for
Yeah.
the court, Mr. Valley, but for the fact that he didn't have a verifiable address, would have been out on pretrial release since January 7th. The state didn't file an information until March. So Mr. Valley has been sitting in jail for approximately 2 months before the state even decided to file an information on the current case. I don't believe Mr. Valley is any kind of threat to the society. He has family that lives here. He's been living here all his life. The only issue, and his mom is very supportive. She's in court all the time. She calls me pretty much every day. We've been working together trying to see if we can get him into a facility because he can't do it himself because he's locked up. And she would happily take him in, but he also is staying with a relative, so she doesn't have the convenience of taking him in. Otherwise, she would. And so, like I said, but for the fact that he didn't have a verifiable address to go to, he would have been out on pretrial release at least, 2-3 months, almost 3 months ago.
Okay, so you're telling me that that his assigned judge was going to release him if there was a verifiable address.
Well, he was the magistrate judge put him on pretrial release. When we went to see Judge Monica subsequent to that, we were trying, and she called, I believe it was Banyan, she called, he sent over a court order, I emailed it to them, she had them on the phone, they were gonna go out and do an intake for him, but everything went south after that, and obviously no one was able to go in or out of the jail. We did ask for ROR at the time, and she said she would basically defer that until we could figure out if we could get him into somewhere.
Judge, he
was supposed to have a hearing, the 25th, I believe, where we would revisit the whole thing.
And Judge, he is ROR with an Elmo. The issue is the address verification. I did speak with BARC a couple of days ago, and they are not doing intakes in the jail for understandably so. However, they do still do intakes, and so I would ask for him to be ROR with instructions to go to BARC and get a BARC evaluation. Then we can leave it up to the experts to determine whether or not he's in need of residential treatment if necessary. They do have beds available, but they just can't evaluate in the jail. So that's what I would ask for, Judge.
All right. Would there be any issue if I put him on a standard pretrial? I'm sorry?
Oh.
Okay.
So I'd ask that the tab be removed, and instead, in its place, he receive treatment as determined by the experts at BARC.
That would be over the state's objection, Your Honor.
All right, over state's objection, I'm going to ROR Mr. Valley to standard pretrial release. I'll delete the TAD monitor, but I'm going to order no alcohol, no intoxicants, which I assume was already ordered, and with random testing. And you've got to get that. You got to call for that BARC evaluation within 48 hours of your release. Okay.
Your Honor, as a matter of fact, I have 2 orders to get evaluated once upon my release. I have the orders with me, so I have the order for BARC and I have the order for Banyan. If I could actually make it to in person, I know they're willing to take me. It's just the fact of me. When I was ordered to those programs, that's when the virus took place, and the evaluators couldn't come here.
Okay, so I'm gonna, like I said, I'll ROR you to standard pretrial. What I'll do is I'll give you the option of Banyan or BARC or any substance abuse evaluation and any of their follow-up, okay?
Thank you.
All right, and do we have a future date on Mr. Valley? Sure.
And Judge, I have the phone number.
Is 5/22/20 for status conference.
Okay, so we can leave that on, and then the address, see, I'm finally, before noon is the time. All right, so, sir, you need to go to pretrial office at 540 Southeast 3rd Avenue, 2420, okay?
Sure.
All right, and you gotta be there before noon, all right?
I just want to know, because I don't know how this works without the I don't have a physical address right now. I can get one within 24 hours.
Okay,
Like, do you,
so here's the situation. Get one. If you have trouble finding someplace, I can tell you, I'm not gonna order it because I wanna give you some flexibility on, where you're gonna stay. But, I know that First Step is still taking people, because I happened to run into, Mr. Merritt the other day. And, so that's a possible option, okay?
I guess what I'm asking is like, do I get released and then I provide the address?
That's correct.
All right, thank you,
Right.
thank you, Your Honor.
And we've also had discussions, his mother has the information and the cell phone number for Faith Farm if they're still taking people in.
Okay, thank you. All right, thank you very much.
Thank you.
Yes,
That'd be great, that's okay. If you can just call us when he's there.
48 hours. Thank you.
Judge, next if I can call Carlette Hope. Mr. Hope was supposed to be on the docket. He did not make it on the docket, so I will read his case number. He is at North Broward, and it will also be Miss Douglas's case to be handled. And Mr. Hope's...
Wait, before we do that, because I have nothing, I want to make sure, State, are you prepared to
I
do
have
it?
nothing on this case, Your Honor.
He was on the spreadsheet that Judge Tudor sent to the state a couple days ago.
Yeah.
And he was on the email as well. He just didn't make it on this morning's docket.
Okay, unfortunately, these things are happening, but he's not on any of the dockets, so I need you guys to contact Judge Siegel's office, let him know that.
He was in the email. The clerk's office just didn't put it on the actual docket. So he's there, Judge, if we can just argue the motion.
Can you give the case number to the state, give them a few minutes to look at it?
Of course, Judge.
And if we can, we will. And what's the name? I know they're at North Broward. What's the name?
It's Carlette Hope, and the case numbers are 20950 MM10A and 1912545 MM10A.
All right, so I'm not making any promises at this point. I'll give the state a few minutes. We'll move on to something else, but we'll come back to.
Thank you, Judge.
All right, thank you.
Next, Judge, we can address Ada Farrer. She is at the main jail. It's on page 12 of the misdemeanor docket, and this will be handled by Anna Ferrato.
All right. Ms. Ferrer, good afternoon. How are you?
Good afternoon.
All right. And pull this up. Okay, so we're on Ms. Ferrer.
Yes, Judge, this is Anna Ferrado on her behalf. Judge, Ms. Fair we had an order granting an ROR motion for her release to pretrial with a GPS monitor. However, one of the conditions because of the GPS monitor was that she needed to have a verifiable address. Unfortunately, Ms. Fair at this point does not have a verifiable address. She doesn't even know where she's going to be living upon her release. That order was granted on the 23rd of last month, on March 23rd. So that means that she's being on an extra 9 days in custody with risk of being contaminated because she doesn't have this verifiable address. So at this point, we're asking if Your Honor would be willing to modify the conditions of her release and either for an ROR or on the alternative, a standard pretrial. The previous conditions.
All right, State.
Your Honor, the state would be objecting due to the fact that she has no verifiable address. She is a flight risk. We don't know if she's going to come back to court or not. I understand she was already ROR'd, but we wouldn't have a way to find out if she's going to come back or not.
Well, what makes someone a flight risk because they don't have a verifiable address? I mean, I understand it's a concern, but is there any other reason to think that Ms. Ferrer is a flight risk?
Mm-hmm.
Sure.
Judge, while they're looking at that, if I may,
Sure.
there are no other indications that Ms. Farah ever did not appear in court or any such thing.
Okay. So basically, the bottom line is that's the only issue, though, right?
She does have priors, Your Honor.
Okay.
I'm just looking them up.
Sure. I'm gonna look at the PC while you're getting those priors.
Does have a petty theft, Your Honor, that was disposed, that is from back in 2017, if I'm not mistaken,
Okay.
which was resolved with a withhold, and court cost has been waived. And this is the only other, other than traffic infractions, of course, this is the only thing that she has in Broward County.
Okay.
Your Honor, she does have a prior capias on the petty theft case. It was on. In November of 2018, it was issued and it was served in December of 2018.
That's over 2 years ago, where, you know, she is literally is held in custody because she doesn't have the financial means to find or to procure any type of housing.
Right.
That should not be an impediment for her release.
Okay. All right. Over state's objection on Ms. Ferrer, I'm going to ROR to standard pretrial release. Ma'am, you've got to report to 540 Southeast 3rd Avenue, Suite 2420 by noon the day after you're released, okay?
Okay, thank you.
All right, any other conditions?
Thank you,
You'd have no victim contact, direct or indirect, while you're out. Anything else, defense?
No, Your Honor, not at this point. Thank you so much.
All right, anything else, state?
No, Your Honor.
All right, thank you.
Judge, if I may recall Henry Flores on page 9 of Your Honor's docket, we secured a bed for him at Pompano Beginners. Mr. Epps is present and available to provide you with the information, and he's at Conti.
Okay. All right, so, all right, Mr. Flores?
Mm-hmm.
Good afternoon
sir.
again.
Good afternoon.
Okay, and defense?
Yes, Your Honor, Benny Epstein for the defense.
All right, and my understanding, you were going to give me some information on a program?
Yes, I was able to speak with Pompano Beginnings. They are willing to accept Mr. Flores into their program. I spoke with their liaison, Martin, and he said there wouldn't be an issue. I could place, let the court know that there was a place for Mr. Flores to go.
Okay. And state, I already know that you're objecting, correct?
Well, Your Honor, because Judge Solomon has already said that as long as he finds a place for him, we have no objection to that, as long as it's a portal-to-portal transport. Because how can we ensure he's gonna go?
Well, because I'm going to order he goes, and if he doesn't, he's violating his pretrial release, and he gets to sit back in jail while all this is going on. And I suspect that whoever's sitting in this seat probably would not be thrilled with that situation. I understand the concern. I have some concerns on how that's going to work logistically.
Okay.
And in reality, we're, at that point, we're putting more people in contact. I'd like to try to minimize that as much as possible. So on Ms. Flores, I'm going to grant the motion. He's going to be ROR'd with the condition that he reside and follow all the rules of Pompano Beginners. He must report to Pompano Beginners within 24 hours of his release.
Your Honor, I have the address, the main address that they provided me with.
Okay.
It's 437 Southwest 2nd Court, Pompano Beach, Florida, 33032.
All right. So, Ms. Flores, you understand? You got to.
Yes, sir.
All right. So within 24 hours, you've got to report to Pompano Beginners at 437 Southwest 2nd Court in Pompano. You understand?
Yes, I do.
All right. If you don't do that, you're violating my order, and we're going to issue a warrant for your arrest. That'll be no bond. Okay.
Okay, well understood.
All right, thank you.
Thank you.
Thank you, Judge. Next, we have Jason Caves on page 12 of your Honor's docket, and the attorney is Howard Clark. This is going to be a negotiated resolution, Judge.
Okay.
He is at Main Jail.
Okay. All right. Mr. Caves, good afternoon.
Sir?
How you doing?
Good afternoon. Good.
Good.
Your Honor, the plea offer is, for count one, it's an adjudication of credit time served, 6 months probation, 13-week anger management course, letter of apology to the victim and no victim contact. For count two, it's an adjudication, 6 months probation to run concurrent, 13-week anger management, a letter of apology to the victim and no victim contact. And same thing for count three, Your Honor. All of them to run concurrent. And no return for count three, I'm sorry.
Okay, so count three would. All right, let me take a look here.
Count three should be an adjudication time served.
Yeah.
Yeah, time served with 6 months probation.
All right, so 6 months adjudication, 6 months probation on all counts.
Right.
On counts 1 and 2, special condition, 13-week anger management, no victim contact, letter of apology to the victims.
Yes, Your Honor. And on count three, it's just a no return, the special condition.
All right, where is it that he's not returning to? Pull it up here.
I apologize, Your Honor. The
It's okay.
count three is a resisting, so there's no return.
All right, that's why I was
Yeah.
confused. Thanks. All right. So count three will just be the adjudication, 6 months probation.
Right.
Okay. All right, Mr. Caves, raise your right hand for me. Swear to tell the truth, the whole truth, nothing but the truth?
I do, sir.
All right, you can put your hand down. And good afternoon. How you doing, counsel?
Very good.
Very good. And sir, my understanding is you'd like to resolve your case today. Is that correct?
Yes, Your Honor.
All right. If you could state your name, spell your last name for the record.
Jason Caves. JASONCAVES.
All right. And the state's made an offer. If you wish to resolve on counts, on all counts, it's going to be an adjudication and 6 months probation. On counts 1 and 2, it's going to be 13-week anger management, letter of apology, and no victim contact, direct or indirect. Count 3 will just be the adjudication, 6 months probation, all to run concurrent. Is that your understanding of the state's offer?
Yes, Your Honor.
And is that what you wish to accept to resolve your case?
Yes, Your Honor.
How old are you, sir?
45.
Okay, how far did you go in school?
12th grade.
Are you read and write English?
Yes.
Have you had enough opportunity to discuss the case as well as the offer with your attorney?
Yes, Your Honor.
Has he answered all your questions for you?
Yes, Your Honor.
And are you satisfied with his representation?
Yes, Your Honor.
All right, very good. You're charged in counts 1 and 2, threats to specified individuals. Count 3, resisting without violence. Those are each punishable by up to 364 days in the Broward County Jail. You understand the maximum penalty?
Yes, Your Honor.
All right, the minimum penalty would be a withholding court cost. You understand?
Yes, Your Honor.
All right, since I am placed on probation, if you were to violate the terms of probation and the state could prove that it was a willful and substantial violation, you would still be looking at up to the maximum penalty on each count. Do you understand?
Yes, Your Honor.
All right, are you currently under the influence of alcohol, drugs, or medication?
No, Your Honor.
Any history of mental health problems?
No, Your Honor.
All right, other than what I told you I was going to sentence you to, has anyone made you any promises or guarantees to get you to change your plea in this case?
No, Your Honor.
Has anyone threatened you or coerced you to get you to do this?
No, Your Honor.
Are you doing this because you believe it's in your best interest to resolve your case this way?
Yes, Your Honor.
All right, you understand if you didn't want to resolve your case this way, we'd have a trial. The state would have to prove your guilt beyond a reasonable doubt to a jury of your peers, but by entering this plea, you're giving up your right to have that trial. Is that what you want to do?
Yes, Your Honor.
All right, if you're not a U.S. citizen, taking this plea will result in your deportation. You understand?
Yes, Your Honor.
Also, if this offense or any prior criminal offense are considered sexually violent or sexually motivated in nature, you subject yourself to involuntary civil commitment. Do you understand that?
Yes, Your Honor.
All right, very good. State, are you aware of any evidence that if tested for DNA would exonerate the defendant?
No, Your Honor.
All right, defense?
No, Your Honor.
All right, sir, you're not aware of any such evidence, are you? Sir?
No, Your Honor.
All right, state, you have a factual basis?
Yes, Your Honor.
And defense, you stipulate for the purpose of the plea?
Yes.
All right. Right? And I've had an opportunity to review the probable cause affidavit. Based on my reading of the probable cause affidavit as well as stipulation of counsel, I find that there is a factual basis to accept the plea. Mr. Caves, how are you pleading to these charges?
No contest, Your Honor.
Find the defendant is alert and intelligent. Please enter freely and voluntarily with a knowing and intelligent waiver of his rights with the assistance of an attorney with whom he is satisfied. Accept the no contest plea. On all 3 counts, I'm going to adjudicate you guilty, place you on 6 months probation. That'll run concurrent. On counts 1 and 2, I'm going to order 13-week anger management. I'm also going to order no victim contact. I'm also going to order that you write a letter of apology on for the 2 individuals in counts 1 and 2. Anything else, State?
No, Your Honor.
Anything else, defense?
No, Your Honor.
All right, sir, you have 30 days to appeal. If you can't afford an attorney, I'd appoint one for you. Good luck to you. I'm going to give you the phone number. We're going to write it on your paperwork, but I think they just handed it to you. But it's 954-357-5904. Okay?
Correct.
All
Yes, sir.
right. Very
How
good.
many prints do we need?
I'm sorry?
How many do we need? Prints? How many?
We just need one.
Okay, thank you.
Thank
And
you.
Judge, can we give him the number for probation?
I did.
Oh, you did? Okay.
Yep.
I was reading something else.
Not,
Sorry about that,
not,
Judge.
not a problem.
Judge, if I may call Bernard Brooks on page 13 of the misdemeanor docket, this is Mitchka Bavandi's case, and she's unable to appear via Zoom, so if I may approach with her cell phone number, Judge.
Okay. Thank you.
North Broward, Your Honor, approach it.
North Broward.
Hello,
Hi, may I speak to Ms. Bavandi, please?
this is she.
Hi, good afternoon. This is Judge Michael Lynch. I have you on speakerphone in open court on the record. How are you?
Fine, how are you? Good afternoon, Your Honor.
Very good. And Mr. Brooks, good afternoon.
Good afternoon to y'all.
All right.
Good afternoon.
So we're here for a bond motion. Mr. Brooks is present via closed circuit. And what would you like to tell me, Ms. Bavandi?
Yes, Your Honor. I filed the motion for release. Mr. Brooks is charged with a minor misdemeanor, giving false name. He's been in custody since March 1st. And given the health situation right now, with the COVID-19, I was concerned about him being in custody, and that is why I filed the motion for his immediate release.
Okay. Thank you. And my understanding right now is there's a $500 bond with an Elmo. Is that correct?
Correct, Your Honor. And given that Mr. Brooks is indigent, that's tantamount to no bond for him.
Okay. State.
Your Honor, the state would be objecting due to the defendant's criminal history. He has a 2000 resisting without violence adjudication, a 2003 felony battery withhold, a 1998 grand theft auto adjudication, 2020 trespass, which was an adjudication. And that's it, Your Honor.
All right. Mr. Brooks, you have someplace to stay if I let you out?
Yes, sir. Yes, I do.
All right. Overstates objection. I'm going to grant the motion. He'll be ROR'd. Do we have a future date for Mr. Brooks?
Yes, Your Honor. Currently, he was given a date in May with us,
Okay.
but as the court's aware, that may change.
Correct.
Depending on the closure. So, but he can keep in touch with me, and I can inform him of what the court date would be once we have an actual firm set court date.
All right, very good. So, Mr. Brooks, right now as it stands, you've got a May 4th court date. Just make sure you're in touch with Ms. Bavandi because I don't know whether we're going to be open for business or not on May 4th, okay?
All right, thank you so much, Judge.
Not a problem. Take care.
All right, thank you, thank you.
Next, Judge, we have Adrian Brown at Paul Ryan. This is with attorney Howard Clark on
All right.
page 13.
Okay.
This is gonna be a negotiated resolution, Your Honor.
Okay.
approaching, Your Honor.
Thank you.
Your Honor, the plea offer on count 1 is an adjudication with credit time served and no victim contact. Count 2 is also an adjudication, credit time served. Count 3 is an adjudication, credit time served, and no return to the CVS at 5555 North University Drive in Lauderhill, Florida, 33351.
Okay. All right. All right. Mr. Brown, good afternoon. How you doing?
Good.
Okay, very good. Do me a favor, raise your right hand. You swear to tell the truth, the whole truth, nothing but the truth?
Yes.
Okay, you can put your hand down. Please state your name and spell your last name for the record.
Adrian Hugh Brown, and then maiden name Numbers.
And it's the last name is Brown, correct?
Yeah.
Okay.
Yes.
All right.
Yes,
All right. And my understanding is you'd like to resolve your case today. Is that correct?
yes.
All right. So the state has made an offer. It's going to be an adjudication and time served on all 3 counts. But on count 1, I'm going to order that you have no victim contact. On count 3, I'm going to order that you do not return to that CVS in Lauderhill. Is that your understanding of the offer?
Yes, Judge.
And that's what you wish to accept to resolve your case, correct?
Yes, Judge.
All right, Mr. Brown, how old are you?
20.
Okay, how far did you go in school?
School.
Yeah, what was the highest level? Did you complete 9th grade, 10th grade?
High school.
Okay. So did you graduate high school or get a GED or?
Yeah.
Okay. Do you read and write English?
If I read, yes. Yes,
Okay.
Judge.
Have you had enough opportunity to discuss the case as well as the offer with your attorney?
Yes, Judge.
Has he answered all of your questions for you?
Yes, Judge.
And are you satisfied with his representation?
Yeah.
All right, very good. You're charged in count 1 with battery. That's punishable by up to 364 days in the Broward County Jail. Count 2, petty theft, punishable by 60 days in the Broward County Jail. Count 3, trespass of a structure or conveyance, punishable by 364. You understand the maximum penalty you're looking at?
Yes, Judge.
All right, the minimum penalty would be a withholding court cost. You understand?
Yeah.
Okay. Are you currently under the influence of alcohol, drugs, or medication?
No.
Oh, we just lost this. Oh, there we go. And any history of mental health problems?
No.
Okay. Other than what I told you I was going to sentence you to, has anyone made you any promises or guarantees to get you to change your plea in this case?
No, no.
Has anyone threatened you or coerced you to get you to do this?
No.
Are you doing this because you believe it's in your best interest to resolve your case this way?
Yes, Judge.
All right, you understand if you didn't want to resolve your case this way, we'd have a trial. The state would have to prove your guilt beyond a reasonable doubt to a jury of your peers. But by entering this plea, you're giving up your right to have that trial. Is that what you want to do?
Yes, Judge.
All right, if you're not a U.S. citizen, taking this plea will result in your deportation. You understand?
Yeah.
Also,
Yes, Judge.
okay. Also, if this offense or any prior criminal offense are considered sexually violent or sexually motivated in nature, you subject yourself to involuntary civil commitment. Do you understand?
Yeah.
All right. And State, are you aware of any evidence that if tested for DNA would exonerate the defendant?
No, Your Honor.
Defense? All right. Sir, you're not aware of any such evidence, are you? Are you aware of any evidence that if we tested it for DNA would show that you had nothing to do with this, it was someone else?
Yes, Judge.
Listen to what I'm asking, okay? So you've seen on TV sometimes people go to prison and it turns out they do a DNA test later and it shows this person wasn't the person who did it. That's what I'm asking. Do you know of any evidence out there at all?
I have no problem with any evaluations or anything.
No. Just listen to me. I need to know whether you believe there's any evidence out there that if we tested it for DNA would show that it was someone else involved in this case and not Adrian Brown. You're not aware of that, are you?
That wasn't me.
Well,
Judge, there's no such evidence.
I'm approving any
he's telling me it's not
anything.
him.
Your Honor, can we put this on recall?
Yep, we'll put it on a brief recall, okay?
Thank you, Judge.
Sure.
Finally, Judge, we have Andy Pitcher on page 13 of Your Honor's docket. This is Mr. Epps' case, and he is at North Broward.
Okay. All right, this is on Pitcher.
Hello, sir.
Good afternoon, sir. How are you?
Good afternoon. How you doing, sir?
Very good. So we're on Andy Pitcher, and do we have Mr. Epps?
Yes, Your Honor.
There you are, Mr. Epps. All right. What would you like me to consider in regards to Mr. Pitcher?
Yes, Your Honor. This, the motion was previously heard by Judge Solomon. She reduced his bond from $5,000 to the current $1,500. Mr. Pitcher is unable to make that bond. This incident, and he's actually been in jail for 20 days at this point since March 13th. Keeping in mind as well that this case has not yet been filed. It's at his residential treatment facility, and so that was part of the backdrop of the alleged battery.
So the issue is just that he doesn't have the $1,500 or the $150 to put up.
Exactly, Your Honor, and he still believes that he would be able to return back to the Continental wellness program, which is where he and the alleged victim were at the time. I haven't been able to get in contact with Continental Wellness.
I'm pretty sure I'll be able to pay for that through the program.
Their voicemail box is full and unable to message no one line.
Okay.
Judge, the state would be objecting to any motion for ROR. The defendant has extensive priors, which include 2002 aggravated battery, 2004 battery arrest, 2007 battery arrest, 2015.
I don't, the arrests that don't end in with finding of guilt or a conviction or withhold, I'm not interested in.
Okay, Judge. And I also want to inform the court that the defendant is originally from Trinidad. He has only resided at a Fort Lauderdale address for 24 months, Judge. Based on the defendant's violent priors and the facts of this particular case and the fact that the defendant is originally from Trinidad and Tobago, the state would be objecting to a motion for ROR.
All right, and I just want to confirm, because I know I cut you off with when I said I wasn't concerned about arrests. I have, the only one that I heard without an arrest was not without an arrest, but the only one I heard that there was a conviction of some sort was an aggravated battery.
He has a 2002 aggravated battery.
Yeah.
He has a 2016 battery, which was an adjudication.
Okay.
And he has a pending case, which is a trespass down in Miami-Dade County.
If we were to go back to that Continental Wellness Program, any idea whether the alleged victim is still in that program?
My understanding is that yes, Your Honor.
That doesn't,
I haven't been able to confirm it.
Okay. It doesn't sound like that would be a good fit if that other individual is still there. Do they, I'm just pulling up the PC now. Is there any indication that they knew each other before, or is this allegedly just a random issue?
No, my understanding is they knew each other just based on being involved in the program.
Okay.
Both being involved in the Continental program. My understanding is the alleged victim is also involved in the program as well. But it was a situation that got out of hand and they kind of resolved it among themselves. They were both in the Continental.
See, Judge, it did state that they lived next door to each other.
State, in light of the fact, I mean, if you read the PC, the officers actually gave the defendant the option of accepting a notice to appear on this. He'd be out with anything. So explain to me why you feel we need to hold him on this $1,500 bond that he can't afford.
Again, Judge, I want to point the fact that the defendant is originally from Trinidad Tobago. He only has a Fort Lauderdale address for the last 24 months, Judge. And based on his violent priors and this being a violent case, Your Honor, we think that the $5,000 bond was appropriate. Judge Solomon did reduce that to $1,500, so we would ask that $1,500 bond stay in place.
All right. So, Petri, you have a do you have a passport? Is that a no?
No.
Okay. All right. Overstates objection. I'm going to grant the motion to ROR. I'm going to order that. I'm going to place you on standard pretrial, and you're going to have to report to pretrial before noon, and that's located at 540 Southeast 3rd Avenue, Suite 2420, basically right next door to the courthouse. I'm also going to order that you not attempt to get a passport. And no victim contact, direct or indirect. State, would you be asking for any other conditions?
No, Judge.
Okay. Anything else, defense?
No, Your Honor, thank you.
All right, thank you.
Judge, I believe that's all that we have left on the misdemeanor docket with the exception of Mr. Hope at North Broward, if we may address Mr. Hope. We've been trying to get him on the docket for 2 weeks, Judge.
Let me
I'm
see what I
sorry.
can do. That's okay.
Thank you.
All right, State, have you had a chance to look at Carlette Hope?
Yes, Your Honor, I did.
All right, are you prepared to address that today?
Yeah, that we can address.
Okay.
And that'll be Miss Douglas.
I'm sorry?
That'll be Miss Douglas.
Miss Douglas? Okay. And let me, that's North Broward. Okay, so we need Carlette Hope. I'm sorry? All right. And is this Mr. Hope?
Yes, sir.
Good afternoon. How you doing?
All right.
All right, good. Okay.
Good afternoon again, Your Honor.
Yes.
Mr. Pope, his situation that he has bond on both of his cases, it's $100 on each case. He's not able to make the bond, and we're just asking that he be released RR. He's been in jail since December 23rd.
And the bonds are $100 on each case?
On each case.
All right, State.
Your Honor, at this time, the state would be objecting. There was a motion for ROR that was set in January of this year that was denied by Judge Malika, and on March 19th, the same motion was denied again. The judge advised that she was thinking about raising or changing it to a no bond hold in light of the facts of the case and the fact that he has 2 cases pending of the same charge. He also does have priors. He has a 2015 possession of cannabis, a 2013 possession of cocaine, possession of cannabis, 2009 possession of cocaine, 2009 trespass, 2008 trafficking cocaine, 2008 false identification to a Leo, possession of cannabis, possession of cocaine, 2007 no valid driver's license, possession of cocaine, possession of cannabis, I apologize, and resisting without violence, false ID to a Leo, a 2005 possession of cannabis and no valid DL, a 2001, and a 2002 possession of cocaine, all 3 of those years.
Give me a second. I'm just going to pull up the PCs here.
I may, whenever you have a moment. Also, on January, there's a note in here from the ASA on the case that when Judge Malika denied the motion, the state had argued that our concern was that the defendant picked up the other case 3 days after this original charge.
Okay.
It was with at the same location with the same behavior, same victim, right? Or different victim, Your Honor, but same location, same behavior.
I think in this case, the $100 bonds are extremely, yeah.
Judge, if I may just provide additional information that Ms. Douglas didn't provide to the court. We do have a competency evaluation that's pending. Unfortunately, there's no one going to the jail, and so he's here indefinitely. What I would do is I would ask that the court would release him to standard pretrial release with an order to go to Henderson Behavioral to get an evaluation, a mental health evaluation, and comply with any follow-up treatment that they would require. You know, he's at risk in the jail. He's a person who's unable to post bond. He's not able to continue with the competency evaluation because doctors aren't going to the jail. And so we would ask that he would be on standard pretrial release, Judge. And I know that I'm familiar with what the allegations are in the case. Obviously, I understand why the court find them problematic. However, there's no allegation that he, attempted to touch anyone or this is certainly an offensive. The allegations are offensive, but Judge, I don't believe he poses a danger to the community. I think that he's in need of treatment.
Listen, here's my issue. Same location, 3 days apart, and I'm sympathetic, but the $100 bonds seem unbelievably reasonable. I understand he's in a situation where he might not be able to post, but
And that's the concern. It's just that it could be a dollar bond. It could be $1 million bond. He doesn't have the money, so he won't be able to post it. Any other person who had the funds and the finances would be able to post it, but he can't because of his finances.
And what can I do to ensure the safety of the community from him showing up to this location again? I know I can order him not to go back.
You can certainly order him not
Sure.
to. You can order him to again have that evaluation. I'm not sure. Ms. Douglas can provide information about where he would go upon his release. If he does have stable housing, then he could be placed on an ELMO as well.
And yes, Your Honor, with regard to, I know Mr. Hope has been in treatment with Henderson in the past. I believe since he's been incarcerated, he's been on medication. So as time went on, I'm able to communicate with him better. The competency status was set for the 25th of this month. Obviously, we weren't able to go through with that hearing. And like Ms. Edgley said, Mr. Hope would be otherwise out on bond if he would have been able to make it despite whatever the allegations are against him. I did speak to Mr. Hope. He said that he would be able to go to his aunt's house. She lives in North Lauderdale if he were released.
Listen, I'm looking at an order that I believe it was Judge Malika. It looks like her signature on March 19th, denying this motion. I understand the concerns, but I'm not going to, change that, so respectfully, the motion's denied.
Should Judge.
All right.
Judge, if I may recall Adrian Brown on page 13, he's able to answer the questions and accept
Okay.
the offer, Judge.
All right, very good.
And he is at Paul Ryan.
All right, so we're back on Adrian Brown on page 13 of the misdemeanor docket. Mr. Brown, good afternoon again. Okay, so you're still under oath, and where we left off is I was asking you if you were aware of any evidence that if we tested it for DNA would show that it was someone completely different other than you. You're not aware of any such evidence, are you?
No, Judge.
All right, very good. And State, do you have a factual basis?
Yes, Your Honor.
And defense, do you stipulate for the purpose of the plea? Okay. And I had an opportunity to review the probable cause affidavit. Based on my reading of the probable cause affidavit as well as stipulation of counsel, I find that there is a factual basis to accept the plea. Sir, how are you pleading to these charges? Guilty?
To these charges?
How are you pleading? Guilty, not guilty, or no contest?
Say no contest.
Would you like to plead no contest to these?
Yeah.
All right. All right. I find the. Oh my goodness. All right, not a problem. I find that the plea is entered freely and voluntarily with a knowing and intelligent waiver of his rights with the assistance of an attorney with whom he is satisfied. I'm going to accept the no contest plea on all three counts. It's going to be an adjudication, time served. Count one, I'm going to order no victim contact, direct or indirect. Count three. No return to the CVS in Lauderhill that was previously referenced by the state. Anything else, state?
No, Your Honor.
Anything else, defense? No, Your Honor. All right, Mr. Brown, you have 30 days to appeal. If you can't afford an attorney, I'd appoint one for you. Good luck to you, okay?
Thank you, Judge.
All right, thank you. All right, so I believe that concludes the misdemeanors.
Judge, thank you so much, Judge.
Sure,
I
not
really
a problem.
appreciate it.
Not a problem. Okay. Give me 1 second to sign these and we'll keep on rolling. If anyone at any point needs a break, I don't think you will since we have multiple people, but if you do, let me know. Sure. All right, so we're back on page 5 of the felony docket. Kyle Arriete. Paul Ryan. Okay. And this is, all right, thank you. This is Chad Mason. I'm going to get Mr. Mason on the phone.
You have reached the voicemail box.
All right, we'll give that one more shot, and then we'll put it on recall if not.
Hello, this is Pat Mason.
Good afternoon, Mr. Mason. This is Judge Michael Lynch. I have you on speakerphone in open court on the record. How are you?
Good. Nice to talk to you, Judge Lynch.
Great. I'm calling in regards to Kyle Arriete. And Mr. Arriete, good afternoon. How are you?
Good afternoon, Your Honor.
All right, so I have it set for the motion for emergency bond. And Mr. Mason, what would you like me to consider in regards to Mr. Arriete?
All right. I actually represented Mr. Arriete years ago on the 2012 case that I'm asking for bond. I was his public defender at that time, and that was his first felony offense. He was placed on probation and adjudicated. And then what happened is he has a new case from 2019 where there's some charges. None of them, I just want to make one thing clear, because when I spoke to the state about this, it indicated that he was in a fight and then later found with a weapon and other things. there's no evidence whatsoever in the new case that he was actually involved in the fight. That's how they made a stop in the case, but ultimately, there's a pending motion to suppress right now regarding that stop, and he was ultimately determined not to have been in the fight, actually. So there's no risk of violence as to him, as the state, when they objected, had noted. But other than that, he has the new case, and I just wanted to make a bond motion for the VOP case because the new case, we have no ability right now to have the pending motion to suppress heard.
Okay.
And so, and then on the VOP, it's on a third-degree felony false ID to pawnbroker. So it's not the most serious of felonies, of course. And under the current circumstances, I just want to try to get him safe and home with his family.
All right.
So I'm asking for the court to set an emergency bond of some amount that he can post.
All right. What kind of bond are you asking for?
Well, he has $5,700 in bonds on the counts that are part of the 2019 case. So I'm probably asking for no more than $2,500 or something in that ballpark for the VOP bond because I think the family can't really afford to come up with much more than that.
Okay. All right. And state.
Your Honor, we object to the release of this defendant. This defendant was placed on probation back on March of 2014. He violated probation in June of 2014. So, within a couple of months of being placed on probation, he was reinstated at the end of June with probation extended by 1 year, and he violated again in September of 2014, this time by leaving the county and getting arrested in Collier County. Nonetheless, he was reinstated in October of 2014 and now placed on drug offender probation, which he violated once again, this time by having cocaine and cannabis in his system by December of 2014. The warrant was amended in February 15th because he also absconded after that violation. He wasn't arrested then from February of 2015 until September of 2015. Yet again, he was reinstated in December of 2015, and this time his probation was modified to include IRT, the 30-day program, and he was released on community control until a bed was available. They also added another year of probation at that time. However, in April of 2016, he violated by failing to remain confined and in the program that he was supposed to be at. And then he just absconded altogether. And so from 2016 to 2019, we had no idea where he was. In the meantime, he was arrested for this new case. And although counsel says that there's no evidence of the fight, well, it's not illegal to participate in a fight, which is why it's not a charge. But the evidence that we have is that he had been involved in a fight. That's why the police were called. They came out there and they stopped him. And when they stopped him, this time he tried to flee from the police. He actually, he was in a car and drove recklessly to get around the police. He resisted arrest, and when he was arrested, he was carrying a loaded firearm in his waistband. So at this point, Your Honor, he scores mandatory Florida State Prison, 27 months. His prior history, and he does have a prior history, aside from those two cases, he had a possession of alprazolam, and he had, I lost it. He had some other misdemeanors, but the possession of alprazolam is another felony conviction. We don't feel that this gentleman is a good candidate for release, not only because, knowing that he had a warrant out for his arrest, he was, involved in whatever, in a bar with a gun, and then, gets into it with the police. But he's clearly a risk of disappearing. I mean, how many chances are you supposed to give a person and reinstate them, with them completely, violating and ignoring every condition placed upon him by the court? And the fact that he absconded from 2016 to 2019, I think, is particularly telling. So, yeah, Judge, we do object to any release of this defendant.
Okay. I'm just so everyone's aware, I'm just pulling up the PC on the new law offense.
I mean, if you're looking at that case, again, like we do have a pending motion to suppress on that case.
Sure.
I can tell you that there are factual discrepancies between what the state's saying and what our position is.
Okay.
And some of them were clarified at deposition in the case. But at the end of the day, I mean, I'm sorry, I'll give you a chance to read it.
No, okay, I just finished reading the PC, so go ahead, Mr. Mason.
I can tell you from the body cam footage in that case that he was completely forthcoming about giving over the weapon. The way they make it read was like he was fleeing and eluding or something like that, but in reality, the way it came out of deposition was clear that there were so many cars around and whatnot that they just ordered him to get off of his motorcycle, and he didn't get off of it immediately, and then they had to forcibly take him off the motorcycle. But at that point, he told them, "I have a weapon in my pants, please grab it out." It shows it on the body cam. And he wasn't ultimately at all, if there's any risk of like him, or worry, I'm sorry, of him being a violent offender or anything, there's never any evidence that ultimately tied him back to the fight that happened in the bar there. Okay. So he has no history of violence. And I do think that with the bond, I have excellent contact with the family and his friends. I don't think he's a flight risk at all. He's very excited to have his motion to suppress heard and to finally get this thing resolved.
And Mr. Mason, I appreciate what you're telling me, but not only is there an allegation of a new felony offense, but there's also the multiple times he's violated probation in the past, as well as the absconding for a lengthy period of time. So I have concerns. Respectfully, the motion is denied.
Would you consider any form of like level 1 pretrial with a bracelet?
No, I'm going to maintain the no bond hold.
All right, I appreciate your consideration, of course.
Sure. Thank you, Mr. Mason. Stay safe.
All right, have a good afternoon.
You too. Bye-bye.
All right, bye-bye.
All right, next we have Kevin Taylor on page 6 and 8. Okay. All right, Mr. Taylor?
How you doing, Your Honor?
Very good. How are you?
Could be better.
I understand. All right, so we're here on the motion for pretrial release. Mr. Nevins? Okay, thank you. State?
Your Honor, the state made a plea offer, and I think that our lines got crossed, and I made the wrong plea offer, so I just made the right plea offer. So could we put this on recall?
Sure.
Or do you guys not want it on recall?
That's fine. I can certainly call him.
All right.
Mr. Taylor, I'm going to give you a phone call real quick, okay? Deputy, if you can walk over to the phone.
All right, so I'm going to put Mr. Taylor on recall. We'll see if this can be worked out, okay?
Hey, I talked to you before, right?
Okay. Next, we'd have
18 months of house arrest.
Brandon Washington. Conti. 1 second, Mr. Nevins, just waiting for Mr. Washington to come up. And this is on pages 7 and 8. Let me get the motion.
There was three orders entered yesterday that would place Mr. Washington on standard pretrial release.
18 months of house arrest.
Okay.
Basically, you can do what you need to do. You can work, go to school. Otherwise, you're in a church. Otherwise, you're in your house. You're on a schedule. You can show.
Okay.
There's no electronic monitoring. You have to do the schedule for a year.
Okay. So are you asking me to delete this from today's docket? All right. So on Mr. Washington, good afternoon. How you doing?
All right, how you doing?
Pretty good. So on Brandon Washington on pages 7 and 8, I'm going to go ahead and delete those.
And just so Mr. Washington understands, he was granted pretrial release here in Broward County, so Suffolk Palm Beach County to serve those warrants.
All right. So you understand that, Mr. Washington?
Excuse me, I couldn't hear him.
All right, so what he's saying is you were already granted the ROR to pretrial release on the Broward cases. The issue is your attorney was attempting to talk to Palm Beach because they've got a hold on you, and they're not releasing that hold at that point. So you need to be served with those warrants. So that's why your attorney's asking me to delete this, okay? I can't do anything about the Palm Beach holds. All right? Thank you.
Judge, if we can go back to Mr. Taylor in Maine,
Okay,
we have a change of plea.
okay. All right, we're back on Mr. Taylor.
Your Honor, the state has tendered an offer of 18 months of community control, no early termination during the first 12, to be followed by 24 months of probation. That is on all 3 of his pending cases.
Okay.
It is a downward departure. The gentleman scores 27 months in Florida State Prison.
Okay. Is there, are there any special conditions on any of those cases?
No, sir.
Okay. And I assume that means there's no restitution owed?
Your Honor, as far as I know, there's no restitution owed, and it is an adjudication on all the cases, but I think he's already been adjudicated.
No, so, I'm sorry, I didn't see the case. My docket doesn't indicate what violations, which cases are violations. So are the 14, the 14 cases are VOPs?
Correct.
Okay,
And the
that
20
makes more
case
sense.
is a new case.
Okay, so on the probation cases, it's going to be a reinstate modified to a new term of 18 months CC, followed by 24 months probation, no early term prior to 12 months, and then that will be the actual sentence on the new law. Okay. Second, look at the PC. All right. Mr. Taylor, best you can, raise your right hand for me. Swear to tell the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
All right, you can put your hand down. Please state your name, spell your name for the record.
KEVINTAYLOR, Kevin Taylor.
All right, and my understanding is you'd like to resolve your all 3 of your cases today. Is that correct?
Yes, Your Honor.
All right, the state's made an offer on the violation cases that if you admit you violated, I'm going to reinstate modified to a new term of 18 months community control followed by 24 months probation with no early term prior to 12 months. On the new law, it would be an adjudication, 18 months community control followed by 24 months probation to run concurrent with your other 2 cases, no early term prior to 12 months, all cases to run concurrent. Is that your understanding of the state's offer?
Yes, with the early term, you're saying that's for after the 12 months. That's just for the house arrest or for the whole probation?
Yeah, so on community control, and Ms. Schneider, correct me if I'm misstating this, the state's offer is that you must do at least 12 months of community control before you can ask for that to be, that portion of your sentence to be converted to probation. You understand?
Okay.
Okay. All right?
I understand.
So you understand the offer that's been made?
Yes, sir.
And that's the offer you wish to accept to resolve all 3 cases?
Yes, sir.
All right, how old are you, Mr. Taylor?
I'm 24 years old.
Okay, how far did you go in school?
GED.
All right, you read and write English?
Yes.
Have you had enough opportunity to discuss the violation of probation cases as well as the new law offense and the offer with your attorney?
Yes.
Has he answered all your questions for you?
Yes.
And are you satisfied with his representation?
Yes, I am.
All right, very good. Starting with the violation of probation cases on 14-9465 CF Tanay, you were originally placed on supervision for dealing in stolen property. That's punishable by up to 15 years prison. Count 2, false ownership information upon an item. That's punishable by up to 5 years prison. You understand the maximum penalty you're looking at?
Yes, Your Honor.
All right. On 14-10000 CF 10A, you were placed on supervision for the same counts: dealing in stolen property, punishable by 15 years prison. Count 2, false ownership information upon an item. You understand the maximum penalty on those?
Yes, Your Honor.
All right. On the new law offense, you're charged with 1 count of carrying a concealed firearm. That's punishable by up to 5 years prison. You understand the maximum penalty on that?
Yes, Your Honor.
All right. Very good. Now, based on your score sheet, you're scoring 27.15 months Florida State Prison at the bottom, meaning if your attorney was unable to negotiate a below-guideline sentence, that would be the minimum sentence I could give you. Do you understand?
Yes, Your Honor.
All right, since you are going to be on a period of supervision, if you were to violate that supervision and the state could prove that it was a willful and substantial violation, you would still be looking at up to the maximum penalty. Do you understand?
Yes, Your Honor.
Okay, are you currently under the influence of alcohol, drugs, or medication?
No, Your Honor.
Any history of mental health problems?
None.
Other than what I told you I was going to sentence you to, has anyone made you any promises or guarantees to get you to admit you violated and to change your plea on the new law offense?
Not at all.
Has anyone threatened you or coerced you to get you to do this?
Not at all.
Are you doing this because you believe it's in your best interest to resolve all 3 cases this way?
Yes, Your Honor.
All right, you understand if you didn't want to resolve your cases this way, on the violation cases, we'd have a final hearing. The state would have to prove that you willfully and substantially violated the terms of your supervision. But by entering these admissions, you're giving up your right to have that hearing. Is that what you want to do?
Yes, Your Honor.
All right, on the new law offense, if you didn't want to resolve your case this way, we'd have a trial. The state would have to prove your guilt beyond a reasonable doubt to a jury of your peers. But by entering this plea, you're giving up your right to have that trial. Is that what you want to do?
Yes, Your Honor.
All right, if you're not a U.S. citizen, taking these pleas will result in your deportation. You understand?
Yes, Your Honor.
Also, if these offenses or any prior criminal offense are considered sexually violent or sexually motivated in nature, you subject yourself to involuntary civil commitment. Do you understand that?
Yes.
All right. And State, are you aware of any evidence that if tested for DNA would exonerate the defendant?
No, sir.
Defense? All right, sir, you're not aware of any such evidence, are you?
No.
All right, State, you have a factual basis?
I believe there's a stipulation.
All right, I don't ask it to be read into the record, I just ask State if you have it.
Yes, we do.
Defense if you stipulate.
Yes, sir.
And I already had an opportunity to read the probable cause affidavit. Based on my reading the probable cause affidavit as well as stipulation of counsel, I find that there is a factual basis to accept the plea. Mr. Taylor, on the new law offense, the carrying the concealed firearm, how are you pleading to that charge?
Contest.
I originally pleaded not guilty
Right.
due to
Do you want to maintain that not guilty? Do you want to plead guilty, or do you want to plead no contest?
No
how
contest.
would that affect what would go on today?
Mr. Taylor, you want to plead no contest?
I plead no contest.
Okay, I'm going to read the allegations in the violation warrant to you. Allegation 1 is that you failed to live without violating any law by committing the criminal offense of carrying a concealed firearm on January 26, 2020 in Broward County, Florida. Allegation 2 is that you failed to live without violating any law by committing the criminal offense of possession of cannabis. They had it as a possession over 20 grams. Is that you just didn't file that, correct?
Yes.
All right, so am I dismissing allegation 2?
Yes, Your Honor.
Okay. All right, so I'm dismissing allegation 2. Allegation 3 is that you failed to make restitution payments, that you're $2,517 in arrears as of January 27th of 2020. Let me see if there's... And allegation 4 is that you failed to make drug testing fee payments to probation, that you're $65 in arrears as of January 27th, 2020. Are you admitting you
I'm sorry, I was told the cost to the drug testing would be waived as far as because I'd be told to pay restitution and every other fee would be waived.
All right. State any objection to him admitting to allegations 1 and 3?
Sir.
All right. So in regards to allegations 1 and 3, the 2 violations, I'll dismiss allegation 4. Are you admitting you violated in those 2 ways?
Yes.
All right. I find the defendant is alert and intelligent. Please enter freely and voluntarily with a knowing and intelligent waiver of his rights with the assistance of an attorney with whom he is satisfied. I'm going to accept the admissions as well as the no contest plea. Starting with 149465 CF10A, I'm going to reinstate, modify to a new term of 18 months community control, followed by 24 months probation. No early term prior to 12 months in community control. On 14-10000 CF10A, I accept the admission. I'm going to reinstate, modify, convert to a new term of 18 months community control, followed by 24 months probation, no early term prior to 12 months. On 2944 CF10A, I accept the no contest plea. I'm going to adjudicate you guilty. I'm going to place you on community control for 18 months, followed by 24 months probation, no early term prior to 12 months. All cases, all counts to run concurrent. Anything else, state?
No, sir.
Anything else, defense?
No, sir.
All right, sir, yeah.
Actually, from defense, if we could request Tri-County travel for work purposes, when he gets out and gets employed.
How about we cross that bridge when we come to it? I'd like to know what kind of job he has that would require that.
He'll be on CC, Aaron.
Once he gets off that, if you have one that's today, I'm asking if he costs supervision.
All right.
Get custody for a while.
That's fine. I'll do that. I'll waive the cost of supervision and the drug testing fees. All right.
I would also ask Your Honor for the option for Mr. Taylor to do community service to work off court costs, which Taylor, you don't have to do community services, gives the option.
Any objections, state?
No.
All right, that's granted as well. That will always be the case on my sentences. Okay. You're requesting it? Okay. So you're requesting me to waive the cost of supervision and everything, but you're requesting me to assess that fee? Okay. All right, I'll assess.
It's a moral conundrum.
Okay, one sec.
I'm sorry, I was just-
No, that's okay. Not a problem. Mr. Taylor, you have 30 days to appeal. If you can't afford an attorney, I'd appoint one for you. Good luck to you, okay? Yep.
Okay, thank you.
Oh, 1 second. One set of prints.
Thank you.
Oh. Okay. I had it confused. I forgot it was county. That's not taking. All right. So, sir, I'm going to order that you report to probation tomorrow morning at 3708 West Oakland Park Boulevard in Lauderdale Lakes. It's the corner of Oakland Park and 441. Okay.
Okay, sir.
And they're going to have on your dispo. It's going to be stamped with the address. All right.
Okay, sir.
All right. Thank you very much.
Thank you.
Thanks. All right, so we're on to page 9, Charles Florio.
We can
I
delete
think
that.
he was, we took care of him yesterday.
Okay. All right, then I'm going to sign these real quick before we move on to the next one.
Sorry, here's an extra piece of paper.
Thanks. Oh, wait, I didn't. No, this was the score sheet for, see? All right. All right, and while I'm signing these, just for the record, on Charles Florio, I'm deleting that from the document. Oh, excellent. Sure. Can we get Mr. Taylor back up at Maine for a moment? All right, and we need his address? All right, Mr. Taylor, could you say on the record your address and your phone number, please?
2431 Sherman Street, Hollywood, Florida, 33020. The phone number for right now would be 954-901-4701.
All right. You guys need anything else? All right. Thank you.
Thank you.
All right. Next, I have Mark Gurley, Conti, and although it lists Ms. Love on the docket, it's Mr. Jellin who filed the motion. Mr. Gurley, good afternoon. How are you?
How you doing, sir?
Very good. And you retained Mr. Jellin, correct?
Yes, sir.
All right. Let me see if I can get Mr. Jellin on the phone.
Judge?
Good afternoon, Mr. Jellin. It's Judge Michael Lynch. I have you on speakerphone and open court on the record. How are you?
Good. It's like a radio now. I got to turn down watching you so we don't get the feedback like when you call me for a free concert ticket.
Perfect. All right, so we're on Mark Gurley, your motion for release from custody.
Yeah, is it Margaret today or Maria's not there today, right?
Yeah, no, it's
No,
me.
no.
It's me.
Nope, Ms. Schneider is right there.
Oh, sorry. I thought you had a day off.
Tomorrow.
Just real quickly.
Yes.
I'll give you the rundown.
Okay.
He's a solid mental health consumer. I don't have any issues right now with competency. He was had a bunch of probation cases. There's only one on the docket because the PD represents him on all the other ones. He picked up a new law violation, which I did represent him on. Ms. Greth declined it. I had him ROR'd before she made her final decision with Judge Duffy. It was ultimately no info. The problem was that the state had moved to kick him out of mental health court before there was a filing decision. So unfortunately, they kicked him out. He now is in limbo. Then the no info happens. I immediately, when the no info was official, I immediately contacted Judge Pork and Ms. Bloomstein as a supervisor. The state, Ms. Bloomstein is refusing to let him back in. In the meantime, he's stuck with this 948 hold. And again, correct me if I'm wrong. I don't want to misspeak, but the issue is there is no warrant. There is no warrant in the system anywhere. So now, in my opinion, he is stuck on a nullity on a 948, which you can't hold him on when there's no new law. Of course, the state could go forward if there was a violation of probation warrant, but there's nothing filed on any of the cases.
All right. Schneider.
I'm a little confused. Are you saying that the only reason he was violated was because of the 20 case?
Correct.
That is
and again, I don't want to be making a mistake here, but I looked at all the cases and there is no warrant for violation of probation on any of the cases that I could see.
Jeez. Sorry, I'm having a hard time signing on here to Odyssey.
And I think if you look at the sheriff's page, it also just shows 948. It doesn't show warrant violation of probation.
I don't know what 948 is.
It's the 948, if there's a new law, it allows them to be held no bond if they're on probation.
I didn't know the code.
I'm only looking at the one that's on, that Mr. Jellin set, and I don't see anything. There's no warrant. There's no indication of. I don't have anything other than his arrest for that new law.
I'm going to check in each case.
Okay.
I don't see a warrant on the 19 case.
There is a warrant?
No.
No, I haven't seen one yet, but I'm going to check them all.
Right.
Sure.
I know it's tough to hear. Ms. Schneider is going to check each one.
Yeah. Hey, Judge, how many hats is Mr. Schneider wearing today? 12?
I'm very impressed with everyone who's putting in their time during all this here. And I know from what I hear, Ms. Schneider's been here pretty much every day.
I don't see the warrant so far here. I see reference to the warrant, but I don't see the actual warrant.
What do you mean a reference?
I see on the probable cause affidavit where it says, violation of probation warrant, but I don't see the warrant.
Yeah, no, I think that's how they get to 948. I think they indicate on there that he's on probation.
Well, it says actual violation of probation warrant, but let me check. I got a couple more. And if not, then you are right.
So the thing is, Judge, I think I would request respectfully that you ROR them, and the PD's got the other cases there. They were notified through the portal of the hearing. I would say if they could just join me to ROR on all of those cases so we can get them out of there.
Well, yeah, we'll let's find out what's going on with the 948, or if there is a warrant. And I'm sure that the public defender sitting here would probably join in on the motion. Okay.
What do you say?
Mr. Wheeler indicated that he represented Mr. Gurley a long time ago, and he would be joining in on your request on the VOPs.
And I'm glad Mr. Wheeler said that, because I think he's a very serious mental health consumer. I don't know why the state kicked him out of there, and I know Ms. Schneider sits over that, so I'd love to get him back to Judge Port, to be honest with you, but Ms. Bloomstein did decline to do that before the, whatever.
One thing at a time, Bill. One thing at a time.
All right.
Let's see if there's a warrant
I'm almost
first.
done, so hold on.
I got another case too when you're ready. Thank you.
Of course you do.
Mr. Jellin, while Ms. Schneider's looking into that, can you just give me the sneak preview of who you're calling next so I can pull the motion?
Well, I'm a little concerned. Ms. Schneider will know about it because it was the one where it was deleted. It's nobody's fault, but they thought there was an agreed order. Her name on the docket is Peterson, Shatoya.
Okay.
But I didn't see it on my hard copy, but I could have had an older one. And Sabrina did confirm today that it's, or Deborah Marshall did, that it's on, and her jail name is Safford, Safford.
Mr. Jellin, it is on, we have it on the docket, so I'm not addressing it right now because we're going to take care of this first one, but it is on the docket, so we will address it, and I'll pull that motion right now, okay?
Okay.
Your Honor, I do not see any warrants on Mr. Gurley, since the state has no prost the very disturbing case involving the false threat.
Wait a minute.
Yeah.
Yes.
Is there a warrant?
Yes.
Ah.
The warrant came in late.
Got it.
Yesterday evening, and I was trying to work on it since it was in custody, and do an affidavit.
We just need one.
Well, let me ask, is there anything other than that new law on those? Any technicals? Sure.
Well, at this point, since the state has the substantive case, I would ask that you not put the warrant through, because if you put the warrant through, he's gonna get arrested again.
All right,
So, Judge, at this time, there's nothing holding him.
all right, so,
But he's still on whatever supervision he was on before.
oh, yes. So let's talk about that. So the case that's on the docket is Mr. Jellen's case, which is 15-6535 CF10A. There's nothing that should be holding Mr. Gurley on that. There's no warrant. There's no longer 948. So Mr. Gurley is to be released forthwith on that. The other probation cases, can someone help me out with those other VOP case numbers, because we'll enter orders
Yes, Your
releasing.
Honor. They are 15-6535 CF10A.
Okay.
15-13989 CF10A. 17-10477 CF10A. 18-1158 CF10A. And 19-5069 CF10A.
All right. So on all of those cases, he's being held, because of a 948, but the 948 should not stand. So he's ROR'd on all of those. There's nothing holding him on those. All right. But Mr. Gurley, let me explain to you. You're still.
Judge?
I'm sorry. Yep.
Because I have no disrespect, but now the problem is, in full candor to the court as always, I believe he was in a program. I believe there was a lot of stuff going on with him. I don't know if he can go back to the program, and the problem is the state kicked him out of mental health court before there was a final decision, and now this is a mess.
All right, Bill, chill. We'll take care of it, okay? We'll take care of it.
I don't know if you're gonna, if you put him out today, which is legal, I don't know where he's going. You see what I'm saying?
I mean, I don't know what to tell you about that, Bill. There was probable cause to believe that he made that bomb threat at the time that he was arrested. Unfortunately for us, the voice recognition was not sufficient, so we declined it. I would hope that the program would take it back. If you need something from me, letting them know that, we declined the case that he was arrested from, I'd be happy to do that, but I don't know what's going to happen today.
Can we do this as a favor again?
Yeah.
Judge Port has a 1:30 Zoom docket that I have a couple cases on for mental health tomorrow.
Okay.
Again, he technically was kicked out of mental health court. If we could put him on that docket, again, with no promises from the state what you're going to do, but at least then Judge Port can straighten out where he's supposed to go and all that.
But then
stuff,
are you going to have him stay in custody overnight so he can be on that docket? Well, then he can't be on the docket if he's not in custody.
I'm sorry.
Well, no, I think what Mr. Jelen is saying, correct me if I'm wrong, Mr. Jelen, I think what he's saying is that Judge Porth is going to have a Zoom docket tomorrow.
I thought he was here tomorrow.
I see. I did.
Yeah, he's here tomorrow. He's not
But
doing
there's,
a Zoom
but there,
docket.
there are two judges handling it tomorrow, and I don't know if that means he also has that docket. I mean, we need to figure out something for Mr. Gurley.
I can tell you that he set a 1:30 mental health case with a guy who's not in custody for me. So that seems to me that he's doing other stuff too.
I have no idea, and if you want him to come before Judge Porth tomorrow, I will email everyone letting him know he's going to be before Judge Porth tomorrow.
All right.
But I would like to make sure he goes home tonight. I think that's appropriate if you're okay with it.
Well, we just released him. So.
Right. I mean,
Okay, great.
no matter what, Mr. Gurley should be released tonight. Mr. Gurley, you have a place you can stay?
Yes, sir.
Okay. So I need you to go there. I need you to talk to Mr. Jelen tomorrow, and probably your public defender who's on the other cases as well. And we can, Ms. Schneider, you're going to be able to get the word out, and
I'm gonna try.
we're going to hope for the best. That will be, of course, attorneys only, because it'll be a Zoom hearing to discuss what everyone wants to do with Mr. Gurley. In the meantime, Mr. Gurley, the only thing I can tell you is wait for a phone call from Mr. Jelen and or.
Okay. Sorry, go ahead.
No, I was going to say I would assume at some point tomorrow evening you guys would have some communication.
Of course.
Yeah, that's what I meant. So you need to speak to your attorneys tomorrow, like late afternoon, evening, to find out what's going on and what they're going to need you to do, because you're still on supervision but they need to work out some details to see whether you're going back to mental health court, okay?
Okay, sir. Can I ask you this question?
Yes, sir.
When I go home, tonight, can I call Mr. Jellin on the phone tomorrow? And
You can
ask
call me
him.
whenever you.
Yeah.
You can call me whenever you want.
Yeah.
Okay.
Mr.
Okay,
Jellin will be waiting for your phone call. You call him tonight as soon as you get out. No, I'm just,
Okay.
give Mr. Jellin.
Only if you promise to talk nice and not yell at me like normal, okay, Mark?
Yes, sir. I'm sorry, Mr. Jellin.
That's all right.
All right,
Yeah,
so.
look what a good job he just did for you.
All right, so Mr. Gurley, I'm letting you out, and you're going to speak to your attorneys tomorrow to find out what's going on from here, okay?
Yes, sir.
All right, sounds good. All right.
Thank you.
Thank you. And then, Mr. Jellin, your other case is Shatoya Peterson.
Yes, and she's in the jail as Miss Stafford, but she's Peterson on the docket, I believe.
Yes, so Peterson is on page 23. And where is Paul Ryan? Oh, yeah, of course. All right, and so we're on Shatoya.
Who you need?
We need Shatoya Peterson or Shante Safford.
Safford, we wanted to do her last because we have two other inmates in here because she's in a quarantine unit. We wanted to bring her last so we can bring everybody out.
All right. Let me, Mr. Jellin, did you?
Judge,
Yeah.
Judge, let me jump in. I apologize. She was reset the other day. There was confusion on both ends, but she's also in an isolation unit for whatever reason,
Okay.
and Christian was going to have her called at 1:30 sharp to accommodate the jail, but if they want to do it at the end, I got no problem as long as we don't forget, okay?
Not a problem. I'm going to put a note for myself right now that we'll give you a call. Mr. Jellin, I don't know how long it's going to take. I'm doing what I can here, but we'll call you as soon as I can.
I wanted to let Mr. Jellin know that the state had conveyed an offer. I didn't realize she was your client, Bill, but I conveyed an offer of 6 months CC with an Elmo. That's it. 6 months CC. No early term on the CC, but that's the offer.
Okay, I mean, I had spoke to Landon too. I will, I'll thank you so much. I'll talk to you guys a little bit later today. Thank you.
All right, Mr. Jellin, I'll call you in a little bit. All right?
Okay,
Thank you. Bye-bye.
Thank you.
Thank you. All right, so we're on page 9, Richard Laveau. And that's actually, it's page 9, 13, and 15. North Broward.
Judge, he is on 3 cases on the docket today. He's on page 12, 16, and page 17.
I've got him on 9, 13, and 15. No, that's okay. I'm hoping I have the right docket, but. Okay.
Violations of probation, Your Honor. Do you see that?
Let me see. All right, so I've got a 20 case. And then is he on probation on that 19 case?
Yes, Judge. He's on probation for the 2016 and the 2018 case.
Okay, I do have those.
Okay. Your Honor, with regard to the 2016 and 2018 violation of probation cases, he is on.
One second. We don't have your client up yet. Do we have Laveau at North Broward? Anyone in North Broward? Thanks, Mr. Wheeler. All right. Mr. Laveau, how you doing? We can't hear Mr. Laveau.
Oh,
How you doing?
I'm good. I'm good, you?
Very good. All right, so now we have Mr. Laveau. Okay? Yes.
All right.
Your Honor, yes, so he's on probation for the 2016 case, for burglary of an abandoned and unoccupied. Contained in the motion I did, include the allegations regarding that case. And then he has a 2019 case, which he was originally arrested for burglary, however, after review, the state did change that charge to, misdemeanor trespass, and I believe the 3 counts on that case are all misdemeanors. He's currently on probation. The allegation for this violation of probation is that he was arrested for a new felony charge. Your Honor, that case is the 2020 case, and my understanding is that it has been the 33rd day for that case. The charges remain unfiled. I would like to indicate that although he's had previous violations of probation, they have been technical in nature, except for the 2019 case that he did pick up. However, I did note on the clerk of court website that in November of 2019, on the disposition, it did indicate that his probation could be transferred to mental health court. So although I don't have competency concerns, I do have concerns as to whether or not he should in fact have been on mental health probation. Perhaps he wouldn't have had any other violations. Mr. Laveau does have family in Broward County. The violation of probation affidavit did indicate that he does have a stable residence. He resides with his brother. He would be able to come over if he was released for those cases. My understanding is that he also does not have any priors besides these 2 violation of probation cases, and then, Your Honor, the unfiled new law. So at this time, I'm respectfully requesting that you place him on pretrial release. If the court's concerned because he does have a violation of probation pending before the court, he would be, defense is okay with him being placed on pretrial with a GPS, just to stay at home.
All right, State.
Your Honor, case number 202177 CF10A does remain unfiled, so he can be ROR'd on that.
Okay.
As far as his other cases, the 1614483, burglary of conveyance, and 196755, trespass of an occupied conveyance and resisting without violence and possession of paraphernalia. The defendant has violated probation. This is his 3rd violation. So he does score prison time, so we're not objecting at this time. And the new case is going to be filed, just hasn't been because of everything that's going on right now.
Okay.
So we don't object to his release, but we would ask that he be released on level 2 with a monitor, PTR level 2 with a monitor.
Well, let me ask you, Ms. Schneider, this is something I was thinking. So he's still on supervision on those 2 cases. And I know that we have the limited monitor situation through pretrial. If I ROR him on the new law and I ROR him on the violations, but order him to continue to report and order as a condition of that ROR that probation put a monitor on him?
Your Honor, the problem with probation is that, as you heard when we were doing the misdemeanor docket, we really don't know how much supervision is being provided at this time. So that's a concern for us. So we would like to have more. I know that Judge Siegel is doing things like putting them on standard PTR and having them call in 2 or 3 times a week and things of that. Maybe something like that would be more appropriate if you don't want to use one of the few monitors that we do have, and I do recognize that we're limited on this defendant. But I don't think that just putting him back on probation supervision when we don't know, my concern is we just don't know.
No, I know, and I get that, but unfortunately, we all have to maybe be a little more flexible than we normally would, and clearly we all are. But my thought is, I don't want to put him on pretrial where he's calling in a bunch of times because I do want him to continue to report to probation. I just don't want to have him calling 3 different places and going to 3 different places. So I understand your concern, but I'm going to hope that probation can take care of this. So what I'm going to do is on the new law, I'm going to ROR you. So that's on 202177 CF10A. I'm sorry, 22177 CF10A. So that's an ROR. On the 2 violation cases, I'm also going to ROR you, Mr. Laveau, but I'm going to order that you continue to report to probation, and I'm going to order as a condition of your release on those cases that probation put a GPS monitor on you. okay?
Yes, sir.
All right?
Yes, sir.
And I'll waive the monitor fee for you, Mr. Laveau. And
Thank you.
sure. State, is there anything else you'd be asking for?
No, sir.
All right, defense?
Your Honor, I would just ask that the court sign an order to have the jail provide him with at least 10 days of medication.
Okay.
Okay.
All right, I'll sign that order, okay? All right, so, and I need to give Mr. Laveau a status date. Let's have him come back on May 20th. Oh, does it? What date? 5/5. I don't think that that's gonna be,
We've started moving towards mid to late May, just in case.
yeah. Let's give May 20th a shot. We'll cross our fingers, okay? All right. And so, Ms. Laveau, when you get out, you need to go and report to probation the next day, all right? So if you get out tonight, you need to go tomorrow. And that's
Yes, sir.
they're going to put the location of probation on your paperwork. But just so you know, it's 3708 West Oakland Park Boulevard, Lauderdale Lakes, corner of Oakland Park and 441, okay?
Yes, sir.
All right, so
Thank
make
you.
sure you report there, all right?
I will.
All right.
Thank you, sir.
Thank you.
All right. Have a nice day.
Thanks, you too. Let me sign this paperwork before we get to the next one. All right. Next up, we have on page 10, Karoy Campbell. North Broward. Okay. So that'll be Croy Campbell on 10 and 14.
On his way.
All right. So are we? All right. So that should be deleted. Okay. When is that? All right. Well, we've already got Mr. Campbell on the way up, so let me just let Mr. Campbell know. They said he's approaching, so I'll just let him know. Mr. Campbell, good afternoon. How you doing?
Good, are you?
Very good. So, Mr. Campbell, I need to roll you to tomorrow when Judge Porth is going to be here, okay? So, on Mr. Campbell, I'm going to reset for that for tomorrow on the 1:30 docket for Judge Porth, okay?
Oh, so it's definitely gonna be around 1:30?
At some point, 1:30 or later. This is the 1:30 docket, and it's 5:15, so, yeah, but you'll be up tomorrow, okay?
All right, thank you.
All right, no problem. So I'm going to delete this from today. We'll put it on for tomorrow.
Yeah. All right, thanks.
Thanks. What was the other one that's an FC? Diaz, Ruben Diaz on page 10. All right.
And 12 and 23.
Got it. Thank you. All right. So on Ruben Diaz on pages 10, 12, and 23, I'm going to reset that for tomorrow, April 2nd, on the 1:30 docket. Okay. All right. Mr. Diaz, how you doing?
How you doing, Judge?
Very good.
I'm doing good.
Good.
Thank you.
So, Mr. Diaz, I need to put you on tomorrow afternoon's docket. Judge Porth is going to be here, so he can address your case, okay?
Tomorrow afternoon?
Yes, sir. So we'll see you tomorrow afternoon, okay?
And he will be in front of me?
You'll be looking at him instead of looking at me.
Okay.
All
All right, Judge.
All
Thank
right.
you. You take care.
You
Thank
too, Mr. Diaz. Take care. Okay?
Bye-bye.
Thank you.
Thank you.
Thanks. All right. Next, we have on page 11, Giovanni Joseph. That's on pages 11 and 13. Maine. Okay.
Main Jim?
Maine, Giovanni Joseph.
Hey, how you doing?
Pretty good. How are you, sir?
Good.
Good. All right. And this is going to be a negotiated resolution? All right. State, can you tell me what the negotiations are?
Yes, Your Honor. The negotiations are that in exchange for a plea, the state is going to place agree to place Mr. Joseph on 6 months of community control with no early termination, followed by 12 months of drug offender probation.
Okay. Any special conditions on any of those three cases?
I think on the cases that he is that are all of them VOPs? They're all VOPs, then whatever conditions were previously imposed.
Okay, so it's going to be a reinstate, modify, new term, 6cc, followed by 12 drug offender probation?
Correct.
With any of the same terms and conditions previously
Correct.
entered? Okay. And I'm sorry, I should tell you guys, the docket, I don't know what are VOPs and what aren't.
I know.
So if you can let me know, he's got the 2 VOPs in this, that would help me out. Okay? Let me just pull up his warrant.
3K.
On that, the 194648, is he on supervision for that count two, resisting without, or is it just for the possession of cocaine? Do we know?
I don't know right now.
All right, I can look. I was just wondering, on the last one, on the one on page 13, the 194648, only the possession of cocaine, correct? Okay, all right. All right, Mr. Joseph, best you can, raise your right hand for me. You swear to tell the truth, the whole truth, nothing but the truth?
Yes, sir.
All right, you can put your hand down. Please state your name, spell your name for the record.
Giovanni Joseph, JIVONNI JOSEPH.
All right, and my understanding is you'd like to resolve all three of your violation cases, is that correct?
Yes, sir.
All right, the state's made an offer that if you admit you violated, I'm going to reinstate modified to a new term of 6 months community control, followed by 12 months drug offender probation with no early term. Is that no early term only as to the CC or to the whole thing?
Only as to the CC.
Okay, so no early term on the CC. All the other terms and conditions that were originally entered into would remain in effect. Is that your understanding of the offer?
Yes, sir. Can I ask one question?
Yes, sir.
Is I'm be able to go to work and go to like church on community control? Cause I do work.
Yeah, what you need to do is you need to talk to your community control officer. When you're on community control, what you need to do is be able to give your schedule in advance. So you'll be able to do those things that are approved. The main thing, though, is everything has to be pre-approved. You can't just go and do what you want. You got to make sure community control is aware of it. You don't want to come right back with a violation because you deviated from your schedule, okay?
All right.
All right. So, I told you what the offer is. You wish to accept that offer on all three cases, correct?
Yes, sir.
All right. How old are you, sir?
I'm 20 years old.
Okay. How far did you go in school?
I stop at 8th grade.
Okay. Do you read and write English?
Yes, sir.
All right. Have you had enough opportunity to discuss the violations as well as the offer with your attorney?
Yeah.
All right. Mr. Wheeler, are you representing him today for today's purposes? Oh, I'm sorry. I didn't realize that. Maybe. Oh, there you go. All right. So let me go back. I just wanted to make sure. All right. So, Mr. Joseph, on case number 19225 CF Tanay, you were originally placed on supervision for possession of cocaine. That's punishable by up to 5 years prison. You understand what the maximum is?
Yes, sir.
All right. On 191433 CF Tanay, you were placed on supervision for grand theft in the third degree, also punishable by a maximum of up to 5 years prison. You understand what the maximum is?
Yes, sir.
All right. On 194648 CF Tanay, you were placed on supervision for possession of cocaine, also punishable by up to 5 years prison. You understand what the maximum is?
Yes, sir.
All right. I am going to be placing you back on supervision. What that means is if you were to violate the terms of supervision and the state could prove that it was a willful and substantial violation, you would still be looking at up to the maximum penalty. Do you understand?
Yes, sir.
Okay. Are you currently under the influence of alcohol, drugs, or medication?
No, sir.
Any history of mental health problems?
No.
Other than what I told you I was going to sentence you to, has anyone made you any promises or guarantees to get you to admit you violated?
No, sir.
Has anyone threatened you or coerced you to get you to do this?
No, sir.
Are you doing this because you believe it's in your best interest to resolve your cases this way?
Yes, sir.
All right, you understand if you didn't want to resolve your cases this way, we'd have a final hearing. The state would have to prove that you willfully and substantially violated the terms of your supervision. But by entering these admissions, you're giving up your right to have that hearing. Is that what you want to do?
Yes, sir.
All right. I'm going to read the allegations in the violation warrant to you. Allegation 1 is that you failed to promptly and truthfully answer all inquiries directed by probation. That on March 12, 2020, you answered untruthfully an inquiry by probation as to you stating that your aunt and cousin had the coronavirus and you've been in contact with them. Allegation 2 is that you failed to make restitution payments, that you're $250.02 in arrears as of March 13th, 2020. Allegation 3 is that you refused to submit to random testing, that you refused to submit to a urinalysis test on March 12th, 2020 by not reporting for your instructed drug test. Are you admitting you violated in those 3 ways?
Yeah.
All right. I find the defendant is alert and intelligent. The admissions entered freely and voluntarily with a knowing and intelligent waiver of his rights with the assistance of an attorney with whom he is satisfied. I'm going to accept the admission on all three cases. On 19225 CF10A, I'm going to reinstate, modify to a new term of 6 months community control. No early term on the community control. That's followed by 12 months drug offender probation. All the other original terms and conditions will remain in effect. On 191433 CF10A, I accept the admission. I'm going to reinstate, modify to a new term of 6 months community control with no early term. That's going to be followed by 12 months drug offender probation, and all the other original terms and conditions will remain in effect. On 194648 CF10A, I accept the admission. I'm going to reinstate, modify to a new term of 6 months community control, no early term on that, followed by 12 months drug offender probation. All the other original terms and conditions will remain in effect. All counts, all cases to run concurrent. Anything else, State?
No, sir.
Defense? All right. Sir, you have 30 days to appeal. If you can't afford an attorney, I'd appoint one for you. And, sir, your paperwork is going to be stamped with where you need to report, and I think they just handed it to you as well. But it's 3708 West Oakland Park Boulevard, Lauderdale Lakes. I'm ordering that you report within 24 hours of your release. All right?
All right, thank you.
All right. Sir, can you state your address and phone number on the record?
I'm going home with my mom, so like she just moved to Court Spring. Can you call her on the phone? She could tell y'all the address right now.
Do you have a phone number that maybe you can give so that we can track down your information?
Yeah, 954.
Okay.
687.
Okay.
2941.
2941. What's your mom's name?
Valerie.
All right. Anything else that we need from Mr. Joseph right now? All right. Thank you, Mr. Joseph.
All right.
All right.
How many prints, Your Honor?
Actually, 0. They're all violation cases. He's already been printed.
Okay, thank you.
Thank you. All right, the next one I have is on page 12, Jose Olguin, North Broward.
Judge, what was that name again?
It's Olguin, Olguin.
We don't have that.
Oh, on the motion it lists.
Gonzalez.
On the motion it lists Jose Gonzalez Olguin. On the docket it just says Jose Olguin. I'm sorry, I just saw that.
Oh, no problem. Gonzalez. ¿Habla inglés? No. Oh, shit. Judge, we need a Spanish interpreter.
All right. You know what? I'm going to put him on recall. I'm going to. Is Mr. Mr. Martinez is there? I'm sorry, I didn't know. Do you want to address all your cases now, and I'll get an interpreter on the line?
Yes, Your Honor. That'd be perfect.
Okay, great. Let me see if I can get an interpreter.
Oh, he's my lawyer.
Good afternoon, sir. 1 second. Un momento. I speak to Mr. Sinisi, please. Hi, Mr. Sinisi. This is Judge Michael Lynch. I have you on speakerphone and open court on the record. How are you?
Good afternoon, Judge. How are you?
Good. Would you be able to help us out on a couple cases in interpreting? If not, that's fine. I can move down the list.
I'm driving right now on 75.
Not a problem, Mr. Sinisi. Be safe. I'm going to go down the list, okay?
Okay, thank you. I'm sorry, Your Honor.
No, not a problem at all. Take care.
You too. Likewise.
Hello?
May I speak to Sandra Bryan, please?
Hi, yes, speaking.
Hi, Ms. Bryan. This is Judge Michael Lynch. I have you on speakerphone and open court on the record. How are you?
Oh, boy. Fine. How
Good.
can I help? Yes.
I was wondering, I have a couple cases that I needed a Spanish interpreter. I was wondering if you were available to assist us. If not, I understand. I can continue to go down the list, but you are next.
No, it's fine. No, I can talk. Is this going to be on the phone or are you doing a Zoom? Or?
No, it's going to be on the phone. I'm in the magistrate courtroom. I have, and I'll give you the name. It's
Okay.
Jose Gonzalez Olguin, Olguin, case number 19-3284, CF10A, and he is present over closed circuit TV from the jail. So I know that this is not how we normally do things, but I'm going to swear you in kind of over the phone. You swear to interpret from English to Spanish, Spanish to English to the best of your ability?
Yes, I swear.
Okay, and please state your name, spell your last name for the record.
Sure. My name is Sandra Bryan. The last name is spelled Bryan.
All right. And, all right, good afternoon, sir.
Buenas tardes, señor.
Okay. And Mr. Martinez? Good afternoon. All right, we're here on the motion for release.
Estamos aquí para la moción sobre la libertad.
Okay.
Sí. Entiendo.
As stated in our motion, Your Honor, you previously considered this, however, circumstances have changed significantly, and there are 5 things that I wish for Your Honor to consider.
Your Honor, I know someone was speaking, but I couldn't make out the words just now.
Okay.
This is the interpreter.
Mr. Martinez, I need you to speak as loud as you can because you can't really hear all that well in here, okay?
Yes, Your Honor.
All right, so say that one more time.
Your Honor, as stated in our motion, Your Honor previously considered this. However, there are 5 quick points I wish for you to consider, given that circumstances have changed significantly.
I'm sorry again. It's not distinct. The words are not distinct. I hear louder, but I can't make out the words.
All right, maybe on this one we will try from the PD phone. So what I'm going to do is we're going to call you right back, Ms. Bryan. I'm going to give your number to one of the assistant public defenders, and we'll see if having you at the phone closer to the TV, maybe you can hear better.
Thank
All right,
you.
so
No
we'll
problem.
call you right
I'll be
back.
waiting.
All right.
Okay, bye.
Sorry? Yeah. Let me do Sandra. Okay. Okay, thanks. All right, so let's see if this works a little bit better. Mr. Martinez, third time's the charm. All right.
Your Honor, as stated in our motion, you've already considered this, but circumstances have changed significantly. There's 5 things we wish for you to please consider. Number 1, this gentleman is 63 years old, and obviously it's well established at this point that those over 55 are at much higher risk. Many jurisdictions, sheriffs, and district attorneys throughout the country have agreed to release
Mr. Martinez, I need you to break it up a little bit so the interpreter can interpret, okay?
I'll slow down, Judge.
Thank you.
Judge, can we also just confirm that he can hear her, the interpreter?
That the defendant can? All right. So, Mr. Gonzalez, can you hear the interpreter?
Señor González, ¿usted puede escuchar a la intérprete? ¿Me puede oír?
No.
Maybe.
Oh.
Maybe Mr. Martinez can say me something.
All right.
Can we call from the state's phone? We just have
Sure. We'll try every phone in here. We'll figure it out. All right. So, Ms. Bryant, we're going to call you back from a third phone. Let's see if that works.
Okay.
All right.
Okay, thank you.
Thank you.
Mr. Martinez can translate me?
One second.
Okay.
Hey, Rick.
Hello?
Yes, I hear you so good.
Okay, great. Let's try it again.
All right. Let's see how this works. All right, you're on, Mr. Martinez.
Thank you, Your Honor. Your Honor, many jurisdictions, sheriffs, and DAs throughout the country have agreed to release nonviolent offenders, and we should follow suit, reducing the jail population and the risk to elderly nonviolent offenders, such as Mr. Wing.
Okay, su señoría, mi cliente corre riesgo dentro de la cárcel alrededor de los demás que están presos. I'm not sure if I heard everything.
Number 2, Judge, the state will likely emphasize that, the alleged victim suffered through some injuries as stated in the probable cause affidavit. However, after investigating this case, visiting the scene, and depositions.
Wait.
Ciertos daños que no están incluidos en el affidavit de causa probable.
Mr. Martinez, I need you to do like 2 sentences each so the interpreter can interpret and then pause and then start back up, okay? All right. So I'm sorry, Ms. Bryant, I don't know where you left off there.
I heard that there were some allegations. I interpreted what I thought I heard, which was that there were allegations about injuries that were not included in the probable cause affidavit.
No. Okay. Let's try this one more time. Slow and loud, Mr. Martinez.
Your Honor, number 2, he was involved in an accident that was not his fault. Go ahead.
Número 2, él estuvo envuelto en un accidente. Did you say an accident? in an accident. Okay, que tuvo mi cliente envuelto en un accidente that was not what?
Not his fault.
Ah, que no fue culpa de él, dice el abogado. Estuvo en un accidente que no fue culpa de mi cliente. Okay, you can go on.
And I say that based on the evidence that we have heard investigating this case, including the fact that the alleged victim did not stop at a stop sign.
I heard this part, including that the alleged victim did not stop at the stop sign.
I'll speak louder, Judge.
All right, thank you.
Let me know if I'm too loud. Judge, the point I am making is that this gentleman is not a criminal. He is a hardworking gentleman who was involved in a car accident that wasn't his fault, and then he panicked.
Lo que quería decir, su señoría, es que ese caballero no es un criminal. Él es una persona que trabaja muy duro. Él estaba envuelto en un accidente automovilístico, el cual no fue culpa de él. No fue culpa de él.
Number 3, Your Honor, this gentleman is absolutely not a threat to our community. He is not violent. I've researched his criminal history. Please go ahead.
Y tercero, su señoría, esta persona no presenta ningún riesgo para la comunidad. Él no tiene ninguna violencia en absoluto en sus antecedentes y no presenta amenaza para la comunidad.
With the exception of one prior driving without a license, he has no other criminal history in his life.
Con la única excepción que una vez tuvo un caso de haber estado manejando sin una licencia válida, él no tiene ningún antecedente penal en su vida.
Number 4, Your Honor, please do not let the fact that he has an immigration hold influence your decision to remove the monetary bail as we're requesting.
I'm sorry, can you repeat that, please? I'm sorry.
Please do not let the fact that he has an immigration hold weigh in on the decision to remove the monetary bail.
It's not the volume. It's not the volume. Can you separate the words a little bit?
Slow down, Gus.
It is ICE's prerogative
It is whose prerogative?
ICE.
Okay. Que el Departamento de Inmigración es el que puede decidir
to come and pick up offenders from the jail within a reasonable period of 48 hours.
Ellos son los que tienen el poder de decidir si van a venir a la cárcel a recoger un acusado dentro de las 48 horas. Did you say within 48 hours?
Yes.
Yes, okay, dentro de las 48 horas. Ellos son los que deciden eso. Okay.
My understanding is that with limited exceptions, they stopped picking up low-level offenders.
My understanding is that with limited exceptions, what?
They have stopped picking up low-level offenders.
Yo tengo entendido que con algunas excepciones limitadas, ellos han dejado de venir a recoger a personas acusadas de ofensas menores o de bajo riesgo.
Given his age, he should not remain in custody during this pandemic, risking his health and safety.
Y por lo tanto, él no debe de quedarse encarcelado durante esta pandemia, corriéndose riesgo a su seguridad.
Merely because he's too indigent to post the requisite monetary bail.
I'm sorry. One more time, please. It's like an echo. That's what it is.
Merely because he cannot afford the monetary bail.
Que él no se debe de quedar en la cárcel solamente por la simple razón de que no pueda pagar esta fianza monetaria.
Number 5, he has ties to our community, including a niece and family.
Él tiene enlaces con la comunidad, inclusive él tiene su familia.
In summary, Judge, please remove the requirement of monetary bail because
En resumen, su señoría, hemos comprobado la razón por la cual estamos pidiendo esto según para la fianza monetaria. Según la fianza monetaria.
Because open schedule with a GPS is more than enough to protect the community and ensure future attendance in the case of an at-risk 63-year-old gentleman with no felony criminal history.
Y colocándole un monitor electrónico basta y es suficiente para asegurar que él se presente en el futuro y para asegurar la protección de la comunidad contra una persona como él que está corriéndose el riesgo porque tiene 53 años de edad.
Thank you, Judge.
Thank you.
Gracias, señoría.
All right. Schneider?
Yes, Judge, we object to the release of this gentleman. I don't want to belabor the facts since I know you've already heard them. But we dispute counsel's version of the facts in that there is video that shows the victim did stop at a stop sign before entering the turn lane. Is that too much? That it shows that the victim did stop at a stop sign before making the turn. However, that's neither here nor there for this case. The defendant is charged with leaving the scene of a crash with serious bodily injury. After crashing into the motorcyclist, he left the scene. That motorcyclist lost a leg. And he is a leg, yes, correct, yes. And the victim is very involved in this case and opposed to this defendant receiving any change in his bond status. Bond status be changed. We believe, as to the claims that this defendant has no prior history, we don't know. He's not from this country. What we do know is that he fled the scene after hitting someone and clearly seriously injuring them. He is in this country illegally. He is a Mexican citizen. And the effect of releasing him would be that ICE would have to pick him up and deport him. I've unfortunately come across this catch-22 in some homicide cases. And if a person in this status is released because they're here illegally, they don't get the immigration process, they're deported by law. And he would completely evade responsibility for this crime if that were to happen. So, in a sense, both because of his doing and because of things that aren't of his own doing but still exist, release makes him an absolute flight risk. makes him a flight risk. That's our position, and we object to any change of his bond status as you have previously determined was appropriate.
You may clarify
What,
something the state said,
what, Mr. Martinez, hold on. Okay. Mr. Martinez?
Thank you, Judge. Your Honor, the state said, open quote, quote unquote, I wrote my notes here, the effect of releasing him is deportation. I feel that's inaccurate. Go ahead, Madam Translator. The state said the effect of releasing him is deportation. That is not quite accurate. Jose Gonzalez Oguin, regardless of the immigration issue, is entitled to reasonable bail. But for the fact that he is indigent, he would have been out of the jail months ago. ICE is not picking up low-level offenders. Go ahead.
ICE is not picking up.
The only reason he is in jail is because he cannot afford the monetary bail, which is what I'm asking the court to please remove. Lastly, my point was, Judge, that no criminal behavior, for example, reckless driving, DUI, anything like that, caused the accident. He made a terrible mistake and panicked after the motorcycle crashed into him.
Crashed into him.
Bottom line, Your Honor, he's 63 years old. He's been in our country for many years. He has only one misdemeanor prior. He's not a threat. He's at risk. Please release him on non-monetary conditions, Judge.
Thank you. All right, and I had, as Mr. Martinez had indicated, I'm the judge assigned to this case. So I'm pretty familiar with the facts because we addressed his bond in a previous motion. And I still believe that the bond that was set is a reasonable bond amount. Therefore, the motion is denied. Thank you. All right. Ms. Bryan, why don't I give you a break and we might call you. We're going down a list, so we might mix it up a little bit, okay? All right. Thank you so much. Stay safe. Okay. Martinez, what else do you have?
page 16 of Your Honor's docket.
Gotcha. Yeah, that's not the 14. Okay. And let me, we'll start up here. I'm gonna call the next interpreter and we'll see if, we can get this done.
Hello?
I speak to Mr. Felicioni, please.
Yeah, this is him.
Hi, this is Judge Michael Lynch. I have you on speakerphone in open court on the record. How are you?
How you doing, Judge? Good to hear from you.
Good. I'm going down my list of interpreters. I'm in the magistrate courtroom. I also understand it's almost 6 o'clock, so you might not be available to do this. But if you could spare a few minutes, I'd really appreciate your assistance with interpreting.
I got a question, Your Honor.
Yes, sir.
How am I going to say no to the Honorable Judge Michael?
Oh, that is a good answer. That's a great answer. I appreciate that. Let me. So we need defendant Ramon Machado Fernandez. Okay, and here he is. So I know we can't really do this over speakerphone, but you swear to interpret from the English to Spanish, Spanish to English to the best of your ability?
I do, Your Honor. For the record, Igor Felicioni, Spanish interpreter. Good afternoon, Your Honor.
Good afternoon. All right, so we're on, this is Ramon Machado Fernandez.
Señor Ramón Machado Fernández.
Okay. All right. Good afternoon, sir.
Buenas tardes, señor.
Buenas tardes.
Good afternoon.
All right, and Mr. Martinez?
Your Honor, there's 3 things I wish for you to consider. The first one is the adamant wishes of the alleged victim, Alejandro Garrido.
Your Honor, I honestly cannot, the interpreter cannot understand what
Okay.
Mr. Martinez is saying.
All right, hold on. Let's. Do we already have that on max volume? Probably.
It's very close.
Okay, yeah, we're now at max volume, and Mr. Martinez, let's give this another shot. Slow, loud, and I would say 1 to 2 sentences.
Okay, Judge, let me know if I'm going too loud. The first thing I wish for the court to consider, please.
Lo primero que yo quisiera que la Corte considerara, por favor,
are the wishes of the alleged victim, Alejandro Garrido.
es la supuesta víctima Alejandro Garrido,
who has been very adamant that he wants these charges dropped. Not to a misdemeanor or time served, but outright dropped.
que ha sido muy convincente de que quiere que los cargos sean desestimados. No que le den tiempo servido, que desestimen los cargos.
Mr. Garrido made extensive efforts to get in touch with the state attorney's office in February, and his calls were not returned.
El señor Garrido hizo esfuerzos sobrehumanos para ponerse en contacto con la oficina de la Fiscalía en el mes de febrero y su llamada no fue devuelta.
Finally, on March 2nd, he showed up unexpectedly at our lobby, pleading for assistance, advising that he wanted these charges dropped.
Finalmente, el día 2 de marzo, el señor se presentó en nuestro lobby suplicando que lo ayudáramos, pidiendo que los cargos fueran desechados.
He further insisted that him and Mr. Machado Fernandez are friends, that they were drunk, and that they were quote-unquote horsing around and got a little out of hand.
Él insistió adicionalmente que él y el señor Machado son amigos y que simplemente las cosas estaban jugueteando y las cosas se salieron un poco de las manos.
He further advised that he did not sustain any injury other than a minor superficial poke on the earlobe.
Además, dijo que él no sufrió ninguna lesión aparte de una herida pequeñita punzante en el lóbulo de la oreja.
Obviously, we don't have the power to drop charges, and we referred him to the state attorney's office again. And since then, he's made extensive efforts to make an appointment, but he says that the state has not accommodated him.
Obviamente nosotros no tenemos la facultad de que los cargos sean desestimados, solamente lo puede hacer la fiscalía. Y nuevamente él ha intentado de muchas maneras hacer una cita y no se le ha devuelto la llamada.
Number two, Mr. Machado Fernandez has extensive ties to the community. He has a wife and children who urgently need him.
Adicionalmente, número dos, el señor Machado Fernández tiene lazos profundos con la comunidad, tiene una esposa y tiene un hijo que lo necesitan fervientemente.
His wife calls me every few days, desperately pleading for assistance because she needs his help and is struggling to make ends meet.
La esposa me llama a mí cada 2 o 3 días suplicándome que la ayude porque necesita tener a su marido y que la ayude a pagar las cuentas.
Lastly, number three, today I learned that his wife is self-quarantining because she has tested positive.
Por último, número 3, hoy me enteré que la esposa está haciendo cuarentena porque resultó positiva.
She's doing fine at home so far, but other family members and friends are temporarily taking turns taking care of the children.
Ella está en la casa, está bien, pero está haciendo la cuarentena y algunos familiares y amigos están tomando turnos para cuidar a los niños.
If released, he needs not only to be able to work, but to assist his wife, tend to the children, and handle his family's affairs.
En el caso de que el señor sea liberado, no solamente se tiene que encargar de cuidar a su esposa, tiene que trabajar y tiene que cuidar a sus hijos y manejar sus asuntos familiares.
Standard pretrial is enough to ensure attendance while we wait for the state to finally meet with the alleged victim and hopefully honor Mr. Garrido's wishes of not processing this case.
Nosotros consideramos que dejar al señor en libertad en condiciones estándar es suficiente para darle el tiempo a la fiscalía para reunirse con la supuesta víctima y esperemos que cumplan con los deseos del señor Garrido y desestimar los cargos.
Thank you, Judge.
Gracias, juez.
Thank you. State.
Your Honor, while a victim's wishes are important to the state,
Su señoría, si bien los deseos de la víctima son importantes para la fiscalía,
they do not mandate how we proceed on a case.
ellos no dictan cómo vamos a proceder nosotros con un caso.
We intend to proceed with this case.
Nuestra intención es de proseguir con este caso.
We offered to agree to release this defendant on PTR level 1 supervision with a GPS monitor.
Nosotros ofrecimos llegar a un acuerdo y liberar al señor en condiciones previas a juicio, nivel 1 con un monitor GPS.
Yet this gentleman remains in custody because his attorney wasn't willing to accept that.
Y sin embargo, este caballero sigue estando bajo arresto porque su abogado no estaba dispuesto a aceptar esas condiciones.
We still stand by the fact that those would be appropriate conditions of release at this point in time.
Nosotros nos mantenemos firmes en nuestra convicción que estas son las condiciones apropiadas para una liberación en este momento.
This defendant has a prior history that includes a robbery and a false imprisonment.
Este acusado tiene un historial criminal que contiene robo y privación ilegítima de libertad.
And subsequent to this case, he was arrested for a battery on his girlfriend.
Y en relación a este caso, él fue arrestado en una oportunidad por una agresión física sobre su novia,
which eventually had to be dismissed because she didn't want to go forward with the case.
que fue desestimado eventualmente porque ella no quiso proceder con los cargos.
But we feel that releasing him on level 1 PTR with a GPS monitor is appropriate at this point, given all of the circumstances that have been explained to the court.
Dadas todas las circunstancias que le hemos explicado a la Corte, consideramos que liberar al señor con condiciones previas a juicio nivel 1 con un monitor GPS son apropiadas.
And again, he only remains in custody because that wasn't good enough for his lawyer.
nuevamente, él sigue estando bajo arresto porque las condiciones ahora fueron lo suficientemente buenas para su abogado.
I have a question. It looks like he was originally out on a $3,000 bond, level 2 GPS.
Correct.
Yo tengo una pregunta. Parece que él estaba libre originalmente con una fianza de $3,000 y un GPS, ¿correcto?
Actually, mine says level 1 GPS, but I could be wrong on that.
It was level 2. I'm looking at the magistrate order.
Era un monitor nivel 2. Estoy viendo la orden del magistrado.
And the allegation, the violation of pretrial, the only allegation was that case that the state dropped.
Y el único alegato de la violación de las condiciones previas a juicio fue ese caso antes mencionado que la fiscalía desestimó.
Martinez, if I put your client back on level 2 with a $3,000 bond, is that acceptable to you?
Señor Martínez, si pongo a su cliente en un nivel 2 de supervisión con una fianza de $3,000, ¿eso es aceptable?
Your Honor, in lieu of Your Honor denying our motion, then of course we would accept that. My concern, however, is that he's going to have to not only be working, but he's going to have to be bouncing back and forth between his wife's house, where she's self-quarantining, where the children are, that he has to pick them up, take care of them, bring them food, and then also working. And
let's let the
I'm just concerned that he's not going to be able to do that if he's on house arrest for a case that, you know, hopefully.
Mr. Martinez, we've got the interpreter. We've got the interpreter.
Soon. It's just not necessary to protect the community or ensure attendance for him to be on house arrest, is what I'm saying, Judge. And it would just.
Mr. Martinez, can you hear me?
To provide for his family and handle this situation.
Can you hear me, Mr. Martinez?
Yes, Judge.
Okay, I was trying to stop you. We have the interpreter, and you kept going, which I understand this is not easy, but there's no way that the interpreter got that. I don't think.
Su señoría, si usted lo que está diciendo es que a cambio de negarnos la petición, va a hacer eso, pues por supuesto. Mas, sin embargo, mi preocupación es que este señor tiene que trabajar. Entonces, adicionalmente, vamos a tener que él tiene que ir a casa de la esposa que está en cuarentena y a casa de los niños. Va a tener que llevarles comida y también va a tener que estar trabajando. Eso es difícil, máximo si lo vamos a considerar liberarlo en condiciones de arresto domiciliario por un caso que de esta naturaleza él no va a poder manejar sus asuntos familiares.
I stand corrected.
Igor is very talented, Your Honor.
He is. I knew I called the right number.
Hey Gus, can you hear me?
Yes.
All right. How about we agree to pretrial level 2 with the Elmo and make ask the court for an exception for purposes of child care?
Sure.
Okay. Does that work for the court?
Acordamos un previo juicio nivel 2 y que la corte haga una excepción para cuidados de los niños.
All right. Over state's objection, I'm granting that motion. Bond will be set at $3,000 as it originally was. Level 2 with the GPS. However, he shall be permitted for child care and also medical care of his wife. I'll allow him to do what he needs to do as long as he lets pretrial know.
Ok, por encima de la objeción de la fiscalía voy a fijar la fianza en $3,000. Lo voy a dejar en libertad con un monitor GPS nivel 2, pero con la excepción de que él puede hacer todas las diligencias necesarias para el cuidado de sus hijos y su esposa, siempre y cuando se lo haga saber al oficial del previo a juicio.
Sí, pero yo no mi familia no tiene dinero en estos momentos para pagar una fianza.
My family doesn't have any money right now to pay the bond.
Mi mujer no está trabajando y tengo los niños y ella sola en la casa. Debo renta, todo.
My wife is not working right now, and she's there, and she has the kids. She's alone at the house, and she doesn't have any money to pay rent.
ROR level 2 with the same conditions that I just laid out, and I'll waive the GPS monitoring fee.
Ok, señor, en ese caso lo voy a liberar bajo su propio reconocimiento, más sin embargo con las condiciones que ya le dije anteriormente, un monitor GPS nivel 2 y el monto de pago del monitor queda perdonado en este caso.
Okay.
Okay,
Gracias.
and I'm going to give you a status date of May 20th.
Le voy a dar una fecha de audiencia de estatus del 20 de mayo.
All right.
Okay.
Anything else, defense?
No, thank you, Judge.
Sure. Anything else, state?
No, sir.
All right. Thank you.
Okay.
Mi-
Muchas gracias.
Okay. And Mr. Martinez, did you have anything else you needed to address?
One more, Your Honor, is Rolando Perez Corcho. I have it on page 17. I would guess by the pattern, you might have it on 15. We've been 2 pages ahead of you.
Still on 14. Okay.
Also, our copy is 19009976.
All right. So we'll get him. And Mr. Felicioni, do you mind helping me on one more? I'm really sorry.
We've been over this, Your Honor.
Thank you.
No problem.
Okay. And good afternoon, sir.
Buenas tardes, señor.
Buenas tardes.
All right. And this is on Rolando Perez. Oh, I'm sorry. Is that yes? Rolando Perez Corcho.
¿Usted es Rolando Pérez Corcho?
Sí, señor.
Yes, sir.
All right. And Mr. Martinez.
Your Honor, first regarding the facts of this case, the probable cause affidavit only gives you a quarter of what occurred, or half of the story at most.
There's somebody
Wait.
talking over. Excuse me, Your Honor. There's somebody talking over Mr. Martinez.
All right. Ms. Martinez, try that one more time.
Let me know if I'm too loud. Your Honor, the probable cause affidavit only gives you a quarter of what occurred, perhaps half of the story at most.
Su señoría, la declaración jurada de causa probable solo da un cuarto de los eventos que ocurrieron.
What it fails to tell you is that the alleged victim would incessantly contact Mr. Perez Colcho whenever it was convenient for her or whenever she needed something.
No, interpreter cannot understand. I apologize.
No, that one more time, Mr. Martinez. Just slow it down a little bit. And there's no such thing as too loud.
Alleged victim would incessantly contact Mr. Perez Colcho.
La supuesta víctima trató de contactar al señor Corcho.
Whenever things would go wrong, she would then seek to enforce a prior injunction whenever they weren't getting along.
Ella tenía una medida cautelar de protección.
In this case, the PCA also fails to explain to the court that Mr. Perez Cocho and the alleged victim agreed for him to pick up some items in the parking lot.
En este caso también el señor Pérez Corcho y la supuesta víctima habían acordado que él se iba a acercar a recoger unas cosas en el estacionamiento.
And then the alleged victim's new boyfriend used his car to block off Mr. Perez Cocho to pin him in.
Y entonces el nuevo novio de la supuesta víctima utilizó el carro de la supuesta víctima para bloquear al señor Corcho.
Got out of the car in a violent and aggressive manner, began hitting Mr. Perez's window and challenging him to fight.
Y se salió del carro de manera muy violenta y agresiva y se bajó del carro y golpeó la ventana del señor Pérez Corcho, instándolo a pelear.
Instead of escalating the situation or getting out of the car to fight, he tried to drive away around the new boyfriend's car and nearly hit him in the corner in an attempt to escape.
En vez de escalar la situación y pelear, el señor intentó irse manejando y alrededor del carro del nuevo novio de la supuesta víctima y casi lo golpea.
Moving on, number 2, Your Honor, this gentleman's only priors are 2 driving while license suspended. This is after checking on CCIS.
El señor, el número 2, los únicos Y el único historial criminal que tiene el señor son 2 cargos de manejar con una licencia de conducir suspendida.
Third, 3, Your Honor, many jurisdictions in our country have either eliminated or reduced monetary bail, recognizing that it is fundamentally unjust for those with money to get out of jail versus those without money.
Adicionalmente, número 3 es, en todo el país las fianzas monetarias están siendo reducidas porque es fundamentalmente injusto que los que tienen dinero salgan de la cárcel y los que no se queden ahí.
In this case, but for the fact that he's indigent, he would be out of custody. Hence, we ask the court to eliminate the requirement of monetary bail.
En este momento, entonces, le pedimos a la Corte que elimine el requisito de la fianza monetaria.
And number 4, Your Honor, he is 56 years old. He is at much higher risk of contracting or having adverse consequences, including death, from this pandemic when compared to younger gentlemen such as yourself and I.
Entonces, número 4, a causa de la edad del señor, él está en un riesgo más agudo de morir si llega a contagiarse de la enfermedad que está actualmente en modo pandemia, más allá que cualquier persona joven como usted o yo.
In conclusion, Judge, we just ask, please remove the requirement of monetary bail and kindly release him on pretrial release, whether it be open schedule with a GPS or otherwise. That should be enough to protect the community and ensure attendance at future proceedings.
En conclusión, que solicitamos que el señor sea liberado sin fianza, en condiciones estándares previa juicio, con GPS, con un calendario abierto. Eso sería suficiente para proteger los intereses de la comunidad.
Thank you. Schneider?
Yes, Your Honor, the state objects to any change to the conditions of release for this defendant.
Su señoría, la Fiscalía objeta cualquier cambio en las condiciones de liberación para este acusado.
We may disagree on what the nature of the relationship between the victim and the defendant was, but we can't disagree on text messages that we have that were sent by this defendant to the victim.
Nosotros podemos estar en desacuerdo con respecto a la naturaleza entre el supuesto, el acusado y la supuesta víctima, pero con lo que no podemos estar en desacuerdo es con la naturaleza de los mensajes de texto que nosotros tenemos que el acusado le envió a la supuesta víctima.
These text messages included threats to kill her.
Los mensajes de texto incluyeron amenazas de muerte a la señora.
He continuously came, was showing up where she worked and where she lives.
Él continuamente se ha estado presentando donde ella trabaja y donde ella vive.
To the point where she ended up moving out of the apartment complex where she lived and moving in with a friend to avoid him.
Hasta el punto que ella se mudó del complejo de apartamento donde ella vivía, se mudó a otro sitio para evitarlo.
Yet the defendant kept coming after her and sending her these messages through the WhatsApp phone service.
Mas, sin embargo, el acusado seguía buscándola y le mandaba mensajes a través de la aplicación WhatsApp.
Continuously threatening and insulting her.
Insultándola y amenazándola continuamente.
She originally got a restraining order.
Ella originalmente obtuvo una orden de restricción.
And this defendant pled to a violation of that restraining order on February 10th of this year.
Y este acusado se declaró ante la violación de la orden de restricción el día 10 de febrero.
However, even after being served with a restraining order, he continued to stalk her and threaten her and show up to the point where she is terrified of him.
Sin embargo, él, luego de haber recibido la medida cautelar, él continuó acechándola, continuó amenazándola hasta el punto de que ella está aterrorizada.
And the incident that counsel mentioned with the car crash,
y el incidente que mencionó el abogado del choque de carros,
this defendant charged the victim's friend's car on purpose after saying, "See, I'll show you what's going to happen," or something to that effect.
este acusado embistió a propósito el vehículo del amigo de la víctima, luego de haberles dicho algo así como que ya te voy a demostrar lo que vas a ver, lo que va a pasar, o algo parecido.
And then he left the scene.
Y luego se fue de la escena.
The victim is terrified of this defendant, Your Honor, and we ask that you not change any of the conditions of his release.
La víctima simplemente está aterrorizada de este acusado y le pedimos por favor que no cambie las condiciones.
Thank you.
Your Honor, regarding the text messages, a lot of them are being taken out of context. He did say some things he didn't mean, and then ultimately corrected himself, saying that he didn't mean it and that he was upset with her. Regarding Judge, the alleged victim, a GPS and supervision by the sheriff's office would ensure that he stays away from her, and if he comes anywhere near her, well, the GPS would show it, and he would be violated immediately. All I ask, Your Honor, is that you please not let indigency, lack of ability to pay, be the reason that he continues to stay in jail. He's been in there for many months, and now we have this pandemic going on. A GPS and then supervision by the sheriff's office is enough to meet the goals that Your Honor wishes to accomplish.
Su señoría, con respecto a los mensajes de texto, fueron tomados fuera de contexto, él se corrigió, él dijo que no había tenido intención de enviar esos mensajes, que estaba alterado. Nosotros consideramos que una liberación con GPS y supervisión del Departamento de Sheriff de Broward aseguraría la seguridad de la víctima, dado que si él se acerca, se daría cuenta el Departamento de Sheriff de Broward. Lo único que le pedimos en este momento, su señoría, es que no permita que su estado de indigencia lo obligue a permanecer dentro de la cárcel, especialmente con esta pandemia. Por lo tanto, reiteramos que un GPS y supervisión del Departamento del Sheriff de Broward sería suficiente para cumplir con sus metas.
Judge, if I could just have one final word.
Sure.
Under circumstances like these, this person is not thinking clearly.
En circunstancias como esta, la fiscalía quiere decir que las personas no piensan claramente.
And a GPS monitor may tell us where he is, but it's not going to stop him from hurting this victim.
Y un GPS quizás nos diga dónde está el señor, pero no lo va a detener de hacerle daño a la víctima.
All right.
It's $100,000 on a third-degree felony. I don't know if they want to interpret that.
This is Mr. Wheeler speaking, indicating that it's a third-degree felony with a $100,000 bond.
The state's not moved for pretrial detention.
Este es el señor Wheeler indicando que esto es un delito de tercer grado con una fianza de $100,000.
Ms. Schneider, can you tell me about his prior criminal history, if any? Well, I'm aware of the one.
Yeah, counsel is right. Other than he's got the prior injunction, violation of injunction, and I don't believe he has anything of significance other than that. It's the facts of this case that are very disturbing and that were very disturbing to the magistrate who reviewed them, and the terror of the victim that this defendant is going to make good on his multiple threats.
La fiscalía indica que el señor ciertamente no tiene antecedente criminal aparte de la violación de la medida cautelar, no tiene nada significativo, mas sin embargo los hechos de este caso fueron perturbantes para el juez magistrado que escuchó y que la víctima está aterrorizada en que él va a cumplir sus amenazas.
And if it helps the court, Judge, he already has everything he needs. He has no reason to go back there. He doesn't want any contact with them and wants nothing to do with them anymore.
Well, I'm sorry, go ahead.
La defensa solo quiere agregar que él ya tiene todo lo que necesita y no quiere tener ningún tipo de contacto con la señora ya más.
I'm saying he's got his stuff. There's not going to be another conflict with the ex-boyfriend. He's got to stay away. He knows that.
Judge, this had nothing to do with picking up any stuff.
Listen, I understand that it's a high bond for a third-degree felony, and I agree that in most situations, $100,000 on a third-degree felony is a lot. But I have major concerns with the facts that are alleged, and therefore, respectfully, I think it's a reasonable amount in this situation, and I'm denying the motion.
Entiendo que es una fianza alta, pero es un delito de tercer grado. $100,000 ciertamente es mucho dinero, pero esta corte tiene preocupaciones muy significativas con respecto a los hechos de este caso y por lo tanto respetuosamente niego su solicitud.
Thank you.
Gracias.
All right, and Mr. Martinez, do you have any others we need to address?
That's all, Judge.
All right, and Mr. Felicioni, thank you so much. I really appreciate it.
It is not a problem, Your Honor.
And
That's what I'm here for.
I appreciate it. Stay safe, and we'll see you when we're opened up for real business here.
You too, sir. See you soon.
Take
Have
care.
a good one.
Bye-bye.
Bye-bye.
Okay. All right. All right, next we have on page 16, Timothy Leinhardt. Reset to Friday. All right, and we already reset it to Friday, so I can just delete these then?
Judge, I'm here,
Oh.
Lauren Alcolt,
Oh.
on behalf of Timothy Leinhardt.
Hi, how you doing?
Good, how are you, Judge? Please
Good.
do not roll Mr. Leinhardt to Friday.
I was just told that he already was reset to Friday.
Yeah, I thought yesterday we reset him for, but he's here. Yeah, and I'm ready to
I'm right here,
address it
yeah.
if you want.
Ms. Leinhardt, how you doing?
He's not here,
I'm
he's
doing
at
good, sir.
Conti.
You?
He's here.
He's there.
Perfect.
All right, I have no problem. I was just told that it was reset, so, but if everyone wants to,
No, I spoke with Mr. Leinhardt, we're ready to address the motion now.
Okay. All right.
Well, he's a VFO, so if it's the motion, then he's a VFO.
Wait a minute. So he's VFO?
He's VFO, I did make a plea offer, and if he was willing to accept the plea offer, then I would waive, or I would stipulate to a finding, but obviously if that's not gonna happen, then he is a VFO.
All right. Ms. Alcolt, is he resolving? Can you hear me? Okay, so Ms. Schneider just told me, so he's VFO, but they extended an offer, so they'd be willing to waive any issues, any danger hearing issues on that if he's resolving, but otherwise I have no ability to set a bond on this.
Your Honor, at this time, Mr. Leinhardt does not want to accept Ms. Schneider's
Okay.
offer of 24 months.
Okay, all right, so, so the offer was 24 months FSP?
Correct.
Okay,
Which is a well below guidelines offer.
what's he scoring?
He is scoring a bottom of
54 months.
54, I think it's a little bit more than that, hold on a minute, I gotta read my own.
54.7 months.
54.7 months.
Okay, all right. So, Mr. Leinhardt, just so you understand, I just want to make sure we're clear. I can't address the bond on the violation cases because you're VFO. I can't set a bond even if I wanted to. But the state's made an offer, which I'm not encouraging you to take, to reject. It's whatever you want to do. But the offer is 24 months Florida State Prison credit for any time you have, which is significantly below the 54.7 months that you score at the bottom. I have no preference whether you take these to final hearing and contest everything or if you accept the offer. But I need to make sure you understand this offer is 30 months below what you're scoring. So did you need any time to think about that?
No, I've already spoke to Lauren Alcott yesterday. These
Okay.
are nonviolent drug offenses.
Okay.
I'm drug program treatable. You know,
Okay. All right. So, Ms. Alcohol, I'm not, we're not going to go forward with the bond motions because I can't.
Without the danger hearing?
Right. And the only way we'd get to a danger hearing is if he admitted or if we went to final hearing and he was found guilty of the violation. So I have, under the statute, I have no ability to give him a bond.
Yes, Your Honor.
Okay? So on Mr. Leinhardt, I'm going to delete him from today's docket. Also, there's no reason to have him on for Friday because the motions can't be addressed. Okay? All right.
Yes, Your Honor.
All right, thank you.
Judge.
Thank you.
thank you, Lauren.
All right.
Hi, Timothy.
All right, and next we're on page 17, Ricardo Gonzalez Guerra. Also at Conti, okay.
I thought we deleted him.
Did we delete him?
No,
I don't think so.
David, you told me that he was deleted because he was mental health or something?
Good.
Yeah.
Yeah. Did I? Oh.
Oh, no, you guys had a conflict with him or something. No?
I was told he was deleted because he was already on yesterday's docket.
Okay, so should he be deleted? All right. And so on Ricardo Gonzalez Guerra, I'm going to delete that from the docket. How about on 17, Andre Joseph, on 17, 21, and 22? Maine.
Good evening, Judge.
Good evening, how are you?
I'm doing well, how are you?
Very good. And do we have, okay.
Yes, this is Miss Drea Joseph.
Okay, very good. How you doing?
I'm finding you.
Very good. Okay.
And Judge, I believe we've reached a negotiated resolution on this.
Okay, great.
And this is one violation of probation and 2 new law offenses.
Okay.
The violation of probation is the 2018 case.
Okay.
The 2 2019 cases are the new law offenses.
Okay. All right, and what are the negotiations?
Well, I think we were doing a split. Yeah. So on the probation case, Your Honor, the offer is 18 months Florida State Prison
Okay.
as a habitual offender. He's already previously been declared to be a habitual offender. But
Okay.
I do have I will supplement the record today with his priors, certified priors. I do have them.
Okay.
And on the new case, we were going to do a year and a day followed by a year probation. No. 12 months probation to follow the 18-month sentence.
Okay. So,
I'm sorry, could the state repeat that? My understanding was that the split sentence was 18 months, revoke in 18 months, Florida State Prison for the VOP, and then the 2 new law offenses were a 12-month probation sentence to run consecutive.
Right, that's what I said.
yes. So, okay, so the VOP will be a revoke, 18 months, previously declared a habitual on the original sentence, correct?
Yes.
All right, so that will remain. So it'll be a revoke, 18 months Florida State Prison as a habitual offender, credit for any time served. That will be, and the 2 new law offenses will be 12 months probation consecutive to the violation of probation case. Are there any special conditions on the probation?
No.
Okay.
And Judge, just to clarify,
Yeah.
the 2 new law offenses, the probation, the 12 months, is that concurrent with each other?
Yes, that would be concurrent with each other, but following the prison sentence. Your Honor, the only condition that I would say is because I don't know if there's any restitution, I would reserve restitution.
Okay. On both the.
There's restitution on the 2 new law offenses.
I don't think there is either, but just in case, I'd like to reserve.
I'll order and reserve as to the amount. If something, if it turns out there's restitution, we can deal with it, okay?
That's fine.
All right. And let me just pull this up. All right. Okay. If you could raise your right hand best you can. You swear to tell the truth, the whole truth, nothing but the truth?
I do.
Okay, you can put your hand down. Please state your name and spell your name for the record.
Andre Joseph, Joseph.
All right, and my understanding is you'd like to resolve all three of your cases, one of which is a violation, the other two are new law offenses. Is that correct?
Correct.
All right, and the state's made the following offer on the violation of probation. It's going to be a revoke, 18 months Florida State Prison. You'll get credit for any time you've already served. That will be as a habitual offender. And then the other two cases will be consecutive to that, but they'll be concurrent with each other. It's going to be an adjudication, 12 months probation. I'm going to order restitution, reserve as to the amount. Is that your understanding of the offer?
Yes, sir.
And is that what you wish to accept to resolve all three cases?
I do.
All right, how old are you?
34.
Okay, how far did you go in school?
Completed the 10th grade.
Okay, do you read and write English?
Yes.
Have you had enough opportunity to discuss the violations, the new law offense, as well as the offer with your attorney?
I do.
And has she answered all your questions for you?
Yes, she did.
And are you satisfied with her representation?
Totally.
All right, very good. On the probation case, let me get to it. You were originally placed on supervision for grand theft of a motor vehicle. That's punishable by up to 5 years prison normally, but as a habitual offender, it's punishable by up to 10 years prison. You understand the maximum?
Yes, sir.
Okay. On case number 197496 CF Tenay, you're charged with 2 counts of dealing in stolen property. Those are each punishable by up to 15 years prison. You understand the maximum penalty on those?
Yes.
All right. On 195078 CF Tenay, you're charged with felony petty theft. That's punishable by up to 5 years prison. Do you understand the maximum penalty on that?
Yes.
Okay. And do we have a score sheet on?
Yes, Your Honor, I'm working on that right now.
All right, thank you. What's the bottom of the guidelines?
Bottom of the guidelines is 33 months in Florida State Prison.
Okay. So, Ms. Joseph, the bottom of your guidelines is 33 months Florida State Prison, meaning if your attorney had not been able to negotiate a below guidelines offer, that would be the minimum sentence that I could give you. Do you understand?
I do.
Okay. Since you are going to be placed on supervision after you finish your prison sentence, on those 2 cases, if you were to violate the terms of probation and the state could prove that it was a willful and substantial violation, you would still be looking at up to the maximum penalty. Do you understand?
Yes.
Okay. Are you currently under the influence of alcohol, drugs, or medication?
No.
Any history of mental health problems?
Yes.
All right. Is there anything about your mental health issues that would cause you to not understand what we're doing here in court today?
No.
Okay. And do you believe you're of a clear and sound mind to make this important decision?
I do.
All right. And Ms. Ross, any concerns about competency?
I do not have any concerns, Judge, and she's currently complying with all of her medication.
Okay. And for the record, I don't have any concerns about Ms. Joseph's competency. She's answered all of my questions in a relevant manner. I've had an opportunity to observe her in court. But, I mean, if you're having any difficulty during the plea, you're going to let me know, right?
Yes.
All right. Other than what I told you I was going to sentence you to, has anyone made you any promises or guarantees to get you to admit you violated as well as to change your plea?
They did not.
Okay. Has anyone threatened you or coerced you to get you to do this?
No.
Are you doing this because you believe it's in your best interest to resolve all 3 cases this way?
Absolutely.
Okay, and you understand if you didn't want to resolve your 3 cases this way, on the violation of probation case, we could have a final hearing. The state would have to prove that you willfully and substantially violated the terms of your supervision. But by entering this admission, you're giving up your right to have that hearing. Is that what you would like to do?
I do.
All right. And as to the new 2 new law offenses, if you didn't want to resolve your cases this way, we would have a trial. The state would have to prove your guilt beyond a reasonable doubt to a jury of your peers. But by entering these pleas, you're giving up your right to have those trials. Is that what you'd like to do?
Yes.
All right. If you're not a U.S. citizen, taking these pleas will result in your deportation. You understand?
Yes.
Also, if these offenses or any prior criminal offense are considered sexually violent or sexually motivated in nature, you subject yourself to involuntary civil commitment. Do you understand that?
I do.
Okay. State, as to the new laws, are you aware of any evidence that have tested for DNA would exonerate the defendant?
No, sir, I am not.
Defense?
No, Your Honor.
All right. And, ma'am, you're not aware of any such evidence, are you?
No, Your Honor.
All right. And, State, do you have a factual basis for both?
Yes, Your Honor, I do.
And defense, do you stipulate for the purpose of the plea?
Yes, Judge.
All right, and I was able to review the probable cause affidavits. Based on my reading of the probable cause affidavits as well as stipulation of counsel, I find that there is a factual basis to accept the plea. Ms. Joseph, how are you pleading to the 2 new law offenses?
No contest.
Okay. Now I'm going to tell you, go over the allegations in the violation warrant. Allegation 1 is that you failed to live without violating any law, that you were in possession of a drug or narcotic not prescribed by a physician, to it amphetamine, as shown by analysis of a urine sample obtained from you on April 3rd, 2019, confirmed by Lear Laboratories on April 15th, 2019. Allegation 2 is that you failed to live without violating any law, that you're in possession of a drug or narcotic, to wit, methamphetamine, as shown by analysis of a urine sample obtained from you on April 3rd, 2019, confirmed by Lear Laboratories on April 15th, 2019. Allegation 3 is that you failed to live without violating any law, that you're in possession of a drug or narcotic not prescribed by a physician, to wit, cocaine, as shown by a urine sample obtained from you on April 3rd, 2019, confirmed by Lear Laboratories on April 15th, 2019. Allegation 4, that you failed to live without violating any law by committing the criminal offense of petty theft on April 19th, 2019 in Broward County, Florida. Allegation 5 is that you failed to pay the state of Florida $10 a month towards the cost of supervision, that you were $93.60 in arrears as of September 17th, 2019. The next allegation is that you failed to make restitution payments, that you're $3,476.01 in arrears as of September 17th, 2019. And the final allegation is that you failed to make court cost payments, that you're $867 in arrears as of September 17th, 2019. Are you admitting you violated probation in those ways?
I am.
All right. And Ms. Schneider,
Yes.
she was already sentenced as a habitual on the probation case. Is there anything that you feel you need to lay a record now?
Not on those cases, but for the sentence on the other cases to be a probation, I do, Your Honor.
Okay.
And the state would indicate that we are, and I have the certifieds with me, so I'm going to put them in the court file at this time. I'm just going to use two. Case number 18-1191 CF10A, in which the defendant was convicted of a grand theft auto, and case numbers 18-1189 CF10A, in which the defendant was convicted of 2 counts of aggravated battery, 1 count of fleeing and eluding, and 1 count of resisting without violence.
Okay, what were the dates of conviction?
The date of conviction on the one that I just mentioned, the aggravated fleeing and all that, it was April 13th of 2018, and the date of conviction on the grand theft was July 20th of 2018.
All right. Thank you. And Ms. Ross, are you stipulating that I can legally sentence your client as a habitual on the 2 new law offenses?
Yes, Judge. The only thing is that I don't believe she is habitual offender qualified as to a felony petty theft. I think that would only apply to the dealing in stolen property.
She's correct, Your Honor.
Okay, so it'll only be an HO sentence on the dealing in stolen property. And that also brings up, Ms. Joseph, I got to go back. One thing I told you that on the dealing in stolen property, the max penalty was 15 years prison. I'm going to be sentencing you as a habitual offender in a moment, which doubles it to possibly 30. Do you understand?
Yes, sir.
So what that means is if you were to violate probation on that case and the state could prove it was willful and substantial, you'd be looking at up to 30 years. You understand?
Yes.
All right. Does that change anything, or you still want to resolve your case?
Yes, I do.
You do. Okay. Very good. So I find the defendant is alert and intelligent. The plea and admission are entered freely and voluntarily with a knowing and intelligent waiver of her rights with the assistance of an attorney with whom she's satisfied. Starting with the violation case. She was previously sentenced as a habitual. It'll remain as an HO, and I'm going to revoke supervision, sentence you to 18 months Florida State Prison. Anyone have any idea what time served she has on that?
Do you have that?
I know that she has almost a year on this current violation, and I believe she also had some time from the original arrest. I can supplement all those numbers for the court though.
All right, you're going to get credit for all time served that you've already served. They're saying we need it now. Can while I'm doing this, can someone check that time served?
Okay. I can do that calculation while you continue.
All right, I appreciate it. All right, so just to be clear, that's as a habitual offender, revoke 18 months Florida State Prison, credit for all time served, which we're going to give you that number in just a moment. Now back to page 17 on 197496 CF10A. I am going to sentence you as a habitual offender. I'm going to adjudicate you guilty. I'm going to place you on 12 months probation, which will run consecutive to the 181191 CF10A, and I'm going to order restitution reserved as to the amount. On 195078 CF10A, I'm going to adjudicate you guilty. This will not be as a habitual offender. I'm going to sentence you to 12 months probation. I'm going to order restitution reserved as to the amount. That is going to be concurrent with 197496 CF10A and consecutive to 181191 CF10A. Anything else, State?
No, sir.
Anything else, Defense?
Judge, by my calculation, as far as county time goes,
Yeah.
she has 527 days of county time. That would be 178 days from the original arrest, which was January 30th, 2018 through July 26th, 2018, when she was transported to prison. And then 349 days from this current arrest, which is April 19th, 2019, to today's date, which is April 1st, 2020. That's 527 days. However, she was sentenced to 12.75 months of Florida State Prison on July 20th, 2018. So there will be additional prison time that she had credit for.
Sure. So what I'm going to do is, ma'am, I'm going to give you credit for, this is on the violation of probation case. I'm going to give you credit of 527 that you've served in Broward County, and you're also entitled to all credit for the time you've already served in Department of Corrections. Okay?
Yes.
All right. Anything else, Ms. Ross?
No, Your Honor. Just if we could convert any remaining costs or restitution on the VOP to a civil lien, and to waive all costs of supervision, or to at least not make them a condition of probation for the current cases.
All right, the court costs will not be a condition. I'm going to waive the cost of supervision and any drug testing fees. I'll convert any outstanding fees to on all three cases to a civil lien.
Thank you, Judge.
All right. Okay. Can I get you to state an address and phone number on the record?
I have an address and phone number for her, Judge. She'll be residing with her mother. It's at 1850 Northwest 42nd Terrace, apartment R, as in Ross, 411, Lauderhill, Florida, 33313. Her mother's name is Roxanne Joseph, and the phone number is 754-244-7166.
Thank you. And Ms. Joseph, so it sounds like you're going to be time served and never actually go to prison. If that's the case, if you get released, I need you to report the next day. So if you get released tonight, tomorrow morning, I need you to go to probation. It's on the corner of Oakland Park and 441. It's
Yeah, I'm familiar.
okay, and they're gonna put you got it. So you've got it there, and we're gonna put the information on your paperwork as well. Okay, and
Okay, thank you.
sure, you have 30 days to appeal. If you can't afford an attorney, I'd appoint one for you. Good luck to you. Okay.
Thank you. Thank you, Ms. Ross.
Thank you.
Yeah, we need 2 prints, correct? 2 prints. Thank you.
Judge.
Thank you. All right. Let me get some of this paperwork done. I will check. Who's, which, thank you. Thank you. All right, next we've got on page 17, Ronald Jackson. Conti?
Oh, the serpent, his tablet just died.
Sure.
Is that extension 8699?
8699. You guys don't have any chargers over there? Oh, all right. Well, of course, the time when we all need tablets, of course. Just pull the motion here. All right, Mr. Jackson, good afternoon, how you doing?
Good afternoon, Your Honor.
I'm gonna get Mr. Sarfin on the phone here.
Please state your name after the tone, and Google Voice will try to connect you.
Judge Michael Lynch. Good evening, Mr. Sarfin. This is Judge Michael Lynch. I have you on speakerphone and open court on the record. How are you?
Hey, Judge. How you doing?
Very good. I'm calling in regards to Ronald Jackson. And we've got your motion, and I've got Mr. Jackson on the TV screen here.
Okay, great. And I believe there was an offer relayed of 6 months community control followed by probation. I don't believe Mr. Jackson wants to accept that.
Okay. State, what's the offer on Mr. Jackson?
The offer was an adjudication, 6 months of community control with no early termination, followed by 24 months of probation.
Okay. And I see in the motion, is it correct, he's scoring 12.6 months Florida State Prison?
That's correct, Your Honor.
Yes.
Okay.
Yes.
All right. So, Mr. Jackson, I don't have any preference one way or the other, but I just want to make sure you understand the offer that's been relayed. Right now, the state has made a below guidelines offer. You're scoring 12.6 months Florida State Prison at the bottom, meaning if you open pled to me right now, that's the minimum I can give you. Their offer is an adjudication, 6 months community control, followed by 24 months probation, no early term on that 6 months. So you do 6 months community control, 24 months probation. Do you have any interest in that offer?
Well, Your Honor, I was just wondering if maybe I could maybe get less probation on this. I was offered at the beginning a 364, and I want to know what happened to that.
We can't do,
All right.
trying to empty out the jail.
Right. Yeah, we're not really in a situation right now because of all that's going on. The reason why a lot of these offers are being made is because we're trying to eliminate a lot of the population of the jail. We're trying to get them out. So,
But I'll make the probation 18 months if that helps.
all right. So, new offer: 6 months community control followed by 18 months probation. So they cut you by 6 months. You want it?
Your Honor, the only problem is I'm homeless. I won't be able to do the community thing. That's the problem. I was trying to get in a program, outside program, so I could be able to do this. I really wanted to resolve this case today.
All right. Let me take a quick
But I'm
look.
in a bind.
Let me take a quick look at the PC and because I don't know much about the case, and maybe Ms. Schneider, while I'm looking at that, if she feels like offering a straight probation.
It's a robbery, Your Honor. The defendant had concealed $80 worth of merchandise in his backpack from a 7-Eleven. When the employee tried to stop him and retrieve the stolen items, the defendant fought him back. He exited the store, the employee followed him, again tried to get the items back, and there was a lot of pushing and shoving, and he fled the scene. But he has a significant prior history, including a couple of fleeing and eludings and DUIs. Scores 12 months FSP. and
I'm
it's kinda
prepared
hard.
to argue the bond motion.
Okay.
If there's nothing else on the table.
All right, so Ms. Schneider, you're not
I mean, I
open to a
understand the
probation
CC
offer?
problem, but I don't know that I can just put him on probation. How much county time does he have in?
And that fleeing and eluding is from 1989.
Well, he's got a couple of them.
He's been in, the most recent arrest that he's in for right now is September 14th.
September?
Yeah. And he had his original arrest June 16th, 2019, and then he's been in since September 14th.
Okay, how about this? How about 24 months probation, special condition, county jail time? I don't know what it is.
How about, when did I
6
say?
months county jail? Does he have 6 months?
Yeah, so he'd be
Okay,
time
6
served at
months, yeah.
180.
Okay.
All right.
How's that?
Let me, so Mr. Jackson, new offer. Adjudication, 24 months probation, special condition, the 180 days in Broward County Jail that you've already served. So 24 months probation, basically.
Yes, Your Honor.
Sound good to you?
Yes.
All right. Okay, and is there any, didn't look like any restitution, but
I don't know that they ever got the property back, but it's, well, yeah, because how would they know that?
Yeah.
Yeah, no restitution.
no restitution? All right, so there, the only special condition is that you can't return to that property, no return. Okay?
Okay, Your Honor.
All right, and Mr. Jackson, raise your right hand for me. Swear to tell the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
All right, you can put your hand down. Please state your name, spell your name for the record.
My name is Ronald Jackson. RONALD, initial C, JACKSON.
All right, my understanding is you'd like to resolve your case today, is that correct?
Yes, Your Honor.
All right, and the state has made the most recent offer of an adjudication, 24 months probation, no return to that property, and a special condition, 180 days, Broward County Jail. You're going to get credit for 180 that you've already served. Is that your understanding of the state's offer?
Yes, Your Honor.
And is that what you wish to accept to resolve your case?
Yes, Your Honor.
How old are you, sir?
52,
How far did you go in school?
12th grade.
Okay, you read and write English?
Yes, Your Honor.
Have you had enough opportunity to discuss the case as well as the offer with your attorney?
Yes, Your Honor.
Has he answered all your questions for you?
Yes, Your Honor.
And are you satisfied with his representation?
Yes, Your Honor.
All right, very good. You're charged with one count of robbery without a weapon that's punishable by up to 15 years prison. You understand the maximum penalty you're looking at?
Yes, Your Honor.
All right, based on your score sheet, you're scoring 12.6 months Florida State Prison at the bottom, meaning if your attorney had not been able to negotiate a below guidelines offer, that would be the minimum sentence I could give you. Do you understand?
Yes, Your Honor.
All right. Since I am placing you on probation, if you were to violate the terms of probation and the state could prove that it was a willful and substantial violation, you would still be looking at up to the maximum penalty. Do you understand?
Yes, Your Honor.
Okay. Are you currently under the influence of alcohol, drugs, or medication?
No, Your Honor.
Any history of mental health problems?
No, Your Honor.
All right. Other than what I told you I was going to sentence you to, has anyone made you any promises or guarantees to get you to change your plea in this case?
No, Your Honor.
Has anyone threatened you or coerced you to get you to do this?
No, Your Honor. No.
Are you doing this because you believe it's in your best interest to resolve your case this way?
Yes, Your Honor.
All right, you understand if you didn't want to resolve your case this way, we'd have a trial. The state would have to prove your guilt beyond a reasonable doubt to a jury of your peers. But by entering this plea, you're giving up your right to have that trial. Is that what you'd like to do?
Yes, Your Honor.
All right, if you're not a U.S. citizen, taking this plea will result in your deportation. You understand?
Yes, Your Honor.
Also, if this offense or any prior criminal offense are considered sexually violent or sexually motivated in nature, you subject yourself to involuntary civil commitment. Do you understand that?
Yes, Your Honor.
All right. And State, are you aware of any evidence that if tested for DNA would exonerate the defendant?
I am not.
Defense? Mr. Sarfin?
No, Your Honor.
All right. And sir, you're not aware of any such evidence, are you?
No, Your Honor.
All right. And State, you have a factual basis?
Yes, I do.
Defense, you stipulate for the purpose of the plea?
Yes.
All right. And I had an opportunity to read the probable cause affidavit. Based on my reading of the probable cause affidavit as well as stipulation of counsel, I find that there is a factual basis to accept the plea. Mr. Jackson, how are you pleading to this charge? Guilty,
no,
not guilty, or no contest?
No contest.
Find the defendant is alert and intelligent, please enter freely and voluntarily with knowing and intelligent waiver of his rights with the assistance of an attorney with whom he is satisfied. I'm going to accept the no contest plea. I'm going to adjudicate you guilty. I'm going to place you on probation for 24 months. Special condition, no return to that property. Also, special condition, 180 days in the Broward County Jail. I'm going to give you credit for 180 that you've already served. And yeah, I was just, but yeah, time served, but he's got well over the 180. All right. Anything else, State?
No, sir.
Anything else, Defense?
Judge, can I request his cost of supervision be waived considering he is homeless?
Yes, I'm going to waive his cost of supervision and any drug testing fee.
Thank you, Judge.
All right, Mr. Jackson, can you state where are you? Do you know where you're going to be staying?
Yes, I'm gonna be on, try to get here in 1698 Blunt Road, right down the road. If not there, I'll be at 920 at the Hack. Fort Lauderdale. Either one of those two, the first one I could get in.
Okay. Okay. All right, so Mr. Jackson, they're going to let you out tonight. I need you to report to probation tomorrow morning, all right? You need to go there tomorrow morning, certainly within 24 hours of your release, but I want you there tomorrow morning. We're going to put the information, the address on your paperwork, but it's the probation office, corner of Oakland Park and 441, okay?
Yes, Your Honor.
All right. Sir, you have 30 days to appeal. If you can't afford an attorney, I'd appoint one for you. Good luck to you.
Let me just add the language.
Thank you, Your Honor.
Thank you, Judge.
Thank you. Have a good one, Mr. Sarfin.
I think I've.
Oh, do you have another one?
I'm good. Long time no speak. Yes, I have Mr. Severino. I think he's up next.
Okay. All right. North Broward and Anthony Severino on page 18.
I believe that's a negotiated resolution as well.
Okay. They're getting them right now.
Okay, great.
Thank you.
Judge, I had the video going all day, and then when my case gets up, it crashed.
Of course.
Of course.
All right, Mr. Severino, how you doing?
Good afternoon, Your Honor.
All right.
Good evening.
Good evening. And let me see here.
He has one case.
Okay. And Schneider, what are the negotiations?
Oh, are there negotiations?
Oh, I thought there were
I
negotiations.
mean, I
Yeah,
made a
the
plea
offer
offer
was
a year and a
today,
day. I
and
don't
sounds
know
like
if
he's accepting.
it's been accepted.
All right, it sounds like they are accepting that 1 year, 1 day Florida State Prison. All right, and I'm sure, does anyone have any idea what his time served is going to be? 262?
Yes.
Excellent. All right. All right, Mr. Severino, raise your right hand.
Yes.
Raise your right hand for me.
Your Honor,
Yes, sir.
I have a question.
Okay.
Am I getting all of the days since the day of I was arrested?
Yes, sir. I'm going to give you credit for every day that you've served. Okay?
Okay.
All right. Your right hand is up. You swear to tell the truth, the whole truth, nothing but the truth?
Yes, Your Honor.
Okay, you can put your hand down. Please state your name. Spell your last name for the record.
Anthony Severino, Severino.
All right, and my understanding is you'd like to resolve your case today. Is that correct?
Yes.
All right.
Judge,
And
this is as a habitual offender as well.
this is as an HO? Okay. And what's he scoring at the bottom?
33 months Florida State Prison.
33. All right, so Mr. Severino, the state has made a below guidelines offer of an adjudication 1 year, 1 day Florida State Prison as a habitual offender with credit for 262 days that you've already served.
Yes, Your Honor.
Is that your understanding of the offer?
Yes, Your Honor.
And that's what you wish to accept to resolve your case, correct?
Yes, Your Honor, and I also have a request.
Okay, what's your request?
After today, after sentencing, am I able to go in front of Lerna Wren? She's a misdemeanor court judge
Yes.
at room 6155.
Right.
And she has the Henderson Village program for mental health, guys like me. And I was wondering if you could please refer me to her. I went above and beyond the last time I was there, and I would like to return now that I'm homeless.
Well, so Mr. Severino, on this case, I'm about to send you to prison for a year with credit for the 262. So,
Okay.
I'm not really, Mr. Sarfin, do you know, do you have any information on this issue?
The only thing I could say is once he gets out of custody, he's not on supervision. So if he wants to enter a program, he can do that on his own volition, but it won't be court ordered. But he can very well do that if he wants to.
Sure. To your knowledge, he doesn't have any other pending cases?
No, he was in misdemeanor court in the past.
Okay. So, all right, Mr. Severino, so after this, you won't have any open cases, at least in Broward. So you can definitely get into any, go, when you get out of prison, go get into any program that you qualify for, okay? It just won't be court ordered.
I understand, Your Honor.
Okay?
Yes, sir.
All right. So, as I indicated, the state's offers the adjudication 1 year, 1 day, credit for 262 as a habitual, and that's what you wish to accept to resolve your case, correct?
Yes, and you are holding verification? Are you holding?
No, it's an adjudication. It's a conviction.
Yes, Your Honor.
Okay. You still wish to resolve your case, correct?
Yes, Your Honor.
Okay. All right. How old are you, sir?
44.
How far did you go in school?
High school diploma.
Okay. Do you read and write English?
Yes.
Have you had enough opportunity to discuss the case as well as the offer with your attorney?
Yes.
Has he answered all of your questions for you?
Yes.
And are you satisfied with his representation?
Yes.
All right, very good. You're charged with one count of burglary of an unoccupied dwelling. That's normally punishable by up to 15 years prison, but as a habitual offender, it's punishable by up to 30 years prison. You understand the maximum penalty you're looking at?
Yes.
All right. Based on your score sheet, you're scoring 33.15 months Florida State Prison at the bottom, meaning that if your attorney had not negotiated a below guidelines offer, that would be the minimum sentence I could give you. Do you understand?
Yes.
Okay. Are you currently under the influence of alcohol, drugs, or medication?
No.
Any history of mental health problems?
No.
All right.
Not that I know.
Well, Mr. Severino, I'm familiar with you from my courtroom, so let me ask you this. Is there anything going on with you at all, mental health, anything that would cause you to not understand what we're doing here in court today?
No, not at all.
All right. Do you believe you have a clear and sound mind to make this important decision?
Yes.
All right. Mr. Sarfin, any concerns about competency?
No, I don't have any concerns at this time.
All right, and for the record, either do I. I'm very familiar with Mr. Severino. I've seen him in my courtroom. I've observed him here today. He's answered all of my questions in a relevant manner. But, sir, if you're having any difficulty during the plea, you're going to let me know, right?
Can somebody tell me how many days I got left? That's the only question I request.
Well, that's going to be between you and the Department of Corrections when you get there. What I can tell you is I'm giving you credit for 262. And
Yes.
they'll do the calculations as to whether you can get gain time or not, okay?
Okay.
All right. So my last question to you was, I don't think you have any issues with competency, but if at any point you have a difficult time understanding what's going on, you're going to let me know, right?
Yes.
Okay, very good. Other than what I told you I was going to sentence you to, has anyone made you any promises or guarantees to get you to change your plea in this case?
No.
Has anyone threatened you or coerced you to get you to do this?
No.
Are you doing this because you believe it's in your best interest to resolve your case this way?
Yes.
You understand if you didn't want to resolve your case this way, we'd have a trial. The state would have to prove your guilt beyond a reasonable doubt to a jury of your peers. But by entering this plea, you're giving up your right to have that trial. Is that what you'd like to do?
Yes.
All right. If you're not a U.S. citizen, taking this plea will result in your deportation. You understand?
Yes.
Also, if this offense or any prior criminal offense are considered sexually violent or sexually motivated in nature, you subject yourself to involuntary civil commitment. Do you understand that?
Yes.
All right. Very good. And, State, are you aware of any evidence that have tested for DNA and would exonerate the defendant?
No, I am not.
Defense?
No.
And, sir, you're not aware of any such evidence, are you?
Me? No.
Okay. And, State, you have a factual basis?
I do, Your Honor.
Defense, you stipulate for the purpose of the plea?
Yes, I do.
All right, and I had an opportunity to review the probable cause affidavit. Based on my reading of the probable cause affidavit as well as stipulation of counsel, I find that there is a factual basis to accept the plea. Mr. Severino, how are you pleading to this charge?
No contest.
Okay.
Right?
Yes, sir. That's fine, okay? All right, so I find the defendant is alert and intelligent. Please enter freely and voluntarily with a knowing and intelligent waiver of his rights with the assistance of an attorney with whom he is satisfied. I'll accept the no contest plea. Ms. Schneider, do you want to tell me what you're relying on for your request
No,
for me
Your
to
Honor,
say?
I'm withdrawing my request that he be sentenced as a habitual offender.
Okay, so sir, I'm not going to sentence you as a habitual offender, and that changes what your maximum would have been, 30 years. It's back to the 15, okay?
Yes, sir.
All right, so I accept the no contest plea. I'm going to adjudicate you guilty. I'm going to sentence you to 1 year, 1 day, Florida State Prison, credit for 262 days that you've already served. Anything else, State?
No, sir.
Anything else, defense?
No, Your Honor.
All right, Mr. Severino, you have 30 days to appeal. If you can't afford an attorney, I'd appoint one for you. Good luck to you. We do need one set of prints.
Yes, thank you.
Thank you.
All right, thank you, Judge.
All right, Mr. Sarfin, have a good one.
All right, you too. Take care.
Bye-bye. All right, next we have on page 19, Terrell Hillard, North Broward.
I can share with you. Yes, Your Honor.
All right, we've got, we need Hillard.
Hello, yes. 1 second, Your Honor.
Sure.
Good afternoon, Your Honor.
Good afternoon, how you doing?
Blessed and highly favored.
Very good. All right, and so, Mr. Chung,
Good evening, Your Honor.
how you doing?
I'm doing okay, and yourself?
Pretty good. All right, so we're here on Mr. Hillard on the motion to set bond.
Yes, Your Honor. Other than, I guess, what was in my motion, I would like to add that, Mr. Hilliard, he has 92 days in. My understanding is that he does have a placement at Pompano Beginners. I understand that they are accepting people still. And everything else is in my motion, Judge.
Okay, and, yeah, is he scoring, Mr.
Yeah.
Okay.
Did he? 26 months, 26.7 months FSP. State did make an offer, Your Honor, of 12 months of community control with no early termination, followed by 12 months of drug offender probation.
Just part of the issue was that North Broward didn't have the people there in time for me to convey all the offers.
Understood.
Yeah, so Mr. Hilliard's hearing the offer from the state for the first time. Mr. Hilliard, you're scoring 26 months at the bottom of the guidelines of Florida State Prison. The state's offer is to adjudicate you, put you on house arrest for 12 months with no early termination, and that's followed by 24 months of probation. Would you want a moment to think about that? Or you want,
It's 12 and 12.
12 and 12.
I'm sorry, 12 months house arrest followed by 12 months probation. So if
Are
you'd like,
everything ran concurrent?
yes, sir.
No,
Well, they're not concurrent to
no.
each other.
Right.
No, your
But in
cases
all
would
the
run
cases,
concurrent.
yeah.
So,
Yes.
doesn't he own? Oh, no, I'm sorry.
has
Yeah,
three
he does
cases,
have the other
yeah.
ones. I'm sorry.
Your cases would run
Yes.
concurrent.
So I can't get around consecutive then, right? I mean, hold on, you say concurrent? I mean, 24 months for everything, or?
24
Yes,
months for
24
everything.
months for
Yeah.
Half on house arrest, half on probation. If you like, I can call you and talk to you if you have any concerns about it, sir.
Yeah, because I'm just going to a halfway house right now, sir, and
As long as you have an address, you're good to go.
Mr. Chung, do we have the address for them, or? Because I don't know about heart.
Well, we can get that address. So, Mr. Hillard, the question is, do you know one way or the other right now that you want to accept that offer, reject that offer, or do you need a moment to speak to your attorney and they'll call you?
I'll go ahead and take it, sir. If that's the best they can do, I prefer to get it ran consecutive with the 12 months of everything. But if that's the best they can do, I think that's double jeopardy, but I'll go ahead and take it, sir.
Well, I think that's probably a good idea. So why don't I put Mr. Hilliard on a brief recall? You guys speak to him, and that way you can address any concerns that he may have. Okay? Our official cutoff time is 7:30. I'd like to push through if we can, but I'm not gonna torture everyone, but let's see what we can do. All right, so I'm putting Mr. Hilliard on recall. Next is Melvin Henderson on page 19.
Yes, Your Honor, Patsy Rampersad, on behalf of Mr. Henderson.
Okay.
I believe the state has agreed to release Mr. Henderson on standard pretrial.
Melvin Henderson? Oh, I made an offer.
That does not sound like that's the situation.
I had made an offer of an adjudication, 6 months of community control with no early termination, followed by 18 months of probation.
Yeah, I don't believe that was the message that was relayed back to me, Your Honor.
Okay. So you tell me what you'd like to do.
I'm sorry. Can I have the state repeat the offer one more time?
Yes, it is an adjudication, 6 months of community control with no early termination for those 6 months, followed by 18 months of probation. The probation could be terminated early. That's concurrent on both cases.
Okay, my client has 3 cases pending, Your Honor. All of his cases has bond posting. He also has a misdemeanor case pending as well that also has $100 bond on it. My motion was to release my client on ROR because at this time he can't afford any bond. If there's any way my client can call me so I can relay the offer, that again was not relayed to me earlier today.
I can tell you, I want you to know that he also has a Palm Beach hold, and I can't do anything about that.
Okay. There's also a Palm Beach hold that I can address.
Yeah.
All right. So, well, we're on a very limited time crunch at this point. That's just the nature of this entire situation. So I don't know what you'd like to do. You obviously can take time to speak to him about the offer, and I can reset him. We can go forward with the bond motion, or he can accept if he wants to.
So the offer that the state is making, is this for all of the 3 pending?
I only have 2.
I've got 2 cases on the docket.
I only have 2, yeah. If you can tell me what the case number is on the third one, I'll look it up.
The case numbers?
Yeah.
Okay.
It's 1901, 1901-4289 CF10A.
Yeah.
That bond on there is $750. He has 2001340 CF10A, and the newest one is 2001434 CF10A.
Yeah, that's the one I didn't have.
Why do I? Oh. Oh, it is on here. I'm sorry.
Yes, he's on 3 pages, Your Honor. I believe pages, well, the docket that I have is 20, 21, and 22.
I've got
21, 22, and 23.
I've got him 19, 20, and 21.
Well, I'm not gonna be able to talk to the judge.
So is the state willing to offer that offer on all 3 cases?
Not well.
Ms. Schneider, is that offer for all 3?
I'm sorry, let me look up. I'm trying to figure out. I have 19-14289.
Yeah.
20-1340. And then she's saying.
And then.
It's 20-1434.
001434 CF10A. It's the same as
Got it.
case number.
Yes, it's for all 3.
190812.
Yes.
Which I believe was an arrest warrant.
Yes, it's for all 3.
All right, all 3 cases.
Okay, Your Honor, if we can recall this, I'll call my client
Okay.
to relay the offer.
Okay.
Thank you.
Sure, we'll put Mr. Henderson on a brief recall as well. Mr. Henderson, your lawyer is going to get in touch with you to extend you the below guidelines offer. I believe it. Was he scoring or no?
Yes, he does. Wait.
The state's telling me.
Wait. Let me check.
I don't score out the press.
Okay, hold on.
Hold on.
1 second.
I don't have the most current, so let me see.
Okay.
I'm not sure that he does.
All right. We can look at that.
Yeah.
We'll put Mr. Henderson
He
on
does
recall.
not score.
He does not
He
score.
does not score.
Okay. Okay. All right, that's on recall. Let's move on to paid. Mr. Hilliard. Okay. All right, so we're back to North Broward and Trell Hilliard. That's on pages 19, 20, and 25. All right, do we have Mr. Hilliard? No. Yeah, North Broward, I need Hilliard. All right, back on Mr. Hilliard. Good afternoon again. All right.
Good afternoon.
And what's does he want to resolve?
Yes, sir.
Yes. All right, and it's on all three. It's an adjudication, 12 CC followed by 12 drug offender probation, no ET on the CC.
That's correct, Your Honor.
All the run concurrent. Okay. All right, sir. Best you can, raise your right hand for me. Swear to tell the truth, the whole truth, nothing but the truth.
Yes.
Okay, you can put your hand down. Please state your name. Spell your name for the record.
Terrell Hilliard. TerrellHilliard.
All right, and my understanding is you'd like to resolve all three of your cases today. Is that correct?
Yes, sir.
All right, and the state has made an offer. I'm sorry? Okay.
Oh, that's okay.
The state's made an offer of, if you wish to accept, it's going to be an adjudication, 12 months community control followed by 12 months drug offender probation. And because it's an adjudication, you're also going to lose your license for, it's 6 months now, right? 6 months? 6 months, right? Okay. So because it's an adjudication on a drug case, you're going to lose your license for 6 months. Is that your understanding of the offer?
Yes, sir.
And that's what you wish to accept to resolve all three of your cases?
Yes, sir.
All right. How old are you, sir?
45.
How far did you go in school?
9th grade.
Okay, you read and write English?
Yes.
All right. Have you had enough opportunity to discuss all three cases as well as the offer with your attorney?
Yes.
Has he answered all your questions for you?
Yes.
And are you satisfied with his representation?
Yes.
All right, very good. On case number 19-13620 CF10A, you're charged with possession of Utilone that's punishable by up to 5 years prison. You understand the maximum penalty you're looking at?
Yes.
All right. On 2115 CF10A, you're charged with possession of cocaine that's punishable by up to 5 years prison. Count 2, trespass, punishable by up to 364 days in the Broward County Jail. You understand the maximum penalty on that?
Yes.
All right. On case number 19-14403 CF10A, you're charging count 1 with possession of cocaine. That's punishable by 5 years prison. Count 2, possession of cannabis is punishable by 364. And count 3, trespass, structure, or conveyance, punishable by up to 60 days in the Broward County Jail. You understand the maximum penalty you're looking at?
Yes, sir.
All right. Based on your score sheet, you're scoring, it's 26?
26.7.
You're scoring 26.7 months Florida State Prison at the bottom, meaning if your attorney was not able to negotiate a below guidelines offer, that would be the minimum sentence I could give you. Do you understand?
Yes, sir.
All right. And since I am placing you on supervision, if you were to violate the terms of supervision and the state could prove that it was a willful and substantial violation, you would still be looking at up to the maximum penalty. Do you understand?
Yes, sir.
Okay. Are you currently under the influence of alcohol, drugs, or medication?
No, sir.
Any history of mental health problems?
Yes, sir.
All right. Anything about your mental health issues that would cause you to not understand what we're doing here in court today?
Not that I know of, sir. No, sir.
Okay. So far, you're understanding everything we're doing, correct?
Yes, sir.
All right. And do you believe you have a clear and sound mind to make this important decision?
Yes, sir.
All right. Mr. Chung, any concerns about competency?
No, Your Honor.
All right. And for the record, I don't have any concerns about competency for Mr. Hilliard. But Mr. Hilliard, if you're having any difficulty during the plea, you're going to let me know, right?
Yes, sir.
All right, very good. Other than what I told you I was going to sentence you to, has anyone made you any promises or guarantees to get you to change your plea in these cases?
No, sir.
Has anyone threatened you or coerced you to get you to do this?
No, sir.
Are you doing this because you believe it's in your best interest to resolve all 3 cases this way?
Yes, sir.
You understand if you didn't want to resolve your 3 cases this way, we could have a trial, and any one of them or all 3, the state would have to prove your guilt beyond a reasonable doubt to a jury of your peers, but by entering these pleas, you're giving up your right to have those trials. Is that what you'd like to do?
Yes, sir.
All right. If you're not a U.S. citizen, taking these pleas will result in your deportation. You understand?
Yes, sir.
Also, if these offenses or any prior criminal offense are considered sexually violent or sexually motivated in nature, you subject yourself to involuntary civil commitment. Do you understand that?
Yes, sir.
All right. State, are you aware of any evidence that if tested for DNA would exonerate the defendant?
No, sir.
Defense? All right. And, sir, you're not aware of any such evidence, are you?
No, sir.
All right. And state, you have a factual basis?
I do.
Defense, you stipulate for the purpose of the plea? Yes, sir. All right. And I've had an opportunity to review the probable cause affidavits. Based on my reading of the probable cause affidavits as well as stipulation of counsel, I find that there is a factual basis to accept the plea on all 3 cases. Mr. Hilliard, how are you pleading to these charges?
No contest.
Find the defendant is alert and intelligent. Please enter freely and voluntarily with a knowing and intelligent waiver of his rights with the assistance of an attorney with whom he is satisfied. I'm going to accept the no contest plea. On case number 19-13620 CF10A, I'm going to adjudicate you guilty. I'm going to sentence you to 12 months community control. That was no ET on the CC? All right, no early term on that CC. That's followed by 12 months drug offender probation. This will result in a 12-month license, 6-month license suspension, I'm sorry. On case number 20-115 CF10A, I accept the no contest plea. On count 1, I'm going to adjudicate you guilty, place you on 12 months community control, no early term of the CC. That's followed by 12 months drug offender probation. That will result in a 6-month license suspension. Count 2, I'm going to adjudicate and waive. And on 19-14403 CF10A, on count 1, I'm going to adjudicate you guilty, place you on community control for 12 months, no early term on the community control. That's followed by 12 months drug offender probation. That will result in a 6-month license suspension. Counts 2 and 3, I'm going to adjudicate and waive. All counts, all cases to run concurrent. I'm going to go ahead and waive the cost of supervision and any drug testing fees. Anything else, State?
Sir.
Anything else, Defense? All right, sir, you have 30 days to appeal. If you can't afford an attorney, I'd appoint one for you. Good luck to you, okay?
Yes, sir.
All right, and we need, don't leave yet, sir. I'm sorry. It's been a long day. I need you to report to probation tomorrow morning. I'm going to order that you report within 24 hours, but you need to report to probation tomorrow morning. We're going to put the information on your disposition, which you'll get, but it's the probation office on the corner of 441 and Oakland Park. And I also need you to state your address and phone number on the record.
Sir, I don't have that. That's why I asked for the for public beginners. I didn't have to bring the paper with me. I gave it to my defense.
Oh, we got it. Sorry.
Okay.
So we're good there.
They have, for the record, Your Honor, they have several different locations.
Okay.
I don't know which location I'll be staying in. I'll try to have all that by tomorrow morning when I get a bus pass to come go to probation.
Perfect. Sounds good.
And all the court costs and everything, can I get community service for, or?
Sure, I'll give you permission to do community service for the court costs. Okay?
Okay.
All right.
You, sir.
Thank you. All right, page 20, Mark Perez.
Good evening, Your Honor. He's on main jail. This is Alexander Hirschman.
Good evening. I have no idea where. Let me see.
Oh, I'm sorry, Your Honor. He's at Conti.
Conti? Okay. All right. Is that Mr. Perez?
Yes, sir.
All right. Good evening. All right. We're here on the motion for ROR.
Yes, Your Honor.
Okay. What would you like me to consider? Okay.
charging in 2018.
State, what's your position on Mr.
Your
Perez?
Honor, I'm sorry, but we object to the release of this defendant. This defendant is required to register as a sex offender as a result of a conviction that he has for sexual battery on a minor victim. He has, aside from that, a significant record: possession of cannabis, delivery of drugs, possession and use of drugs, more possessions, delivery of cannabis, and he has, more importantly, 2 prior cases for failure to register as a sex offender. So twice before, he has actually had cases filed that have been disposed for failing to register, and still he disappears on us and he fails to register. He scores a bottom of 62 months Florida State Prison. He is a habitual offender, and we do not feel that an individual who shows this kind of disregard for the safety of the public should be released.
Your Honor, if I may.
Sure.
To let you know, since 2007, Mr. Perez has only had,
Yeah, exactly. He had one in 2012, one in 2018.
All right. Where would Mr. Perez be staying if I let him out?
Your Honor, I'm not sure if you're interested in
Okay. Let me speak. Mr. Perez, where would you be staying? Who do you be staying with?
At this moment, I don't know.
No.
Last time I came to jail, what happened, or like they said, because I didn't make it to register, I actually lost my house. No, it wasn't that. It was because they said I moved, but
Right, he's saying that the last
I lost
time.
my house.
Okay. So you don't know you're homeless
I
at this
got a
point?
friend, but I don't know his address. I lived there before, but I don't know his address in Fort Lauderdale.
All right.
Especially with all this going on, I mean, out there, I don't.
That was what was about to come out of my mouth, that I thought that might be a good idea. Mr. Perez, this is what I'm going to do. I need your lawyers to look into a few things as to where you might potentially be staying. I can't. I'm probably not going to be the one sitting up here. But whatever judge this is in front of, you can indicate that I'm deleting it from the docket so that you can look into where he would be residing, and that I would have considered a form of release that might not have had that $3,000 bond. But I'm just deleting it for today rather than denying it.
Mr. Perez, do you have your friend's name and phone number?
I can get it. I actually got a guy in my cell that used to work with the guy too, and he's got his phone number.
Okay.
But yeah, his name's Steve Lehman.
Okay, it's
But I
very
can
important.
get that.
It's very important you contact Ms. Hershon, sir. Okay? Get the information and contact your attorney.
Let you know that my extension is 8620, please.
Call 8620 when you have the information.
I don't know about I don't have a lawyer that I know of. Who am I telling?
You do. You do.
I do.
You do.
I do, and I don't know about it. Okay.
Well, call that number. And,
8620.
8620, and you can speak to your lawyer. All right?
Okay.
All right, so I'm going to delete that from the docket.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Okay, I have one question for everyone here.
Yes, sir.
We're supposed to cut this at 7:30. It's 7:30.
Nobody really does.
Are we, is there anyone here, and it's fine if you do, I'll deal with it, but is there anyone here who needs to go or has an objection to plugging on?
I'm fine with plugging.
All right, hearing no objection. You can reserve your right to object and let me know in a little bit if it changes, but hopefully we can finish this out. All right, so we're back on Melvin Henderson. Is that correct?
Yes.
Okay. Oh, wait, one second. Where's Mr. Henderson again? What jail?
Hey,
North Broward?
Henderson's in
Conti?
Melvin Henderson.
Yes, sir.
He left. He went back to his dorm.
Okay. Well, okay. Well, I guess, I'm gonna roll, Mr. Anderson to, tomorrow's
Frankly,
docket.
Judge, he's got an out-of-county hold, so.
Okay.
I don't know.
All right, so Mr. Anderson will be reset for tomorrow. Okay. How about, everyone go with Friday? Well, as good as we can be? All right, reset Friday. All right, we're on, 21 Pierre Martineau.
I'm not here tomorrow.
Good evening, how you doing? Very good. Where is Mr. Martineau? North Broward?
North Broward, Your Honor. Martineau Pierre?
Yes. All right.
Hey, good evening. How you doing?
Good. How are you?
Just hanging in.
I hear.
He is, he's been a resident here for 29 years. This was allegedly he went into a car, it was looking for change. It's an unsophisticated third-degree felony. This case is unfiled. He does list an address in Miami. What we were asking for is for him to be ROR and the alternative release, pretrial release. He also has a misdemeanor VOP. That's case number 19273 and today. There is a $1,000 bond set on that. We ask that you also
All right. State.
Your Honor, Mr. Martineau currently has a $2,500 bond on the felony case and a $1,000 bond on the misdemeanor case. The state is not opposed to releasing him on standard pre-trial. Reducing the bond, well, can he make any bond? He can't make any bond. Standard PTR.
Standard
PTR.
Okay. ROR, standard PTR on both? And you want him to continue reporting to probation on the probation
I do,
case?
Your Honor.
All right. Ms. Farr-Barrick, any issues with that?
Now, the 20 case has been filed, Your Honor.
Okay.
So I'd like to, could we arraign him? No? Okay, then, could we give him an arraignment date so that we know that he served?
Yeah, that was kind of my thought. I normally wouldn't mind,
Yes.
yeah. All right, well then, I'm not gonna do either of those, but he's gonna be reporting to probation, he'll be on pretrial. So, on Mr. Martineau, on the 23143 CF10A, I'm gonna grant the motion and ROR him to standard pretrial release. On his violation of probation case, 19273 MMM10A, I'm granting the motion to ROR, but I'm gonna order, Mr. Martineau, I need you to continue to report to probation on that misdemeanor probation case, okay?
Okay.
All right, that's 19273 MM10A. And, sir, I need you to, well, he's not gonna be a new intake on that, so is he going to probation? Is he calling probation? Do we know?
Mr. Martineau,
I've been going in.
No, hold on,
going
Mr. Martineau, hold on one second.
Mr. Martineau, do you have the phone number for your probation officer still?
I do. It's in my phone. Like, I got the phone number. It's in my phone, my cellular
Okay.
phone.
When you
It's
get
in my
out,
property.
you'll be able to call him or
Yes.
her? Okay.
Yes, it's a him. Officer Victor.
Okay, so just
That's
call
his name.
Officer Victor as soon as you're released, okay?
Okay. Even better, I got the cell phone number also.
I was told 19273 MM10A. That's not it? Let me
see if I can find it, hold on.
see. Yeah. Oh. There we are. Yes. No, on that one, it's just an ROR, but he must continue to report to probation. Thank you. All right.
Thank you very much. Have a great evening, everybody.
Thank you. You too. All right, next
We're
we.
done. I'm just telling him he's done.
I was like, we're done. You got me. I was very excited for a moment. All right, so we're on page 22, Martavis Cross. Conti.
How you doing, Judge?
Pretty good. How are you?
I'm good. I'm blessed.
Excellent. And this is Miss Early. I'm surprised Miss Early didn't tell me when I had her on earlier. You could have taken care of it. Let me get Miss Early on the phone.
My kids need me out there, sir.
One second. 1 second.
Thank you for calling Early Law Firm. How may we assist you?
Good evening. I need to speak to Keisha Early. This is Judge Michael Lynch. We're having bond hearings.
Okay, I can definitely help with that. You said your name is Judge Michael Lynch?
Yes, it's in regards to Martavis Cross.
Perfect, thank you very much. And just to verify, can you repeat the person you were needing one more time?
Keisha Early, Earley.
Cassia Early?
Yes.
Okay, just 1 second here. And from the court, correct?
Yeah, I'm Judge Lynch. I have you on speakerphone and open court on the record.
Alrighty, I see that, Judge. Just 1 second. Is
Sure.
it Lynch, correct?
Lynch.
Perfect, thank you. I'm going to go ahead and get you connected here to Cassia.
Great, thank you.
My pleasure. You're connected.
Thank you. Ms. Early?
Hi. Yes.
Hi, this is Judge Michael Lynch again. I have you on speakerphone and open court on the record. And I'm sorry, I didn't realize you had a second case. We could have taken care of it earlier, but that's all right. We're here on Martavis Cross.
No, that's fine.
All right,
Yes.
so we're here on Mr. Cross. Mr. Cross is present on the TV screen. And this is your motion for ROR. Hello? Ms. Early?
Yes, I'm here.
Okay. What would you like me to consider in regards to the motion for release?
Well, and the assistant state attorney, let me get her name. She had no objection. I don't know who.
Oh, wait, is there no objection?
No, Martavis Cross?
Yeah.
Yeah, there's an objection.
There appears to be an objection.
Hello?
Yes. Ms. Early?
Who's this?
Ms. Schneider, Maria Schneider is here today and indicated that they have an objection to the release of Martavis Cross.
Okay, are the ASAs not communicating with each other? Because I have written communication from ASA. Ms. Schneider, did you speak with, let me get her name, one moment.
Sure.
Christina?
Yeah, with who?
Ms. Early, who?
This is Christine Murphy's case.
Christine Murphy.
Christina Strandell?
I did not speak to Christina Strandell. I spoke to Christine Murphy, who's the assigned attorney on the case. Not agreeing to release to someone who's violated probation multiple times by picking up new cases, so.
I can't hear you.
I said I am not agreeing to release someone who's violated probation multiple times by picking up new cases.
That was a one time,
What,
and
sir?
I was.
One second, sir. Okay. All right, so, Ms. Early, there is an objection, so, and this is on a violation of probation, is that correct?
He's got 3 cases, Your Honor, 2 VOPs and 1 new law violation.
There's only one case on this
Your Honor,
docket.
So his new case, the new law violation, he's ROR'd on that. He's being held on a no bond hold for the 2 previous violations of probation. That is correct. This case is a little different, Your Honor. Mr. Cross is in the process of being evaluated by Dr. Brandon. He has since had 1 evaluation by Dr. Brandon. However, he was unable to complete the follow-up evaluation because jails are currently closed. I was speaking with ASA Christine Murphy regarding resolving this case. I know that he currently scores prison, and I'm going based on my memory, but I believe this is the case where he scored about 29 months Florida State prison.
42 months.
We were in the process of resolving. I'm sorry?
He scores 42 months Florida State Prison.
42 at the bottom.
Oh, okay. So we were in the process of finalizing his evaluation with Dr. Brandon so that I can prepare a mitigation report for consideration for possible below the guideline sentence. Maria, did you have an offer to relay? I did receive some email communication at this time.
Yes, I do. 18 months in Florida State Prison on all his cases.
Can I say one thing?
All right, Ms.
Hold on, no.
Your attorney is saying she does not want you to say a word, but definitely do not talk about anything with the facts of the case or anything about the violations or anything like that. But your attorney is telling you that she doesn't think you should speak at all right now.
No, Martavis, I know that the jails are closed. I did mail you some communication yesterday, and I'm going to send you another letter tomorrow. Let me put that offer in writing, and we'll discuss, okay? I don't want you to discuss anything about the case at this moment, okay?
Yeah. I wasn't going to discuss the case. I was going to discuss what I completed. From not knowing and being young.
No, let's and Mr. Cross, I'm not trying to be difficult, but I'm getting different things from everyone. So let me ask Ms. Early, what would you like me to do today? Do you want to address the bond? Now, there's only 1 case on the docket, but obviously he's got other cases. But this is the only case that's holding him right now? He's ROR'd? Okay.
I don't know, he's got 2 VOPs, so he should be held on 17-13180 and
Oh, you're right.
18-111.
No, there are 2.
No. He's only being held. He's only being held on the 2 VOPs. I don't know.
Yeah.
I sent an email to the ASA, not the ASA, the JA for the other 2. He's ROR on the new law.
Okay,
it's just the VOPs that's holding him.
Right, but there's 2 VOPs, only 1 on the docket, but that's fine. So what I need to know from you right now, it sounds like you're not quite there with resolving, but it might resolve. Do you want to address the bond, or do you want me to delete this and have you reset it when you have a potential negotiation? What would you like me to do?
Well, we can address the bond. We're here. I know that the state has voiced the objection to releasing or reinstating the bond, or in the alternative, releasing Mr. Cross on an ankle monitor. I know that, again, he would like to resolve the case. So I don't want to hide the cards, Maria. But I do believe that if we get this evaluation completed, that we'll be closer to resolving this case. But that kind of ties into resolving both the VOPs as well as the new law violation. I'll send you an email, Maria, regarding that offer, but I'll just respectfully request if you can just give me some time so that I can communicate with Mr. Cross regarding that offer.
That's fine. I can leave the offer open for some time. I just do want you to, so that you are aware of everything. He scores at the bottom of the guidelines 42 months in Florida State Prison. So the offer that I'm making is well below guidelines.
Yeah, that's understood. I just, I have a few cases in my head. I don't have the file in front of me, but I know that Mr. Cross scored prison, and from the very beginning, we were trying to resolve the case, which is why I had him evaluated. And again, Your Honor, the main reason I would like to get Mr. Cross evaluated, we will not evaluated, but released on an ankle monitor, is because Dr. Brandon would like to schedule his evaluation, and then I can finalize my mitigation report by next week. And if he does resolve the case, he can turn himself back in and finish the remainder of the time. But just for him to sit there and not have this evaluation so that we can complete this case, that was the reason why.
Okay. All right. And so what you're asking me to set a bond with a GPS monitor on the 2 violation cases?
That is correct, Your Honor.
All right. What type of bond are we talking about?
Well, Mr. Cross has been declared indigent by the clerk, and although I am a private attorney, Your Honor, I am representing Mr. Cross at a significant discount so that I can thoroughly prepare this case. And if he is going to resolve this case, he would like to get some affairs in order, specifically a proxy for his mother and some other financial POAs so that everything can be taken care of. He does have a child at home as well. So, again, we would like to resolve this case, but it's to the point where even after the jails reopen, Dr. Brandon has expressed to me that he's hesitant on going back immediately. So it's just going to delay the case.
All right. And Ms. Schneider, you're objecting, correct?
Yeah, Judge, we're objecting, and I'd just like to tell you a little
Yeah.
bit. I object, first of all, he's got, he scores on the high side. He does have a prior history of carrying concealed firearm, possessions, burglaries, and so on. But in this case, he pled to probation on the 17 case, the 17-13180. Within 3 months of being placed on probation, he picked up the 18 case, 18-11468. And then shortly after resolving that case, he picked up, approximately 10 months afterwards, he picked up the new law violation that brings him, that he has now, which is a delivery of cocaine, delivery of oxycodone, and delivery of MDMA. We believe that this defendant has shown by his recent activity that he continues to commit offenses despite being on supervision. Therefore, Your Honor, we don't think that he's a good candidate for release, and we're objecting to it.
And Your Honor,
yes.
and Maria is correct in reciting the allegations in the probable cause affidavit, but this is why, and I've had extensive conversations with Christine regarding this case. These are patterns, but I strongly feel after speaking with his family, looking at his medical records, and seeing this pattern that it's associated with some type of mental instability. And this is what this evaluation will cover. This is not just an evaluation for mental, it's a comprehensive evaluation that can kind of answer those questions as to why these patterns are being repeated. And if you look at the probable cause affidavits for the case, for the 2017 case and then a 2018 case that he picked up, oftentimes there were other people involved, and Mr. Cross just quickly kind of took the blame. So without giving more of what this comprehensive evaluation will reveal, it will shed light on the story of his mental capacity as well as his thought process and how he's constantly going in and out of this whole life of crime. But with the proper treatment, it will benefit him in the long run. I do agree that he is not a great candidate for probation, which is why I would strongly consider the state's offer. But this comprehensive evaluation is about 6 hours long, and it goes over a course of a few days. So this is why Dr. Brandon, he already started 4 days before the jail closed for visitors, and he wants to have this evaluation concluded within the same time frame instead of